Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Connecticut versus Raul Valle. We are into day 11. The judge left us with, there's 4 counts altogether. She stopped at count 3 at around 4:30 on Friday. So we have to go through count 4, which will be for Faison Teal. So we heard count 1 for Jimmy McGrath. We heard counts 2 and 3 for Ryan and Tommy, respectively. And then count 4 is going to be for Faison. Now, Ryan and Tommy were first-degree assault. Jimmy is first-degree M, and Faison is second-degree assault. The reason that he's second-degree versus first-degree is that his injuries were not life-threatening. And I was going to fix that, and I forgot. I was going to fix party 1. Shoot, I was going to do that this morning. I had every intention to do that, and I totally forgot. So, hosted by St. Joseph students, you can just get rid of including Valley. He did not host it. So I was going to fix that this morning, and I got caught up in other things. So anyway, how was your weekend, everybody? We had a long weekend here. Brat says, 8 ball, will we get a verdict today? Bot says, maybe not. Aussie, by the way, I love the music you had on with the kittens yesterday. So peaceful. Thank you, Aussie. Yeah, Aaron comes up with the music. Aaron is the one that, if you like the music, you can direct your praise to Aaron. 13th juror. Oops, wait a minute. Pull this one up. Good morning, everyone. Will there be a verdict today? I don't know. They still have to go through about a half hour to 45 minutes. Actually, we have a feed. Let me come over here. They have to go through still about a half hour of at least a half hour, maybe 40 minutes of count 4. And I'm only judging that from the other 3 counts that she did. That's what I think, Mark W. I'm only basing that off of the other 3 counts. It seemed like each one took about 35, 40 minutes, roughly. Hey, Angelique, good to see you. Jacqueline saying fun. Jag, good morning to you. Jojo, you left a comment on the short video. Oh, the Black Kitty, yeah. Okay, cool, Jojo. I'll go check that out. Let's see. All right, let me just turn my mic up a little bit. Hopefully that's a little bit better. How's that doing? No sound. Anquinette saying now there's no sound. Let me double check my sound. All right, I just turned it up. I just turned it up a little bit. Hopefully you guys can hear it. All right. Scott says, did not even think about this trial over the weekend, but ready to get back into deliberation. Still leaning for less than red rum myself. It is a struggle. I agree. Aussie saying, good morning, good day, or good evening, everyone. I missed you all. Thank you. Brenda saying, sound is perfect. Cool. Brat saying, sound is fine. Jojo saying, hear you good. G Stewie. Okay, cool. Sound is good. All right. Glenn saying, good morning, all. I hope you had a safe and wonderful 4th of July. We did. Shanna saying, good morning. Lolo and Tammy saying the sound is good. Awesome. Green-eyed cat. Good morning, everyone. Welcome back. Little black kitty is super cute. She is a cute little kitty. Skits West Side Crime Music. Hello to you. Gail saying self-defense. We'll take a couple polls. We'll definitely do some polls, like how long do you think it'll take for them to deliberate? What now that we've heard all the evidence. Hey, Ruby. Good morning to you. Anquinette says, I can hear you now. It was on my end. Yeah, Brat. We have 3 black ones and 1 ginger. And then we have a 4th, another little black one's probably about a month older than Polly's kittens. Excuse me. Green-eyed cat. I don't expect a verdict until Thursday or Friday at the earliest. Okay. Aussie, I love black cats. I think they have the most personality. All right, be sure to hit the like button as you guys are coming in. I have to do the same. Let me just activate something over here. 1 minute. Yes, Jojo, you discovered the new emojis. Yes, Aaron worked on some new emojis over the weekend. We have IMO, we have facts, we have mod love. I'm not even sure what that other one is. Oh, and no hate zone. So we have mod love, no hate zone, facts, IMO, and then thank you. Cynthia, you have a black cat who is 21 years old. Wow, good for you. Good for your cat. That's awesome. All right, so we have to hear of Faison's charges, or the charges that are coming based out of the attack on Faison. So we heard closing arguments on Friday. I'm sorry, Thursday, because we were off Friday. So we heard closing arguments, and then we heard the charges. We heard count 1, which was to Jimmy. And there was a lesser included. I was interested in the lesser included. So the lesser included was just manslaughter. There was no, so it was intentional. So the lesser included intent. So the first one is intent to red rum, and then manslaughter in first degree is intentional, right? And then we have the statute is a person is guilty when with intent to cause serious physical injury causes the passing of someone. So they must prove specifically intended to cause that serious physical injury, didn't intend to delete, but intended to inflict serious physical injury. And then 2, acting to cause serious physical injury caused the passing. That's proximate cause. That's where proximate cause comes in. So let's see. So manslaughter, guilty if he recklessly engaged in conduct that caused the passing. So he's got first degree M, and then he's got manslaughter, right? So they have to prove 4 elements. Conduct that created great risk, recklessness, extreme indifference to human life, conduct that created James's passing. So there is a lesser included. Hey, Gourmet Thursday, how are you? And Joni, good to see you. Always good to have you in our chat, Joni. Hope you're doing well today. Green-eyed cat, giving some mod love. Hey, Deidre, good to see you. Cynthia, my black cat is in excellent health, except her hearing isn't good. That's fantastic. Good for you. Lots of mod love. Thank you so much for all you mods do. Thank you, JoJo. We have a great set of mods. We have a new mod. When our new mod comes in, I'll let you guys know. Daisy Jane, hey, good morning, everyone. 4th of July was fun. Very good. Yeah, it was pretty quiet here, thankfully, because we have, the kittens. Kim says, good morning, folks. I hope everyone had a great holiday weekend. Thoughts and prayers for Texas. Yeah, boy, they're getting slammed, right? Sherry M, good morning, everyone. Late start for you this Monday morning. Hello, Princess Mish. Hello from Arizona. TBRK 007, thank you for your incredible coverage. I'm so happy I found your channel. I look forward to other trials with you. Thanks so much. Oh, thank you so much. That's really that's sweet. Appreciate you. Suber, sorry if I missed. Is there plans for the stream for after jury instructions? Yeah, you know what we're going to do? I thought I'm going to replay. I'm just going to replay the trial. I thought about that. Okay, what can we do while we're waiting for them? Waiting for them to deliberate. Take it easy there. What are we going to do while we wait for them to deliberate? And I thought we could just rewatch the trial because the first time around I'm so intent on taking notes. But this time around I want to just listen, and then I want to stop it. I'm not going to stop it. I'm going to stop it after they're finished. I'm not going to stop it and stop talk. I want to watch it, and then I want to talk about it. Let's see. Jojo says, now you need to make one for Aaron Love. Yeah, right on. Widespread panic. Yay. Welcome in, Widespread. We have some new emojis that people are using. One of them is Mod Love. Real happy. Good to see you. Jenny, hello from South Africa. So happy I found your channel. I'm happy that you found us too. Fantastic. Rosemary, good morning from Mesa, Arizona. Good morning to you. Yeah, so Super, I thought we could play. I want to replay the trial, and I'm just going to go from day one and just play it. And whenever we have a verdict, we have a verdict. But what happens with me is I'm so intent on focusing on the notes and for my recaps. This time I just want to sit back and just listen, and see if I can pick out anything new. And I'm not going to really take notes. I'm just going to listen to it as a juror and not take notes and just kind of enjoy it from that aspect. That's where I'm coming from. Luigi's, I'm not sure, Betty. Not sure about Luigi's trial. Betty Ann Fry, thank you for joining us. I do not know. We were kind of covering it, but then we kind of dropped off because it's New York. And it's federal, I think. They don't show trials up in New York City. or New York. I was just really bummed. Do we know if they have started deliberating? Real happy they have not. We still have to get through the fourth count. Yes, Daisy, we hit 10,000. We're at 10,080 right now. We hit 10,000 Thursday around 2 or 3, I think. I think it was something like that. Subaru replay crew. Awesome. Glenn says, then your first poll should be how many witnesses do we get to see before the verdict comes in? That's a good one. Hey, Lucy. Hello to you. Real happy. There you go. There's some mod love. Cynthia, good morning. I am new and so glad I found you last week. I am thoroughly engaged. You are so professional. I love that you are a crime watcher like myself. Oh, well, thank you, Cynthia. Appreciate that. Winnaboo, welcome to Rabbit Ears. Thank you for joining us. G. Stewie says, I might have missed a poll last week. Do we all think he will be found guilty? No, G. Stewie, actually, we're kind of on the fence. Hey, Isabel. Oops, looks like we got a feed.
You may be seated. All right, we are back here today to continue on with the trial of the state of Connecticut versus Raul Eliah Valle. I would ask counsel to please place their appearance on the record for purposes of today's proceedings.
Good morning, Your Honor. Mark Derso for the state of Connecticut.
Good morning, Your Honor. Tatiana Messina for the state of Connecticut.
Good morning.
Good morning, Your Honor. Kevin Smith for Mr. Valle, who's at my side.
Good morning. Is everyone all set to call the jury and to continue with the charge?
Yes, Your Honor.
Yes, Your Honor.
We'll do that then. Thank you. Welcome back, ladies and gentlemen of the jury. Thank you. Counsel, please stipulate to the return of our juror.
The state will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right, so before I continue with the jury charge, I just want to thank all of you for your continued attention to the proceedings as well as your continued attention to arrive here timely each and every day. So I know it's been quite some time. You've been very diligent about getting here and being attentive to the proceedings. So I appreciate that very much. So I wanted to thank you for that. At this time, when we adjourned on Thursday, we were going through the court's instructions as to the law that you are to apply to this case. I am going to pick up where the court left off, and that is at count 4, assault in the second degree intentional, Connecticut General Statute, Section 53A, 68-2. The state charges the defendant at count 4 with assault in the second degree, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May, 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause physical injury to one Faison Teal, did cause physical injury to the said Faison Teal with a dangerous instrument, to wit, a knife, in violation of Section 53A 68-2 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. We'll refer to the court's previous instruction on specific intent at 15. Physical injury is defined as an impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious, it may be minor. Element 2, caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. We refer to the court's previous instruction on proximate cause at 14. You must find it proved, beyond a reasonable doubt, that Faison Teal was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or some other person. Element 3, with a dangerous instrument. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of a discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article is capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation and even though harmless under normal use may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person, 2, the defendant did cause physical injury to Faison Teal, and 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of the crime of assault in the second degree intentional at count 4, and you shall then next consider the lesser included offense of assault in the second degree reckless. You'll proceed to the court's instruction on lesser included offenses to assault in the second degree intentional below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statute, Section 53A 68-2 at count 4. This will end your deliberations at count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 4, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 4. Lesser included offenses to assault in the second degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses to assault in the second degree. If and only if you have unanimously found the state has not proved beyond a reasonable doubt all of the elements of the crime of assault in the second degree intentional, and therefore that the defendant is not guilty of assault in the second degree intentional at count 4. The defendant at count 4, the substitute information, is specifically charged with the crime of assault in the second degree intentional. The offense of assault in the second degree intentional under under our penal code is such that it may include the elements of the crime of assault in the second degree reckless. Similar to my previous instructions on lesser included offenses, this brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses to assault in the second degree intentional in the order and under the circumstances as provided herein. The fact that I am instructing you on a lesser included offense to assault in the second degree intentional as to count 4 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the second degree intentional or is guilty of the lesser included offense. If and only if you unanimously found that the state did not prove beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, and that the defendant therefore is not guilty of assault in the second degree intentional at count 4, shall you consider the lesser included offense of assault in the second degree reckless directly below at subsection A. A, assault in the second degree reckless, section 53A 68-3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. The first element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. Refer to the court's previous instruction, recklessness, at 16. Element 2, cause serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction of proximate cause at 14. You must find it proved beyond a reasonable doubt that Faison Teal was seriously physically injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or a serious loss of impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing serious physical injury to another. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it is used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury to Faison Teal, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statutes, Section 53A, 68.3 at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 4, even though you have found the elements of the crime proven beyond a reasonable doubt. This will end your deliberations on count 4. 22. Self-defense, defense of others. The defendant has offered evidence in this case that he acted in self-defense and or the defense of others. Self-defense and defense of others are two separate but related defenses. Although the court is instructing you on both defenses under this section, the defendant is entitled to and must be given by you a separate and independent determination as to each defense under each count. After you have considered all the evidence in this case, if you find that the state has proved beyond a reasonable doubt each and every element of a crime to which self-defense, defense of others may apply, you must go on to consider whether or not the defendant acted in self-defense. In this case, self-defense and the defense of others applies to all crimes charged in the substitute information under each of the 4 counts, along with the lesser included offenses to each of those crimes at each count. In other words, self-defense and the defense of others applies to all offenses submitted to you for deliberations. The statute defining self-defense, defense of others reads in pertinent part as follows. A person is justified in using reasonable physical force upon another person to defend himself, a third person, from what he reasonably believes to be the use or imminent use of physical force. And he may use such degree of force which he reasonably believes to be necessary for such purpose, except that deadly physical force may not be used unless the actor reasonably believes that such other person is using or about to use deadly physical force or inflicting or about to inflict great bodily harm. The determination of whether a defendant reasonably believes physical force to be necessary to defend himself, someone else, from what he reasonably believes to be the use or imminent use of physical force by another individual is one. Whether the defendant actually believed that the other person was using or about to use physical force or deadly physical force against him, a third person, and two, whether a reasonable person in the defendant's position, knowing what the defendant knew and being in the same circumstances, would have had those same beliefs. Whether the defendant's belief was reasonable is a question of fact for you to determine based on all the evidence presented. The acts of the other individual, James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teal at count 4, leading to the defendant's use of defensive physical force, need not be an actual threat or assault. The test is not what the other person actually intended, but what the other person's acts reasonably caused the defendant to believe was the other person's intention. The state's burden. When evidence of self-defense, the defense of others, is introduced at trial, the state, in order to obtain a conviction, must prove beyond a reasonable doubt both the elements of the crimes charged and that the defendant did not act in self-defense or defense of others. If the state fails to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, unless the state proves beyond a reasonable doubt a statutory disqualification, as discussed further below in this section 22 at statutory disqualifications to self-defense, defense of others, and statutory disqualification to the use of deadly physical force, you must find the defendant not guilty, despite the fact that you have found the elements of the charged crime proved beyond a reasonable doubt. The defendant has no burden of proof whatsoever with respect to this defense. Deadly and non-deadly physical force. The law distinguishes non-deadly physical force from deadly physical force. Deadly physical force is justified only when a person reasonably believes that such force is necessary for the defense of oneself or others against the use of imminent use of deadly physical force or infliction or imminent infliction of great bodily harm. Deadly physical force is physical force which can reasonably be expected to cause death or serious physical injury. Physical injury is an impairment of physical condition or pain. Serious physical injury is a physical injury that creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Imminent means that the person is about to use physical force or deadly physical force at that time and not at some unspecified future time. The physical force used by the defendant need not actually have caused a death or a serious physical injury in order to be considered deadly physical force, nor need it have been expected or intended by the defendant to result in such serious consequences. Instead, what determines whether the defendant used deadly physical force is whether the force actually used by the defendant could reasonably have been expected to cause death or serious physical injury. It is up to you to determine, after considering all the evidence, whether the defendant used deadly physical force or non-deadly physical force against James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teal at count 4. If the state claims that the defendant used deadly physical force, the state must prove that beyond a reasonable doubt. In addition, the state may prove that the defendant's use of force was not justified if it can prove beyond a reasonable doubt that while the defendant may have believed that he needed to use such force, his belief was unreasonable in light of all the circumstances known to him at the moment. Whether the defendant's belief in the need to use such force was reasonable is a question of fact for you to determine. However, a person must use no more force than he reasonably believes is necessary for such purpose. Statutory disqualifications to self-defense and defense of others. In addition, the state can defeat the defendant's claim of self-defense or defense of others by proving beyond a reasonable doubt one of the statutory disqualifications to self-defense, defense of others. The statute defining self-defense, defense of others describes certain circumstances in which a person is not justified in using any degree of physical force in self-defense, defense of others against another. These circumstances include provocation and initial aggressor, as more fully instructed below at subsections A and B below. A. Provocation in accordance with Connecticut General Statute Section 53A-19C1. Provocation is one such circumstance under which a person is not justified in using any degree of physical force in self-defense, defense of others against another, when he provokes the other person to use physical force against him. In order to provoke the use of physical force by another, it is not enough that the defendant, by his conduct, elicited the use of physical force by another. Rather, the defendant must have embarked upon such conduct with the specific intent to provoke the other into using physical force and intending to cause the other physical injury or death. The defendant must have specifically intended to provoke another into using physical force and then used force to defend himself from the ensuing use of force by the person provoked. It is important to remember that the defendant has no burden whatsoever to prove that he did not provoke James McGrath, Ryan Hines, Thomas Connery Jr., or Faison Teal with respect to their respective count into using physical force against him. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that the defendant provoked the use of physical force by James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal with respect to their respective count against him. B. Initial aggressor in accordance with Connecticut General Statute Section 53A-19CB. Another circumstance under which a person is not justified in using any degree of physical force in self-defense, defense of others against another, is when he is the initial aggressor in the encounter with the other person and does not both withdraw from the encounter and effectively communicate his intent to do so before using the physical force at issue in the case. Under this provision, the state can prove that the defendant was not justified in using physical force in self-defense, defense of others, by proving beyond a reasonable doubt that he was the initial aggressor in his encounter with James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal relative to each of their respective counts, and that he neither withdrew from that encounter nor effectively communicated his intent to do so before using physical force against them. To prove that the defendant was the initial aggressor in his encounter with James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal relative to each of their respective counts, the state need not prove that the defendant was the first person to use physical force in that encounter. The initial aggressor can be the first person who threatened to use physical force, or even the first person who appeared to threaten the imminent use of physical force under the circumstances. To prove that the defendant did not withdraw and communicate his intent to do so, the state must prove that he did not abandon the conflict in such a way that the fact of his withdrawal was perceived by James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal relative to each of their respective counts, so that they were aware that there was no longer any danger from the original aggression. It is important to remember that the defendant has no burden whatsoever to prove that he was not the initial aggressor or that he withdrew from the encounter and communicated his intent to do so before he used physical force against James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal relative to each of their respective counts. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that he was the initial aggressor, did not withdraw from the encounter, and did not communicate his intent to withdraw before using physical force. statutory disqualification to the use of deadly physical force. In addition, the state can defeat the defendant's claim of self-defense by proving a statutory disqualification to the use of deadly physical force. The statute defining self-defense, defense of others, describes certain circumstances in which a person is not justified in using deadly physical force in self-defense, defense of others against another. The exception applies only to the use of deadly force. So if you have found that the defendant used deadly physical force, you must consider this the exception of duty to retreat at A below. A, duty to retreat, Section 53A, 19B1. A person is not justified in using deadly physical force upon another person if he knows that he can avoid the necessity of using such force with complete safety by retreating. This disqualification requires a defendant to retreat instead of using deadly physical force whenever two conditions are met. 1, a completely safe retreat is in fact available to him, and 2, he knows that he can avoid the necessity of using deadly physical force by making that completely safe retreat. The law stresses that self-defense, defense of others, cannot be retaliatory. It must be defensive and not punitive. The term complete safety, as used in the statute, means without any injury to the defendant whatsoever. A person acts knowingly with respect to a circumstance described in a statute when he is aware that such circumstance exists. It is important to remember that the defendant has no burden whatsoever to prove that he could not have retreated with complete safety or that he didn't know that a safe retreat was possible before he used physical force. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that he did know that he could retreat with complete safety. In summary, if you unanimously find that the state has failed to prove beyond a reasonable doubt any of the elements of a crime to which self-defense, defense of others may apply, you shall find the defendant not guilty and not consider self-defense, defense of others. If you unanimously find all the elements of a crime to which self-defense, defense of others applies have been proven beyond a reasonable doubt, you shall then consider the defense of self-defense, defense of others. If you unanimously find that the state has proven beyond a reasonable doubt that the defendant did not act in self-defense, defense of others, or has proved one of the statutory disqualifications beyond a reasonable doubt, you must reject the defenses and find the defendant guilty. If, on the other hand, you unanimously find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defense alone, you must find the defendant not guilty, despite the fact that you may have found the elements of the crime proved beyond a reasonable doubt. Sympathy. In deciding whether the defendant is guilty or not guilty, you should not concern yourselves with the punishment or potential consequence in the event of a conviction. This is a matter exclusively within the court's function under the limitations and restrictions imposed by statute. You are to find the defendant guilty or not guilty, uninfluenced by the possible punishment or consequence that may follow a conviction. You should not allow any display of emotion by counsel during the trial to draw upon your sympathy. There is no place for sympathy in your deliberations. You should not be influenced by any sympathy for the defendant, the defendant's family, the decedent, the decedent's family, the complainants, or for any other person who might in any way be affected by your decision. Implicit bias. As I indicated earlier, your verdict must be based on the evidence introduced in court and my instructions on the law. Our system of justice depends on judges like me and jurors like you making careful, unbiased, and fair decisions. During our interactions with other people, it is not unusual for us to group or categorize people. Sometimes these categorizations involve negative or positive biases or prejudices, which may be conscious or unconscious. Such preferences or biases, whether they are conscious or unconscious, have no place in a courtroom or your deliberations, where our goal is to treat all parties equally and to arrive at a just, fair, and unbiased verdict. All people deserve fair treatment in our system of justice, regardless of their race, national origin, religion, age, disability, gender, gender identity, sexual orientation, education, income level, or any other personal characteristic. Techniques that you can use as jurors to check whether any unconscious biases are influencing you include slowing down and examining your thought processes thoroughly to identify where you may be relying on reflexive gut reactions, and to consider whether you are making assumptions that have no basis in the evidence. Ask yourself whether you would view the evidence differently if the parties, witnesses, or attorneys had different personal characteristics. In sum, your task is to render a verdict based on facts drawn only from the evidence introduced in the courtroom and from the law as stated in my instructions to you, and not based on prejudice or bias or against any party or person involved in the trial. Duties upon retiring. In conclusion, I press upon you that you are duty-bound as jurors to determine the facts based on the evidence as it has been presented, to apply the law as I have outlined it, and then to render a verdict of guilty or not guilty as to each count. When you reach a verdict, it must be unanimous. That is, all 12 of you must agree on the verdict. As a check that your verdict is in fact unanimous, the clerk may ask each of you to individually announce your verdict in court. It is the duty of each juror to discuss and consider the opinions of the other jurors. Each of you takes into the jury room your individual experience and wisdom. Your task is to pull that experience and wisdom. You do that by giving your views and listening to the views of others. There must necessarily be discussion and give and take within the scope of your oath. That is the way in which a unanimous verdict is reached. Despite that, in the last analysis, it is your individual duty to make up your own mind and to decide this case based on the basis of your individual judgment and conscience. Note-taking. If you took notes during the evidence, you may use them during deliberations, and you may discuss your notes with your fellow jurors. Remember that notes are merely aids to your memory and should not be given precedence over your independent recollection of the evidence. If there is a conflict between your recollection and your notes or the notes of any other juror, it is your recollection of the evidence that must prevail. Your notes or the notes of any other juror are not evidence. You will recall my earlier definition of what constitutes evidence. Your verdict must be based exclusively on evidence presented at trial and the principles of law given to you in these final instructions. A juror who has not taken notes should rely on his or her recollection of the evidence and should not be influenced by the fact that other jurors have taken notes. Notes are only a tool and not always accurate. Do not assume that a voluminous note-taker has taken notes that are necessarily more accurate than your memory. You may discuss your notes with your fellow jurors during the deliberation phase. The decision to do so is yours and yours alone. After the trial is concluded, all notes will be collected by court staff and destroyed. In closing, I remind you that you have the right to request portions of the testimony to be read back to you if you deem it essential during your deliberations. You will have all the admitted exhibits with you during deliberations. You may only deliberate while all 12 of you are present in the jury room. Inform the judicial marshal or court officer when you have reached a verdict, but do not tell him or her the verdict. You will be asked to return to the courtroom where your foreperson will announce the verdict orally in response to questions from the courtroom clerk. The rest of the panel will be asked whether they concur with the verdict. If you have any questions, please send them out as a note signed by the foreperson marked with the time, and please be as specific as possible. You will have the exhibits with you during your deliberations. We will also send in with you a computer on which you will be able to view or hear digital evidence with instructions on how to use the computer, which will be marked as a court exhibit. You will also have with you in the jury room a copy of these instructions entitled Jury Charge, which will be marked as a court exhibit. I remind you, however, that you should follow all the court's instructions and not single out some and ignore others. They are all equally important. Do not begin deliberations until you have selected one of your members to be the foreperson of the jury and you have received the jury charge, the substitute information, the device, instructions on how to access the device, and all fully admitted exhibits. So at this point in time, I am going to ask the jurors to please step out and go into the jury room for a brief moment. I do have to make some comments on the record. Do not begin your deliberations just yet, as the alternate jurors will be in that room with regular jurors. So please remain silent just for a few moments as a jury panel, and I will be bringing you right back into the courtroom. Thank you. Comments, any questions, counsel, any questions, comments, or exceptions to the court's charge?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
All right, and it's a good thing we told him just a brief moment. We'll bring the jury back in, please. Thank you.
Plan out one more, Your Honor.
Thank you. Ladies and gentlemen of the jury, at this time I am going to ask all regular jurors to please stand. If you're a regular juror, please stand. Alternate jurors, please remain seated. Regular jurors, I'm going to direct you to the deliberations room. You're going to go into the room. You will be deliberating shortly. I will ask you to hold off until such time as you have all the exhibits. You've selected a foreperson, you have the substitute information, and you have my jury charge as well as the device and the instructions, okay? So I would ask all regular jurors to please go into the jury room. Once you have all of those documents and the device, and you've selected a foreperson, you can begin your deliberations on this case. The alternate jurors, please just be patient with the court for just a moment. Thank you. Madam Clerk is going to state your name and ask you to stand just so we confirm. Throughout the trial. I know it may be somewhat frustrating to hear the evidence and not participate in the actual deliberations, but you do perform a very important function by being here, and we appreciate that. Now, while it is unusual, alternate jurors are sometimes called upon to take the place of a juror during deliberations. For that reason, I am going to ask you to go back to the jury assembly room and report back to that room and remain there every day until such time as there is a verdict. The same instructions are going to apply to you as I've repeated them throughout the trial. Do not read, listen to, or watch anything about this case. Do not speak to anyone or let anyone speak to you, not even the other alternates or one of the primary jurors. Do not make any private investigations or do any research. When there is a verdict, we will bring you into the courtroom so that you can hear what the verdict is. So I apologize for this, but it has happened. So I am going to ask you to please abide by your oath. I do continue to appreciate the service that you are giving us. It is an extremely important one. The marshal is going to escort you to the jury deliberations room, and I will ask you to continue to report here daily back to the jury deliberations room. The clerk will update you throughout the day, and once there is a verdict, you'll be brought back in to hear the verdict. Thank you so much. Thank you. Okay. Counsel, at this time, I am going to ask you please to meet with Madam Clerk and make sure that all full exhibits are going to the jury and that only full exhibits are going to the jury. Please make sure that the latest substitute information is going to the jury. Also, please check the instructions for the device. Please make sure that you are okay with those instructions. I did ask you to look at the exhibit list to make sure that you're okay with the description of each exhibit. If you are, then we'll mark that and we'll have that go in as well. And then I will just state for the record that there were two things in my charge that I caught while reading the charge. I intend to make that change. I believe they were both under self-defense. Yes, they were. Under initial aggressor, B was before using physical force against, and it was them. I had to add them. And then there was also at the end in describing statutory disqualifications just added, and I did do it on the record beyond a reasonable doubt. All right, so I will make those two changes, and I will submit that to the clerk as an exhibit, our final exhibit to go into the deliberation. Was there something else?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, so then we're going to take a brief recess, and I'll come back on the bench just to confirm that you've gone through the exhibits, and I'll hear any issues, and then I'll have Madam Clerk deliver all of the exhibits and the device for deliberations. Court's going to take a 10-minute recess. Thank you.
All right, court's in recess.
All right, so they haven't started deliberating just yet because she has to still she's going to make these changes to the form, and then she's going to confirm with both state and the defense about the evidence. So I'm going to take down, I did not. Okay. So they haven't actually started deliberating yet. So I have that they started at 10:40, but I think in fact they have not. All right, so let's go through. So it was again, Psychosaurus Rex is one of our new mods. She joins our moderators for this channel. So chat, please welcome Psychosaurus Rex in. Very happy to have them on board. All right, so let's see. The judge, thanks everybody for paying attention or not paying attention, for sticking with the rules. And then she goes into count 4, which is the face-on teal, intentional assault against face-on with a dangerous instrument. They have to prove 3 things: that it caused physical injury, was a result of Raul's actions, and he used a dangerous instrument. Summary: he had the intent. See, that's going to be the interesting one, his intent. 2, he did cause the physical injury. I think that's pretty obvious. And 3, he used a dangerous instrument. I think that's pretty obvious too. So to me, it's going to boil down to his intent. What was his intent? He says he was just flailing away. Well, was that his intent? Was to cause serious bodily injury while he was flailing away? He was just trying to get them off. But then there's also a lesser included, assault second-degree reckless. So I think if you're on the jury and you feel really strong that he intended to do this, you're going to find him guilty across the board on that. If you think that he was acting in self-defense or he wasn't quite sure what he was doing, I think then they're going to come back to the second degrees, the recklessness. So then she talks about defense and defense of others. Since Raul offered this, she had to talk about it. It's separate, but they are related. She says it applies to all 4 counts, and including the lessers. It applies to all of his offenses, justified to use reasonable force for what he reasonably believes is necessary force. Deadly force can't be used unless the other person is about to inflict deadly force on you. So that's pretty important. So do you think that those other kids were going to inflict deadly force on him? He was getting stomped, kicked, punched. And I agree, Brad. I think at one point you said the state on Thursday was saying, stomping and punching, is not a deadly weapon. And I would counter that. I think we've seen many cases where people have been deleted from a kick to the head, punched, to the head, that kind of stuff. So let's see. She says she talks about the initial aggressor. So if you feel that Raul was the initial aggressor, then self-defense doesn't work. So they may start there. They may say, was he the initial aggressor? Did he come on the lawn? Yes. Did he throw the first punch? No. So by being on that lawn, is he the aggressor? Just because he shows up on somebody's lawn, does that make him the initial aggressor? He did not throw the first punch. That is true. He did not throw the first punch. She also says you can use your notes, but don't give them preference over your recollection. Then she is going to make some changes, and then she's going to come back. And I guess that's when they're officially going to start deliberating. So. Janice says, I think some of the specification in charge for 4 could possibly help him. Let's see. Yeah, Proctor. I hate this. The stomper said it was a half stomp. That was face on. Face on was the one. He said it was. I think he said medium. To be quite honest, I think that's what I got to look that up. I think he said medium. Mediums. Yeah. So he said Tyler threw a punch. He doesn't recall who was kicking. He says medium-sized kicks, not too hard. Those were his words. That was Faison's. He said he gave medium-sized kicks, not too hard. So it says Tyler threw a punch. He doesn't recall who was kicking, but he said he did medium-sized kicks, not too hard. And then under cross, he was like, were you saying these are just medium kicks? And then, of course, he doesn't recall. So Faison didn't recall a lot of stuff, as with some of them. Some of them were like, I don't recall. Let's see. Psychosaurus Rex. Weren't they getting text invitations to the address? Yes, they were. That was Griffin. Griffin was the one that told him to pull up. Griffin was the one. He was the one at the first fight. He's the one that said pull up. He said, and in the group chat, he told them to pull up. He told them the road name. So he was the one. Griffin is the one that invited them. So Griffin invited them. Brad, yeah, the medium stomp was just one example of the list of people who I think lied to minimize their culpability. I agree. Yeah. Neil, the photos do show a light beating. I know, a light beating. Right, a light beating. Kate says they went there in the car for a fight, not tea and cookies. They had no business being there in the first place. I agree. Although it wasn't Raul, it was Jack, and it was Tyler. Tyler was the one that said, I want to go back. I know these people. They know my cousin. I want to go back and talk to them. Raul also said, okay, yep, I know some of them. I want to go make peace. So he did say that. but then it's also Jack that drove back, Oh, Pueblo says, clearly didn't kick him as hard as he could have in artful English. Right? Is that Jesus or I'll go with Jesus, Davila or Davila? Not necessarily. I thought they started deliberating at quarter till or 10:40, but then the judge said no, she has to make some changes to the jury form, and then they're coming back. So I don't think they've started just yet. Vice, kicks hurt. Yeah, and are subjective regarding pain. 100%. Sinbad, pull-up has a whole new meaning these days. Are we talking about pull-ups? Are we talking about pull-ups? Stearns will be toast. Yeah, he got kicked down the road. He was supposed to start the 15th. Jury selection was supposed to start the 15th, but now it got pushed to the 22nd. It just got pushed to the 22nd. So, Sherry M., I just wish the cops were called before all this happened. I know, of course. If he was in fear of his life, then he would not have gone back. Any one of those kids could have called the cops. The whole thing is sad. I agree. Note to self, don't invite Griffin to a party. All right, merciful. That is true. So Patsy saying Griffin instigated it. Again, there's a lot of finger pointing. Proctor says Griffin stayed well out of the rumble, just filmed it. Yeah, there's a lot of woulda, shoulda, couldas. There's a lot of, if-thens, if only this person had done that, if all of this stuff. There's a lot of woulda, shoulda, couldas in this, unfortunately, sadly. Patsy, Jack should have been charged with providing the weapon. Yep, there's a lot. Robin, Raul kept going back. Where's the panic and fear? It appears based on the testimony, it was just anger. Gourmet Thursday says, I don't believe Tyler came back to make peace. I believe Tyler Rich's testimony. Tyler and Raul came back to fight and felt justified. So you don't think De Silva went back to make peace? Daisy says, let's not forget this fight started at the first party. That is true. Hey, Dan, thank you for gifting One Trial TV Live membership. Appreciate it. And Mark W. You got it. Fantastic. Let's see. Sinbad says Jack should have been charged too. He played the game well. LW350, Jack and Tyler both received immunity. That tells me the prosecution wanted Raul the most. Yeah, he's the one that actually did the stabbing. So, Psychosaurus Rex, I think multiple people should be getting charged with various things. Jerry says the entire situation is tragic. I agree. Oh, I want to read, once they finally do start deliberating, Widespread Panic found a really cool thing that she found on Kevin Smith's website. And Ken Rosenberg hooked her up. Well, actually, let's see. I can start reading it. So Raul Valle charges and potential penalties for the deletion of Jimmy McGrath. He could be found guilty on any of the following charges, but not more than one. So the deletion, causing the deletion of another person with the intent to cause that. That's a Class A felony. That's 25 to 60-year prison sentence. First degree manslaughter, causing the deletion with the intent to cause serious physical injury or under circumstances evincing extreme indifference to human life. Is that a word? That's a word I'm not familiar with. I have to look that up. I'm sorry. Widespread. Let me look this up. What is that word? Oh, evincing. All right. Reveal the presence of. How about that? I learned something new. All right. Thank you, Widespread. So first degree manslaughter, causing the deletion with the intent to cause serious physical injury or under circumstances evincing extreme indifference to human life. That's a Class B felony, 20-year prison sentence, up to $15,000 fine. Then there's second degree, which is reckless manslaughter. We heard about that. And I think the first degree manslaughter is intentional. That's what I heard judge say. And then second degree is reckless. So recklessly causing the deletion of another person, 1 to 10 years, up to a $10,000 fine. And then criminally neglect homicide, failing to recognize that a person's actions will cause another person's passing. Class A misdemeanor, 1 year, up to $2,000 fine. We didn't hear anything about that. I didn't hear anything about that, to be quite honest. I didn't hear anything about the criminally negligent. Did you guys hear that? Widespread, did you hear that? I didn't hear that in her instructions. All right, then the first degree assault on Ryan and Tommy. Intentionally caused serious injury by using a deadly weapon or dangerous instrument. We did hear that. Intentionally, seriously, permanently disfiguring another person, amputating or disabling part of their body. Recklessly causing serious injury in a way that causes a risk of deletion and shows extreme indifference to human life. So that's a Class B felony up to 20 years. So he could be found guilty 25 and then 20 and 20, right? So that's 25, 35, 45, plus another 20 is 65. This is on the low end, right? Oh, wait, up to 20 years, up to 20 years. So, yeah, he's, well, on the high end, he's looking at 60, 20, and 20. That's 80, that's 100.
All right, counsel. I just want to go over the exhibits and everything that's going in to the jury. So I have asked Madam Clerk to make the exhibit list, the substitute information, the computer instructions, and the jury charge that I just handed the clerk, a court full exhibit. So those items will be going to the jury to have with them during their deliberations. Do either of you have any questions on that, or would you like to review those exhibits before they go in?
The state does not have any issue with that, Your Honor.
Defense has no issues, Your Honor.
Okay. So then, aside from those exhibits and obviously the device, have you reviewed all of the full exhibits going in to the jury for deliberations? My question is, are all full exhibits going in? Are any full exhibits not there that you are aware of?
No, we've reviewed all the exhibits, Your Honor, and we believe we've accounted for every exhibit that was submitted as a full exhibit.
Defense agrees, Your Honor.
Okay. And I just want to make sure, are there any exhibits for ID only that are going in that you noticed?
No, Your Honor.
No, Your Honor.
Okay. All right. Is there anything else that you would like to bring to the court's attention relative to the deliberations?
No, Your
Nothing
Honor.
from the state, Your Honor.
Okay. So at this point in time, Madam Clerk, just for the record, if you could please let me know in terms of full exhibits, core exhibits, what are the references and what are the identification numbers?
So court exhibit number 3, is the jury charge.
Okay, so jury charge, court exhibit 3, full. Okay.
And then number 4 is the jury laptop instructions, which is full as well.
Laptop instructions is 4, full, thank you.
And then the substitute information is full, number 5.
Number 5, full, substitute info.
And the exhibit list is number 6, full.
Right, with that then, I would ask Madam Clerk to please deliver to the jury the full exhibits, as well as the full exhibits that counsel have had the opportunity to go through. And the jury can start deliberating. It is about 2 minutes to 11. If I receive any notes, I will of course inform counsel. If you are planning to leave or remove yourselves from this immediate area, just please let the clerk know how to best reach you. And we'll be able to do that if we receive a note. Okay? Thank you so much. Court stands in recess.
All right, court to recess.
Okay, I'm going to start the clock now. It's 10:58. I'm just going to say 11 o'clock just so it's easier for us to. All right, so 11 o'clock. 11 o'clock. The jury starts deliberating at 11 o'clock. That's just easiest, right? Just easiest. All right, so jury starts deliberations 11. All right, let's just go with it. Because that's just easier instead of like 10:58. Let's just say, all right, let's just make it easy. All right, jury starts deliberating. Jury starts deliberations, 11 o'clock. All right, I'm going to take a quick break. Let me play some music. I'll be back in a second, and then we'll chat a little bit. I just need to take a quick little break here. Let's see, where's some music? Let me play some music. All right, I'll be back in a minute. All right. All right. So if you haven't taken our poll yet, please do so. I'm going to end it because I want to do another poll. How long do you think the jury will deliberate today? How long do you think the jury will deliberate today? That's just today. So I've learned my lesson with Carlos Dominguez because they deliberated like 9 days. So instead of just saying how long will they deliberate, I'm just going to say today, just today. All right, Sue. Appreciate your comment, but let's not. There's no reason to badmouth any victims or anything. That's not what we're about. All right. Aussie, let's see. Aussie says the music nature sounds was beautiful. Is it something that's available? Yes. Hold on a second. Did Aaron make that available? All right. We will make that available for you guys. We'll make that available for you, Aussie. You may have to become a member. We have all the soundtracks from our. If you guys become members, I'm doing a little cooking side project. I've put up a couple. Aaron has to unload it. So if you become a member, we've done all the soundtracks to the trials. Aaron creates all the soundtracks that she created. Are there. I've done a couple cooking episodes. I've done 2 cooking episodes. If you want to see any more cats, if you want to see any more cats, you can go check that out as well. So anyway, yeah. So it's we'll do that a little bit later, Aussie. All right. Take the poll. Yes, Aussie, go check out. Well, if you like the, we'll upload that later tonight. But there are all the soundtracks that Aaron has created are up there. Catherine says, I wonder if this will make many of these kids behave much better in college. I hope so. I hope so. Sinbad says, Aaron gets all the music for the show. I love Kitty Cam. It's available if you have Shazam. You can check what music it is, then find it online. Well, we're going to provide that for you guys. So you could do it that way, or you could just wait till tonight and it'll be available for you. Hey, thank you for the 5 Trial TV Live gifted memberships. Connie Marie got one. Sherry got one. Nick got one. Quilting in True Crime got one. Awesome. And Sarsaichik got one. Sarsaichik. All right, I'm going to end the poll for how long will they deliberate, because I want to start a new poll. So let's just end that poll for now. All right, 667 votes. Good job on that, you guys. Appreciate that. 660. So this is just for today. How long do you think they'll deliberate for today? So this is 667 votes. So how long will the jury deliberate today? 29% of you thought 2 to 4 hours. 28% of you thought 4 to 6 hours. 26% of you thought 6 to 8, and 15% thought 0 to 2. Yeah. All right, let's get another one going here. All right, I want to get one that talks about these charges. Let me see if I can figure out how to get all of these charges. I don't want just a blanket. We've taken a couple blanket ones, but let me try one that talks specifically. All right, let's see. Well, first of all, we'll go with Jimmy. We'll do a couple different polls because I don't want it just to be all encompassing. So, did Raul delete Jimmy, or was? I guess they're all going to kind of be. All right, no, we'll do them individually. Was it self-defense? All right. Let me get the exact language here. All right, count 1. Intent to cause, did stab. Okay. Intent to cause deletion. What's wrong now? Intent to cause deletion. I'm just going through. Okay, then the second one was manslaughter, right? Okay. Manslaughter. Go to count 2. Okay, yeah. So manslaughter intentional. So that's intentional. Intentional, right? Oh my God, come on. All right, so intent to cause the deletion. That's the intent to cause the. Okay, so that's murder 1 and 1 and 1. Intent to cause deletion, and then manslaughter is intentional. Now let's start with that. Did Raul delete Jimmy? Say that better. Let me just see this. Is Raul? What would you? Your verdict be? All right. What would your verdict be for Jimmy's? I hate to say it like this, but passing. What would your verdict be for Jimmy's? Maybe for count 1. Jimmy, for count 1. Count 1. Jimmy. Okay. What would your verdict be? What would your verdict be for count one, which is Jimmy? So M1, intent to cause deletion, manslaughter. But it was intentional. All right, let's start with that. All right, let's start with that, you guys. All right, new poll out there for you guys. New poll. Okay, new poll for you, chat. We'll just go through them. We'll do like every half hour or something. We'll do a new poll or 15 minutes, however long it is. All right. Oh, let's see. Oh, CK, you saw the couscous video. Cool. Thank you. Appreciate that. Dan Smith, I don't grasp M in the first, though. So then you would go with, oh, I suppose I should have said not guilty. Well, wait a minute. Let's see. Was there a not guilty? I should have said not guilty. I should have added not guilty. All right. Should I get rid of that? Let me get rid of that. I'm sorry, you guys. I screwed that up. Let me end that. I screwed that up. Let me put not guilty. Sorry. I screwed that up. All right, let me do another one. I totally forgot not guilty. All right, sorry guys. All right, let's do it this way. All right, because there is a possibility that he would be not guilty because it was self-defense. So okay, let me get this. Sorry. My apologies for that. Sorry about that, guys. All right. And then we have to add a not guilty, which would be self-defense. Okay. Now we go. What would your verdict be for count one, Jimmy? Intended to cause, murder one, so manslaughter, intentional, not guilty of both, which would be self-defense. All right. Now we can go ahead. All right, now we go ahead. All right, now new poll. Now. All right, let's see what are you guys saying here. Hey, Willow Johnson, hello to you. Yes, Jojo, I'm pretty sure there was self-defense. If not, we're going to go with it. We're just going to go with it. Your choice on count one isn't an option. Oh, manslaughter 2? Was that even an option? I don't remember that being an option. Well, it was first degree or second degree, but I just remember her saying reckless. So I just put down that. Yes, the jury is deliberating. Jury is deliberating. I should put that here. Let me do this. Jury is deliberating. Jury started deliberating at 11 Eastern. There. Will Johnson, I think we'll have a hanging Chad. Gourmet Thursday says it's not self-defense to me if you pursue the fight and with a weapon. Pratt says, and since he brought the knife in the car and pulled it out first, he has a clear incentive to shift any blame he can. All right. So what I want to do is I want to go back and play just start playing again, because I'm so intent on focused on getting the notes and listening, so that I take notes and all that stuff. I want to actually just go back and I just want to listen. I just want to listen to this. So I am going to do this. All right, hold on a sec, guys. I just have to do some things here. Hold on. 1925. Just bear with me for a moment. I'm going to pull this down here. Now I can actually, I want to go back and I just want to listen to day one, and then we can kind of talk about each witness as they come along. Okay. I'm going to put that down here. Okay. All right.
Of we're here today to start the matter of Raul Eliah Valle, so it's State of Connecticut versus Raul Eliah Valle. First day of evidence is prepared to commence. Counsel, please identify yourselves for the record.
Good morning, Your Honor. Mark Durso for the State of Connecticut.
Good morning, Your Honor. Tatiana Messina for the State of Connecticut.
Good morning, Your Honor. Kevin Smith for Mr. Raul Valle, who's at my side.
Good morning. All right, before we begin, there are some preliminary matters that need to be addressed. First, there has been a substitute information that's been filed in this matter. Attorney Smith, have you had an opportunity to review the substitute information?
Yes, I have, Your Honor.
All right, and did you go through that substitute information with your client?
Yes, I did, Your Honor.
It appears to the court the only change in the substitute information is the lessening of one of the charges at count 4 from assault in the first degree to assault in the second degree. Is that your understanding?
Yes, it is, Your Honor.
I'll hear from the state on that. That's your understanding?
Yes, Your Honor.
It's the only change that's been made?
That is the only change.
Thank you. And Attorney Smith, does your client wish for a long reading of the long form, or are you prepared to enter pro forma pleas?
We're prepared to enter pro forma not guilty pleas, Your Honor.
All right, jury election, I'm assuming.
Jury election.
All right, so then we're prepared to move forward. A few more things before we begin. Come on in, sir. All right, I'd like to take a moment to address those in the gallery here to observe the proceedings, as well as those watching via live stream broadcast. Pursuant to Connecticut Practice Book Section 1-10, you may use a personal computer in this courtroom during proceedings to take notes unless and until the court determines that the use of such device is becoming disruptive to the proceedings. The personal computer, however, may not be used for any other purpose while you are in the courtroom, including but not limited to access to the internet, social media posting or live streaming, email, text messages or chatting, recording, live streaming, or any other form of posting or transmitting information about the trial as it proceeds, unless conducted pursuant to a media request filed by a member of the media defined at Connecticut Practice Book Section 1-110A, and in accordance with Connecticut Practice Book Section 1-11C, as permitted by this court. Media orders have been entered in this file. If you have any questions regarding the scope of the order, please refer to the clerk's file at the clerk's office. To date, the only formal request that has been made in accordance with the rules of practice has been made by one media outlet, Law and Crime, hence no other person or outlet should be recording, either by way of video or audio, any of these proceedings, including still photographic images. This order does extend to any video recording, audio recording, or the taking of photographs of any of our jury members while such jurors are on court property. Additionally, no other electronic devices, including cell phones, are to be used in this courtroom for any purpose whatsoever. You are prohibited from using a cell phone or any electronic device at any location of the Superior Court to take pictures, to take videos, audio recording, or broadcasting still or moving images, unless you are at the clerk's office photographing records. Lastly, this court will not tolerate any violation of these procedures. To note, disruptive behavior from the gallery, including but not limited to any extreme emotional behavior, outbursts, comments, intimidating behavior, or any other actions which may affect the integrity of this trial process, may result in immediate removal of you from the courtroom. This extends and applies equally to all public areas of the courthouse as well. Please be mindful of your behavior. If you feel yourself becoming unable to control your emotions at any time during these proceedings, kindly remove yourself from the courtroom. Also, as a general announcement, it is anticipated that graphic and/or sensitive evidence may be introduced. We will do our best to provide you notice before any such evidence is displayed. However, I cannot assure you that this will be foolproof, and therefore provide you with notice that if you are sitting here in the gallery watching the proceedings, or you are watching the proceedings live stream, you should please be vigilant and pay attention to the evidence and make your own determination as to what is tolerable and when perhaps you should remove yourself from the proceedings or turn yourself away from the live streaming broadcast. So I do ask everyone to please follow these rules as they pertain to courtroom and courthouse decorum, so that we can proceed through this trial in the fairest and most efficient way for all parties involved. So thank you so much for your cooperation. Does anything need to be addressed by counsel before the court brings the jury in?
Your Honor, just from the defense, we would be moving for sequestration of the witnesses pursuant to 42-36 and ask that the court enter such an order.
All right, Attorney Durso, do you wish to be heard on that?
I don't have an objection to that. I don't see do see one witness that was on the witness list. The defendant's mother was on the witness list. To the extent that she becomes a potential witness in rebuttal or on defense's case in chief, I think that needs to be addressed by the court. But outside of that, I don't see any other witnesses.
Attorney Smith?
Your Honor, I understand that she is a witness on the state's witness list. The defense certainly does not have any intention to call her. I would ask that she be allowed to remain in the courtroom and not be subject to that sequestration order.
All right, so Attorney Smith, she's not on your witness list currently, correct?
That is correct.
All right, so I just go back to you, Attorney Durso. Is it possible that if in fact there are segments of the trial that you believe would cause some sort of problem with the sequestration order and having the potential witness, that being the mother, the defendant being in the courtroom, would you be able to sort of carve those out and bring that to the court's attention?
I guess I can, Your Honor. I don't necessarily – I anticipate what the evidence is going to be. However, if certain things are mentioned during the course of the trial where the defendant's mother would become a potential rebuttal witness, that would obviously be the state's concern. So for her to watch the entire trial and maybe tailor her testimony would be problematic. That's the only concern the state has at this time. Obviously, I don't know what the evidence is going to be on the defense side, but that's the state's concern.
All right, so what I'm going to do is I am going to allow the mother to stay in the courtroom. I am going to ask the state's attorney to, at any point in time, that if you feel there is testimony that would create a tailoring issue with respect to that particular potential witness on your witness list, to please bring that to the court's attention, and we'll address it at that time. All right?
Yes, Your Honor.
Thank you. And that's sufficient with you, Attorney Smith?
That is, Your Honor. Thank you.
All right. So then the court, did he anticipate that this would be requested? I'm just going to read through this instruction quickly so that everyone has an understanding of what this means. So I am going to go ahead and grant the motion to sequester witnesses. This is the order that is going to be in place. All witnesses, defense and prosecution, including expert witnesses, shall be sequestered while another is giving testimony and shall be precluded from discussing testimony with any other witness. This order extends to any and all such testimony via live coverage, testimony recorded, broadcasted, displayed on any other media platform, transcribed or documented by way of any other written or photographic form. The order extends to the transmittal of testimony to a witness by any means, directly or indirectly, through a third person or entity. Upon a sequestered witness's completed testimony, the sequestered witness is allowed to observe the proceedings in person or otherwise. The sequestered witness, however, continues to remain under the court's order to not discuss or transmit their testimony by any means to any other prospective witness. Counsel shall provide notice to all prospective witnesses of this obligation under the orders to their witnesses, and also shall inform the court immediately of any known or suspected violation of the order. The intent of the court in entering this order is to impose a broad application of the rule for the purpose of preventing witnesses from tailoring their testimony to that of other witnesses, and to help to ensure a fair trial in the days of digital streaming, live media coverage, and other technological advancements. So with that, the order stands. Madam Clerk, I'll give you a copy of this. Is there anything else that needs to be addressed by the court before we bring our jury in?
I don't believe so, Your Honor.
Not from the defense, Your Honor.
All right, so with that, we are ready to proceed. Madam Clerk, please bring in our jury.
So, LW, you kept quiet about the judge. I do believe she was a bit biased. Here, hold on. I think she was a bit biased against the prosecution or in favor of the defendant, maybe because he was young. I'll have to keep an eye out for that. Jacqueline, yes. If you look at our description, he's out on $2 million bond, but he's under strict house arrest and he has GPS monitoring. He also was not supposed to use, he's not allowed to use any kind of, he's not allowed to use the internet. He can't go on the internet, and I think it maybe unless to do schooling, which he's not doing, but yeah, he's out on bond. Denise, poll questions were too narrow with the exception of not guilty. The other options include intent. They're too narrow. Well, that's kind of what I wanted. I didn't want, because we've done, Denise, we've done just random guilty, not guilty. So I wanted to drill down. These are the charges that they're going to be considering. So I wanted to get, I didn't want it to be, just wide open. Hey, hola, how are you? Good to see you. Mark asked, did Tyler know that Raul had the knife when they went back to talk about the car damage? I don't think that's when he got the knife. According to Raul, Jack threw him the knife when he saw those kids come running at him. So they were already looking at the car damage, I think. Pretty sure that they were already looking at the car damage. YouTube monitors, unless please refrain from the all caps, just saying. YouTube monitors, one, the older kids should be held responsible for what happened. Yeah, there should be a lot of people that should be held responsible. 100%. Hola, high panic, baka and squeegee. Catherine, so since he was 16, he hasn't gone to school. Trial take so long to start. No, he said he completed his. He did say he completed his GED. He's not in school. Hold on a sec. Let me. I think he completed it. It took him a little bit. He finished high school in 2023. So this happened in 2022. So he did say he finished school. He finished it online. Yes, he did graduate. He graduated in 2023. He said he took online courses. Billy, what's up? How are you? How's it going? Thank you for dropping in. Always good to see you. Hope all is well. All right, so let's get back to this. This is day one recap. I'm replaying day one, so it's replay of day one while we wait for the verdict. While we wait.
Good morning, ladies and gentlemen of our jury.
State will stipulate to the presence of the jury.
Defense stipulate as well, Your Honor.
All right, thank you. So, members of our jury, at this point in time, I am going to ask you to pay your attention to Madam Clerk. She is going to be conducting a jury roll call and providing an oath to you. Thank you. Madam Clerk.
Ladies and gentlemen, as your names are called, please indicate your presence by answering here, rise, and remain standing. firm as the case may be, that you may decide this case between the state and the defendant based on the evidence given in court and on the laws of the state as explained by the judge. That you will not talk to each other about this case until instructed to do so. That you will listen to and consider what the other jurors have to say in deliberations about this case. That you will not speak to anyone else or allow anyone else to speak to you about this case. And that when you reach a decision, you will not disclose the decision until it is announced in court. So help you God, or upon penalty of perjury. If so, please say I did.
I did.
Thank you. You may be seated. As your names are called, please indicate your presence by answering here, rise. That you will listen to and consider what the other jurors have to say in deliberations about this case. That you will not speak to anyone else or allow anyone else to speak to you about this case. And that when you reach a decision, you will not disclose the decision until it is announced in court. So help you God, or upon penalty of perjury. If so, please say I did.
I do.
Thank you.
All right, thank you. Members of the jury, my remarks at this time are to generally acquaint you with some of the legal principles that will control your deliberations and give you an idea as to how this trial will proceed, how long it's expected to take, and what our daily schedule will be. You will get detailed instructions of the law at the end of the trial before you begin your deliberations. Now, I will be reading from a set of documents to ensure that I do get all of the important information that I intend to get out to you accurately. So this is a criminal case. The state has brought charges against Raul Eliah Valle as follows. In the substitute information in the Superior Court of the State of Connecticut for the Judicial District of Ansonia Milford in docket ending 418T, Part A, June of 2025, Mark R. Durso, Senior Assistant State's Attorney, accuses Raul Eliah Valle of murder and charges that in the County of Fairfield, in the City of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Eliah Valle, with intent to cause the death of one James McGrath, did stab and cause the death of the same said James McGrath in violation of Section 53A-54A, subsection A of the Connecticut General Statutes. Count 2. And said state's attorney further accuses the said Raul Eliah Valle with the crime of assault in the first degree and charges that in the County of Fairfield in the City of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Eliah Valle, with intent to cause serious physical injury to one Ryan Hines, did cause serious physical injury to the said Ryan Hines with a dangerous instrument, to wit, a knife, in violation of Section 53A-59, subsection A1 of the Connecticut General Statutes. Count 3. And said state's attorney further accuses the said Raul Eliah Valle with the crime of assault in the first degree and charges that in the County of Fairfield in the City of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Eliah Valle, with intent to cause serious physical injury to one Thomas Connery Jr., did cause serious physical injury to the said Thomas Connery Jr. with a dangerous instrument, to wit, a knife, in violation of Section 53A-59, subsection A1 of the Connecticut General Statutes. And count 4, said state's attorney further accuses the said Raul Eliah Valle with the crime of assault in the second degree and charges that in the County of Fairfield, in the City of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Eliah Valle, with intent to cause physical injury to one Faison Teal, did cause physical injury to the said Faison Teal with a dangerous instrument, to wit, a knife, in violation of Section 53A-60, subsection A2 of the Connecticut General Statutes, dated at Milford, Connecticut, the 13th day of June 2025, signed by Mark R. Durso, Assistant State's Attorney. Now, ladies and gentlemen of the jury, the information which I just read to you is not evidence. It is merely the formal means of accusing a person of a crime and bringing him to trial. You must not consider it as any evidence of the guilt of the defendant or draw any inference of guilt because the defendant has been arrested and formally charged. Every defendant in a criminal case is presumed to be innocent, and this presumption of innocence remains with the defendant throughout the trial, unless and until he is proved guilty beyond a reasonable doubt. The burden is on the state to prove the defendant guilty beyond a reasonable doubt, and that burden of proof never shifts throughout the trial. Unless you find at the conclusion of all the evidence that the state has proved beyond a reasonable doubt that the defendant has committed every element of an offense, you must find him not guilty of that offense. On the other hand, if you are satisfied that the evidence establishes the guilt of the defendant beyond a reasonable doubt, you should not hesitate to find him guilty. Now, the defendant may or may not testify in this case. An accused person has the option to testify or not to testify at the trial. He is under no obligation to testify. He has a constitutional right not to testify. You must draw no unfavorable inferences from the defendant's choice not to testify if the defendant chooses to not testify in this case. The procedure of the trial is as follows. After I finish this instruction, the state will present its evidence, then the defendant may present evidence. The defendant has no legal obligation to present evidence. The law does not require a defendant to prove his innocence or to produce any evidence. If the defendant does present evidence, the state may then present rebuttal evidence if it so chooses. When all the evidence has been presented to you, the lawyers will then make their arguments to you. Bear in mind, argument is not evidence. You may consider argument of counsel during your deliberations, but it is not evidence. Under our rules, the state argues first, then the defendant through counsel argues, and then the state argues a second time. But the defendant does not argue a second time. Each counsel is, however, given the same amount of time for argument. It is only the state that breaks its argument into two parts. When arguments are completed, I will then instruct you as to the law that you must apply in this case. At the conclusion of the instructions, I will send you to the jury room to begin your deliberations. That is the first time you will discuss this case with anyone. Up until that time, you will not discuss this case with anyone, not even each other. Once deliberations start, all deliberations must be conducted in the jury room and only when all jurors are present. When you deliberate, you apply the facts that you find to the law as I instruct to reach your verdict, and your verdict must be unanimous. My responsibility as judge is to conduct the trial of this case in an orderly, fair, and efficient manner, to rule on questions of law that arise during the trial, and to instruct you as to the law that applies to this case. It is your duty to accept that law as I state it to you, whether you agree with it or not. My actions during the trial in ruling on claims or objections by counsel, in comments to counsel, in questions to witnesses, or in setting forth the law in instructions to you are not to be taken by you as any indication of my opinion as to how you should determine the issues of fact. If you come to believe during the trial that I have expressed or intimated any opinion as to the facts, you should disregard it. As I've told you, my job as judge is to ensure there is a fair trial so that you can decide this case. During the course of the trial, I may occasionally ask questions of a witness. Do not assume that I hold any opinion on the matter to which my questions may relate. Remember at all times that you as jurors are at liberty to disregard all comments of the court in arriving at your own finding as to the facts in this case. You must not take anything I may say or do during the trial as indicating what I think of the evidence or what your verdict should be. Your function as the jury is to determine the facts. You are the sole and exclusive judges of the facts, and you alone determine the weight, the effect, and the value of the evidence, as well as the credibility of the witnesses. You must consider and weigh the testimony of all the witnesses who appear before you, and you alone are to determine whether to believe any witness and the extent to which any witness should be believed. It is your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. In the course of evaluating the evidence, you are entitled to draw any and all inferences that you find reasonable and logical from the evidence you hear. You will decide what the facts are from the evidence that is presented here in this courtroom. That evidence will consist of the testimony of witnesses, documents, and any other material admitted into evidence as exhibits, and any facts on which the lawyers agree or that I may instruct you that you must accept. The following are not evidence, and you must not consider them as evidence in deciding the facts of this case. Statements and arguments by attorneys, questions and objections of the attorneys, and testimony that I instruct you to disregard. There are two kinds of evidence in a trial, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, it is evidence from which you can infer another fact. As an example, if you wake up in the morning and see that the sidewalk is wet, you may infer that it rained during the night. The wet sidewalk is circumstantial evidence that it rained. Other evidence, however, may provide another explanation for the water on the sidewalk, such as a garden hose that was left on overnight. Therefore, before you decide that a fact has been proved by circumstantial evidence, you must consider all the evidence in the light of reason, experience, and common sense. In deciding this case, you may consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. Now, some evidence may be admitted for a limited purpose only. When I instruct you that a piece of evidence has been admitted for a limited purpose, you must consider it only for that purpose and for no other. In deciding the facts of this case, you are the sole judges of the credibility of witnesses. You will have to decide which witnesses to believe and which witnesses not to believe. You may believe everything that a witness says, or only part of it or none of it. Every witness, however, starts on an equal basis. You are to listen to all of them with an open mind and judge all of them by the same standards. Police will be testifying in this case. You must determine the credibility of police officials in the same way and by the same standards as you would evaluate the testimony of any other witness. The testimony of a police official is entitled to no special or exclusive weight merely because it comes from a police official. You should recall his or her demeanor on the stand and manner of testifying and weigh and balance it just as carefully as you would the testimony of any other witness. You should neither believe nor disbelieve the testimony of a police official merely because he or she is a police official. During the course of the trial, counsel for either party may object to a question asked by the other lawyer. It is the responsibility of counsel to object to evidence which he or she believes is not properly admissible, and you should not be prejudiced in any way against a lawyer who makes objections. When that happens, I will rule on the objection. If I sustain the objection, you will not hear an answer to the question, and you should not wonder why it was asked or speculate as to what an answer would be. If I overrule an objection, you will hear an answer to the question, and you may give it whatever consideration you feel that it is entitled to. There may be times when counsel or the court may ask that you be excused when arguments or objections are made. Those arguments often include matters or evidence that the court may eventually exclude. The reason that I ask you to step out is to assure that you will not hear evidence that is not properly admissible and not to keep you from evidence that you should hear. A few moments ago, you took an oath that will govern your conduct as jurors between the time you took the oath and the time you're discharged by me after you've rendered a verdict in this case. That oath and the rules of court obligate you to do certain things and to avoid other things. So I would like to review those obligations with you at this time. First, you must decide this case based solely on the evidence presented here in the courtroom and on the law as I explain it to you. Second, do not make up your minds about what this verdict will be until after you have heard all the evidence, heard the closing arguments of the attorneys, my instructions on the law, and after that, you've had an opportunity with your fellow jurors to discuss the evidence. Keep an open mind until that time. There are some rules that flow from these obligations. I'm going to go over those. You may not perform any investigation or research or experiments of any kind on your own, either individually or as a group. Do not consult any dictionaries for the meaning of words or any encyclopedias or the internet or any other source for general information on the subjects of this trial. Do not look anything up on the internet concerning any you may not communicate trial.
Sorry. this is just kind of, let me fast forward. You're right.
You will recall my earlier
don't have to
definition of what constitutes not to take if you own for your
guys.
witness. All right, with that then, I will direct the state to please call its first witness.
Thank you, Your Honor.
Thank you.
The state would call Lonnie Blackwell to the stand.
Please watch your step. Please remain standing as you enter the witness box. Pay attention to Madam Clerk, who will be putting you under oath. Thank you.
Please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or competency of perjury?
I swear.
Please state your full name, spelling your last name for the record, as well as your badge number and business address.
Lonnie Blackwell. Last name is Blackwell. And what was it?
Badge number and business address.
Currently, I don't have a current badge number. My business address would be 150 Court Street in New Haven, Connecticut.
Thank you. You may be seated.
Good morning, Mr. Blackwell.
Good morning.
You mind just keeping your voice up? It's a little loud in here with the AC, okay?
No problem.
Can you please tell the ladies and gentlemen of the jury what you currently do for a living?
Yep, so currently I'm employed by the Department of Homeland Security. I'm awaiting to go my training to become a special agent in about 2 months. I've been employed by them for about a month. Prior to that, I was a police officer for the Shelton Police Department for about 4 years.
And when you were a police officer, did you have any training that you had to go through to become a police officer?
Yes, I attended the Milford Police Academy for about 8 months in 2021.
And I want to direct your attention to May 14th of 2022. Were you working that day for the Shelton Police Department?
Yes, I was working the evening shift, 4 p.m. to midnight.
And what were your responsibilities that night?
I was on the patrol division at the time, so I was responsible for responding to calls that were in my area that was assigned to me.
Did you receive a 911 call that night to report to an area of Shelton?
Yes, I did.
And can you tell us a little bit about that?
Yes, so around 11:53 p.m. that night, dispatch reported that there was multiple stabbing victims at the address of 43 Laurel Glen Drive. I immediately responded to the area and arrived to the area of the scene in about 6 or 7 minutes.
Your Honor, I don't think there's an objection. We have some exhibits that have been pre-marked. I'd be asking to give me full exhibits at this time. I don't know if we're going to do
All right.
No objection, Your Honor.
Have they been marked full? Yeah.
Your Honor, I have reviewed these in advance.
All right, give me one moment. Once they're marked.
Your Honor, want to review this one?
Guess what number has that one? Thank you. Thank you. Attorney Smith, you've had an opportunity to review Exhibits 1 through 9.
I have, Your Honor. I'll take a chance to
Thank
go
you.
through them one more time now that we've got the numbers on them.
Thank you.
No objection, Your Honor.
All right, court will go ahead and accept into evidence State's Exhibits 1 through 9.
If I may approach the witness, Your Honor.
You may.
Mr. Blackwell, I'm showing you what's been marked as State's Exhibit 1 as a full exhibit. Can you tell the ladies and gentlemen of the jury where you responded to in State's Exhibit 1?
Yep, so when I initially was going to the call, I turned on to Adams Drive here, and I drove up to the intersection of Laurel Glen and Adams. When I approached Laurel Glen, I could see from my cruiser that there was a large group of juveniles. At the time, I approximated maybe 30 juveniles right in front of the yard of 43 Laurel Glen. And I was flagged down at the corner of Adams and Laurel by a small group of female juveniles who waved me down and started pointing me towards the direction of where the incident occurred. So I exited my cruiser at the time and began jogging over to the front yard of 43 Laurel Glen.
And just for the benefit of the record, is 43 Laurel Glen located where that red mark is on top of, in the middle of States 1?
Yes.
And when you got to the scene, what was the scene like?
It was chaotic. As you can imagine, a large group of juveniles. Pandemonium, I would describe it as that. That's best.
Around what time did you arrive there?
Right around midnight.
And what were the lighting conditions out that night?
It was dark, but I could clearly see, probably due to the mix of lights on the house as well as a ton of the juveniles had phones out, lights from the phones, as well as my own flashlight, but everything I could see pretty clearly.
I want to show you State's Exhibit 2 that's marked as a full exhibit. Can you see that?
Yes.
Again, is this 43 Laurel Glen where you arrived at 12 a.m. on the 15th of May of 22?
Yes.
And is this States 2 kind of show the area, what it was like, absent the individuals on the front lawn?
Yes.
And when you got to 43 Laurel Glen on the 15th, midnight on the 15th, where did you respond? Can you tell us where you responded to in States 2?
Yes, so when I walked up on foot, I responded to this specific area of the grass area to the right of the house if you're looking at the front of the residence. And that's where a large majority of the juveniles were located, as well as the 4 victims that I later identified.
I'm going to show you States 5. This is a daylight picture that was taken, obviously, at 43 Laurel Glen.
Yes.
Okay. And the area that you responded, you see this debris area here pointing to the middle section of the grassy area where there looks like there's some clothing items located just to the right of the basketball hoop and just below the red bush area here. Is that the area that you responded to?
Yes.
Okay. And when you responded there, tell the ladies and gentlemen of the jury what you encountered at that point in time.
Yep, so a few of the juveniles pointed me to the victims. So at first, within this area on the grass to the left, I identified 2 victims. One victim had a wound to his arm. He was responsive, he was standing, he was talking. Another victim was sitting upright on the grass, and I witnessed what appeared to be a stab wound to his torso area. He was still responsive at the time. Then I moved on to the right side of the grass area, where then I identified another victim with multiple stab wounds to his leg. At that time, I saw he was bleeding a lot out of the leg, and I applied a tourniquet to his left thigh area as high as I could. And then after applying that tourniquet, I moved on to the last victim that I identified as having a wound to his chest area and began providing medical attention as best I could.
With regards to the third individual that you applied a tourniquet, can you tell the ladies and the gentlemen of the jury why you did that?
Yes, so for my training in the police academy, for our medical training, we're taught if you have a wound and are bleeding a lot from an appendage and you're able to place a tourniquet, that can assist in stopping the bleeding. So that's why I placed it as high as I could on his left leg, where most of the wounds I saw were, to assist in stopping the bleeding.
And based on your training experience, based on what you saw the wounds to be like, what gave you that impression that the tourniquet was appropriate at that point in time?
First of all, because they were on an appendage, and I witnessed a large amount of blood being lost from the wounds, so I was able to apply the tourniquet due to it being on the leg.
I'm going to show you State's Exhibit 7 that's been marked as a full exhibit. Again, is this the area that you responded to that night?
Yes.
Okay. And you see there's like a blue T-shirt here, what appears to be blue clothing, pointing to the middle of State 6.
Yes.
And can you tell the ladies and gentlemen of the jury, is that the area that you responded to after you applied the tourniquet to the third individual? Is that where you found the fourth individual, around that area?
Yes, in that area.
And when you found the fourth individual in that area, tell the ladies and gentlemen of the jury what you observed when you got to that person.
Yes, so when I identified the fourth victim, I immediately recognized that he was blue in the face, which was indicating to me that he probably had lost a large amount of blood, and I did locate a wound to his chest area right near the heart, and did see a lot of blood coming from that wound. So at the time, I believe some other juveniles brought out rags or cloth or some sort, maybe a T-shirt, and me as well as them, we were assisting in just compressing the wound, just trying to stop the bleeding the best we could until EMS arrived.
And were you successful in stopping any of the bleeding before EMS arrived?
Partially, but from my observations, there was a lot of blood lost.
And how long would you say it took for EMS to arrive after your arrival?
Approximately 10 minutes.
When you got there, did anybody else from the Shelton Police Department arrive on scene prior to EMS's arrival?
I believe Officer Nemhard, or right around the same time.
And at the point where you and Nebhard were on scene, what were your responsibilities at that point?
First of all, to just secure the scene, make sure we identified all the victims, number one, and also if there were still suspects in the area or on scene, as well as in the house, which we had not cleared yet. So just a lot of moving parts and identifying what was going on.
Just want to go through these exhibits a little bit. Just real quick. Stage 3. This is just another angle looking towards the street of Laurel Glen that night. Does that reflect what the area looked like, minus maybe the headlights of the cruiser there?
Yes.
Okay. And again, Stage 4, another angle of 43 Laurel Glen in the area where you responded to. Is this an accurate depiction of what that area looked like?
Yes.
And 6, Stage 6, again, this is just another perspective of that area on or about May 15th of 2022.
Yes.
And again, Stage 8, a closer up perspective of the area where you responded to and found 4 individuals suffering from stab wounds that night, excuse me.
Yes.
And again, Stage 9, this is the area from the left side of 43 Laurel Glen, the area you responded to.
Yes.
Now, after police responded to the scene and EMS finally responded 10 minutes later, did your responsibilities change at the scene?
No, at the time I still assisted EMS in providing medical attention. Like I mentioned before, with whatever cloth or rag I was provided, I kept compressing on the wound while EMS then began doing compressions, as well as with the assistance of a neighbor, I believe.
And during your time providing aid with EMS, how long would you say you stayed with the fourth individual at that point?
Approximately 10 minutes.
And at some point after 10 minutes, what happened after that?
EMS then transported him.
And did you follow EMS to where they were transporting him?
I did not. I stayed on scene.
Now, when the individuals were starting to be transported, withdrawn, at some point in time, were the other individuals who were suffering from wounds transported to the hospital? Do you have?
Yes.
And did your responsibilities at that point change once those individuals left 43 Laurel Glen?
Yes.
And what was your responsibility at that point?
At that point, it was to secure the rest of the scene and contain the large amount of juveniles that were there, so then we can begin interviews.
And did you, in fact, begin interviews at the scene?
Yes, I did conduct a few interviews.
And the information that you received from those individuals, did you pass that information on to anybody?
Yes, it was all passed along to the Detective Bureau.
And did the Detective Bureau, based on your observations, respond to 43 Laurel Glen that night?
Yes.
And who responded to that scene at that time?
Detective Bango responded, as well as Lieutenant Kozlowski.
And at that point in time, in May 15th of 2022, did you have body-worn camera?
No,
Why not?
they were not issued to us yet.
Okay. And at some point in time later on in that year, was body-worn camera a requirement of all police departments?
Yes.
Was it a requirement of the Shelton Police Department on or about July 1?
Yes.
So do you know whether or not the Shelton Police Department, in fact, had a body camera at that point in time?
I believe they had one body camera issued.
And do you know what, if anything, that body camera was used for in relation to any investigation?
I believe it was used to record some of the interviews.
And do you know, in fact, whether or not that body camera was used in this case?
I believe so.
Now, how long would you say that you were on scene at 43 Laurel Glen conducting your witness interviews and securing the scene for?
Approximately three or 4 hours.
And at some point in time, did you leave the scene?
Yes, I went back to the headquarters to type my report.
And based on your witness interviews at 43 Laurel Glen, not telling us what they said, but were you able to identify or develop a suspect that you were looking for from those interviews?
Yes, we were able to develop a group of suspects that fled in a vehicle from the scene.
And were you able to develop and identify a vehicle that they were seen fleeing?
Yes, I believe it was identified as a Honda SUV.
And was that information passed along to the Detective Bureau as well?
Yes.
They may have a moment, Your Honor. Your Honor, I have no further questions for this witness.
Attorney Smith?
Thank you, Your Honor.
Sorry.
Good morning, Officer Blackwell.
Morning.
Just want to go over your testimony here. You are currently training, but you haven't yet started with Department of Homeland Security. Is that true?
I'm employed right now. I'm awaiting to go to my training.
Okay. And where are you employed right now? Is that also with DHS?
Yes, with DHS.
Okay, but you are going to complete your training and then go on to do what exactly?
To be a Homeland Security investigator.
Gotcha. You told us that you arrived about midnight in response to a call from dispatch, correct?
Correct.
And you got to 43 Laurel Glen Drive. That's a house in the Shelton neighborhood that you've described there on that Exhibit 1 behind you, correct?
Yes.
And that is a neighborhood that is comprised of a few through roads and then a number of roads that end in cul-de-sac. Is that fair to say?
Yes.
Were you familiar with this neighborhood yourself prior to going there?
To a degree, yes.
How were you familiar with it?
We switch assignments every day on areas that we patrol, so once or twice a week I'd be assigned to that area.
You described that once you got to the scene, it was fairly well lit due to the vehicles that were there, people using their own flashlights, your flashlight, your
Yes.
car, correct?
Correct.
As you were driving there, is it well lit along that path from Adams?
On the road?
On the road.
I couldn't say. I had headlights, obviously. I'm not super familiar with the street. If there's street lights.
Would you say that it got lighter once you got to the scene than it was as you were driving there?
Yeah.
When you arrived, there were cars parked in the driveway.
Yes.
There were cars parked in the road, correct?
I believe so.
Both sides of the road, correct?
I believe so.
And you, in fact, didn't park there at the house. You parked some distance away and walked to the scene, correct?
Correct.
When you got there, did you notice that there were any signs of drinking?
Initially, no. When I initially got no.
When you say initially, no, at some point, though, you did come to see that there were signs of drinking having gone on at that location, correct?
Yes, later on in the night.
And what signs of drinking did you encounter?
I believe there was alcohol bottles found.
Was that inside the house, outside the house?
I can't recall.
Red Solo cups, kegs, bottles of liquor, what are we talking about?
I can't recall exactly.
All of that, perhaps?
Possibly.
Objection as to possibly? I mean,
Overruled.
Were there any signs of any adults on scene?
Initially, no, but some adults did respond.
So when you initially arrived, do you think there were maybe 30 people there in the yard?
My best guess was about 30.
All juveniles?
Yes.
And do you think it's possible that there were in fact more than the 30 that you saw? Were others in the house?
Objection.
Good.
Sustained.
Possible, yes.
Ask that be stricken.
The objection was sustained. I'll move to strike. Ladies and gentlemen, I'm striking the response, so you're not to consider that as evidence. Thank you. Attorney Smith.
You believe you witnessed approximately 30 people in the yard?
Yes.
All juveniles?
Yes.
You told us at that point you had not cleared the house, correct?
Correct.
Did there come a time when you did clear the house?
Yes.
And were there more people inside the house?
I believe so.
How many people would you say?
I could not tell you.
You told us that you began doing some interviews after you'd secured the scene, correct?
Correct.
What was the time that you started those interviews, do you think?
Approximately 12:45.
So about 45 minutes after you arrived on scene, you think?
Approximately.
And you told us that you spoke to, I believe, 3 different people on scene?
Possibly more, correct? Yeah, around.
You only took interviews or statements from 3 of those, is that correct?
Yes.
But you may have spoken to more?
Yes.
You told us you came to learn some information that you passed along to the Detective Bureau, correct?
Correct.
And that was information regarding possible suspects, correct?
Correct.
And information regarding the vehicle that some folks claimed they were in, correct?
Correct.
Did you learn at any point of the existence of any video or recordings that people had made?
No, I was not aware.
Did you learn that any of the people that you had spoken to had been involved in fighting or attacking either Mr. Valle or any of the other folks that were there?
I learned there was a fight.
Did you learn that any of the folks that you spoke to were involved in that fight?
Yes.
When you were speaking with those individuals, did they show any signs of having been drinking?
Possibly.
Did you take any notes while you were doing your interviews or otherwise on the scene?
Yeah, I had a notepad, as well as a written statement form.
When you cleared the house, did you notice any signs of drinking inside the house?
I do not recall.
You're shown here on the Elmo some photographs from the scene. I just want to take a look at those. Showing you what has been marked as State Exhibit 3. That's a full exhibit. You see that, sir?
Yes.
And in this photo that you're seeing here, there are cars parked on the street. You see those?
Yes.
Is that how it looked when you arrived on scene?
I believe so.
Did you take this photograph yourself?
No.
And you see that there's some tape there, correct?
Yes.
That's the tape that y'all used to secure the scene, right?
Yes.
I'm going to show you now what has been marked as State's Exhibit 9. See that same tape there, correct?
Correct.
Securing the scene.
Yes.
And those vehicles, those are the same vehicles that had been parked when you arrived the night before, correct?
I do not know.
Showing you now what has been marked as State's Exhibit 2. Do you see that, Officer Blackwell?
Yes.
Would you agree that those same vehicles are there in the parking, in the driveway?
As the previous picture?
As in the daylight picture that we just saw with the secure tape around it?
I would have to look side by side.
Sure. You see what I'm showing you right now is Exhibit 2, correct?
Correct.
You see those same vehicles there?
2 of them, yes.
Can't see what was on the other side of those vehicles in the picture that was shown before. Is that fair to say?
Yes.
But you see that tape behind those vehicles, correct?
Correct.
From your training and experience, that tape is meant to keep the scene as it is, correct?
Correct.
Did you use that tape? Did you put that up yourself?
I do not believe I did.
I'm showing you now what is State's Exhibit 2. Do you see that, sir?
Yes.
See that same tape that's corralling off the yard, right?
Yes.
Because that was the scene of your investigation and you wanted to secure that, correct?
Correct.
No tape used in the street, would you agree?
I do not recall.
Did you ever use any tape to secure any of the vehicles that were parked there on the road on either side?
I did not.
I'm showing you now State's Exhibit 4. Do you see that, sir?
Yes.
Do you see any tape that's in the street?
Just on the basketball hoop?
Nothing in the street, however, correct?
No.
And would you agree, sir, that vehicles that had been there the night before are no longer there in this daytime picture?
Correct.
Officer Blackwell, fair to say you've been called here today to tell us about what you witnessed when you arrived on the scene, right?
Yes.
And you've done that to the best of your ability?
Yes.
But if what these jurors want to know is why Mr. Valle did what he did that night, you can't really be of any help to them at all, can you?
No.
Nothing further.
Attorney Durso.
I have no further questions for this witness.
Oh,
Your
very
Honor.
good. So witness may step down. Thank you. Attorney Durso, I think this is a good time to take the morning recess, okay? So ladies and gentlemen of the jury, I did indicate that we would be having a morning recess as well as an afternoon recess. So we are going to stand in recess for 15 minutes and we'll be back. If you wouldn't mind, please leave your notebooks on the chair. And again, don't discuss anything about this case with your fellow jurors as we take that recess. Thank you. Court stands in recess for 15 minutes. May I see counsel? Thank you.
Court's in recess.
I can zoom through these. We don't need to watch that.
Good morning. Please enter the witness box. Please remain standing. Madam Clerk will put you under oath. Thank you.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. Please state your full name, spelling your last name, as well as your business address.
Michael Egan, E-G-A-N. My place of business is Echo Hose Ambulance, 100 Meadow Street, Shelton, Connecticut, 06484.
Thank you. You may be seated.
Thank you.
Thank you.
Good morning, sir.
Good morning.
Can you please tell the ladies and gentlemen of the jury what you currently do for a living?
I'm a paramedic with Echo Hose Ambulance in Shelton, Connecticut.
And did you have to go through any training to be a paramedic?
We did. It's a pretty extensive program. It's broken down by didactic, which is classroom, and then a clinical portion. My program was just under 2 years, approximately 1,800 to 2,000 hours.
And as a paramedic, are you also an EMT?
You are. I was an EMT first, and then you start as an EMT, and then you can work your way up, and if you choose to go on further, you can become a paramedic.
And what's the difference between being an EMT and a paramedic?
So EMT is considered BLS, which is basic life support. A paramedic would be advanced life support, ALS. On the EMT level, they can do bleeding control, CPR, AED, assist patients with taking some medications, administer a very small amount of medications. Paramedics can do far more. We can go into cardiac monitoring, some invasive procedures. We have a lot larger range of medications that we're allowed to administer. Our scope is just a lot broader than EMTs.
You had mentioned AED with regards to EMTs. What does that mean?
So that's a defibrillator, an automatic defibrillator. That is where you would apply it to someone who's in cardiac arrest. It analyzes a rhythm and then will determine if the patient should be delivered a shock or not. The machine determines that, not the provider, and that's why EMTs don't have extensive cardiac training like paramedics do. So the machine will determine that for them, or a layperson or anybody who's using it.
And what would a paramedic do in an instance where an AED would be used?
Paramedic, they would be hooked up to their what's commonly referred to as a life pack or a monitor, and the paramedic would be interpreting that rhythm based off their knowledge versus the machine doing it, and the paramedic would make the decision to if the rhythm had to be shocked or defibrillated. The paramedic would make that decision versus what the machine making that decision.
Okay. Now, were you working back on May 15th of 2022?
I was.
And in what capacity were you working?
I was an EMT at that time.
And where were you an EMT?
At Echo Jose Ambulance in Shelton.
And EMT, what does that stand for?
Emergency medical technician.
And what shift were you working then?
I was working 6 p.m. that night until 6 p.m. the next morning. I was on a 24-hour shift.
So you started on the 14th into the 15th?
The night of the incident is when I started at 6 p.m.
Okay. And you were slated to get off at 6 a.m. the next
6 p.m. the next day. Yeah, 24. We call it a reverse 24 because you start later in the day.
Okay. And did you have an occasion to respond to a report of medical need at 43 Laurel Glen?
I did.
And I want to direct your attention to State's Exhibit 1 behind you. Is that the area in which you responded that just for the record, the red dot there is 43 Laurel Glen?
That is, yes.
Okay. And when you got there, can you please just, actually, withdrawn. I'm going to show you State's Exhibit 2. Again, is this the house that you responded to that night?
That is.
On a report of medical, someone in need of medical attention?
Yes, sir.
Okay. And when you got there on what time did you get there?
I believe the call was dispatched just before midnight, and we arrived a minute or two after midnight.
Okay. So for all intents and purposes, you arrived there on the 15th of May?
Yes, sir.
So when you got there, can you describe to the ladies and gentlemen of this jury what the scene was like?
Sure. So when we arrived, the police were obviously there. I think there was maybe 1 or 2 units. I can't remember specifically. And there was a large group of people on the front lawn. We pulled just past the residence to leave room for additional ambulances because at that point we had been told there was multiple patients. We got out of the ambulance. We were encountered with a very large crowd. It was rather chaotic. People were screaming and yelling. We knew there was possibly four patients at that time, so we started our triage. We came across the first patient. In this picture, if you kind of see, there's a cluster of, looks like kind of garbage. That's right around where we found the first patient.
I'm going to show you State's Exhibit 5.
Sure.
This is a daylight picture, essentially the same area.
Yes.
Can you use State's 5 to kind of describe what you did?
Yeah, so there's that red tree right there, just in front and to the right of that red tree. We found our first patient. He was laying supine on his back. He was completely unresponsive. His breathing was spontaneous but erratic, which is not a good sign. We immediately checked in times like that for triage, we immediately checked for a pulse, which he had a very weak, thready pulse, which is another bad sign. And he did not look well. You can look at someone that's very sick and determine they don't look well. So we do a rapid trauma scan, which is we check for any major bleeding. So we did that. I remember his shorts were absolutely saturated in blood. And we found a puncture wound to his upper left abdomen, kind of his left lower chest area. So when we come across a wound like that, where there's suspected trauma, you apply what's called a chest seal. In the event that there is a punctured lung, it can help stop that lung from collapsing any further. So we applied that chest seal. At that point, we didn't see another major bleeding, so my partner broke off and continued to triage the rest of the patients. And when I went to reassess that patient that was laying there, we noted that he had stopped breathing at that point. I reassessed the pulse, and he had no pulse.
So you mentioned triage. What is triage? Can you just explain?
Yeah,
that?
of course. So triage is when you get onto a scene and you're overwhelmed by patients for the amount of resources you have immediately available. You have to determine who is in the worst shape and who could benefit most from the help. So if you come across someone that is in cardiac arrest and deceased and you have 4 other patients, you're not stopping to help that patient, unfortunately. You're moving on to someone who can still be helped. Because if you stop to help that person, their odds are very slim. Now, someone else who had another chance to survive, their odds are going down because you're spending time on this person who really has no shot.
Okay. So on the night in question, when you got there, is it safe to say, based on what you've told us so far, when you got there, you attended to the first patient that you saw?
We did, yep.
And that patient, based on your assessment, was still breathing and had a pulse?
Yeah, it was a very weak, thready pulse, and his respirations are very erratic, but they were spontaneous, so he was still breathing technically.
And when you applied the chest seal, I think you said, what, if anything, did that do for the patient?
In this case, I don't believe it did much because when we went to reassess him right after that, he was in cardiac arrest. So I don't think it did anything.
So when he went into cardiac arrest, what, if anything, did you do next?
So when someone goes into cardiac arrest, we immediately apply the AED. The AED will analyze a rhythm. While we're setting up the AED, we'll start CPR. But in a witness arrest, you want to get the AED on as quick as possible. The witness arrest meaning he went into cardiac arrest right in front of us, because odds are he's probably in a rhythm that can be shocked. So we started CPR. I had two bystanders there. One said she was a nurse. One said he was a neighbor that was trained in CPR, because at this point my partner was triaging the rest of the patients. So I directed them to start CPR. We applied the AED. You step back and the AED analyzes. It told us that there was no shock advised. And then we retrieved a BVM, which is a bag valve mask. It's called bagging. We applied it to him, and we began delivering respirations and CPR in 2-minute cycles.
Now, when it was no shock advised, what does that mean?
So the AED will analyze a number of heart rhythms, but there's only 2 rhythms that you can shock: ventricular tachycardia and ventricular fibrillation. And the AED will only deliver a defibrillation. Fibrillation. I meant to say fibrillation. Atrial fibrillation and ventricular tachycardia. Sorry. Ventricular tachycardia and sorry, I'm drawing a blank. VFib, ventricular fibrillation. Sorry. Those are the only 2 rhythms that can have a defibrillation delivered to them. So the AED won't deliver a shock to anything else besides that. So when it says no shock advised, it means it wasn't in one of those rhythms. I can't tell you what rhythm it was. It doesn't tell you what it was. It just means it wasn't one of those.
Okay. So when you applied the AED, you received that information. What, if anything, what steps did you take to continue to render aid to that individual?
Sure. So we insert an OPA, which is a small piece of plastic that's curved that helps keep the tongue forward to help deliver ventilations a little more effectively. And then we do CPR at a rate of 30 compressions to 2 ventilations. And we do that in 2-minute cycles, and the AED will count down and it will tell you to stand clear and analyze. It will analyze, tell you if there's a shock advised, no shock advised, and then you just continue doing that in 2-minute cycles.
Now, what was the scene like around you when this was going on? Do you recall what the scene was like, or were you completely?
Yeah. So it was as I mentioned before, it was pretty chaotic. There was quite a few people that were screaming, a lot of people in distress. I remember it was dark. One of the police officers was providing light to us with a flashlight, but even then, that wasn't like there 100% of the time. So it was fairly chaotic.
Was it so dark where you couldn't see what you were doing in front of you?
No, I could see what I was doing, but it was dark. But I wouldn't say it was like pitch black where I couldn't see anything. I believe there was. I feel as though there was light coming from the house as well. We have scene lights on the side of our ambulance that we turn on as well, that are kind of like floodlights that provide light. In this case, the ambulance was fairly close to where we were working on this patient.
And in looking at this exhibit here, State's Exhibit 5, was your ambulance parked somewhere in the area of this, on the street here, State's 5?
It was, yeah. If you look at that reddish tree, I'd say we were just past that.
Okay. Now past it to the right? Or
to the right.
Okay. Okay. And with regards to Stage 5, can you tell where you were working on the patient you just testified to in Stage 5?
Yeah, so there's a cluster of, looks like white garbage. Right there. I'd say it was right in that area because that looks like the remnants of kind of what we leave behind sometimes in emergent situations. A lot of the wrappers of things that we use.
Your Honor, if the record can reflect that, I'm pointing to what appears to be the lower right-hand corner of the grass area where there is white, looks like maybe gauze pads or debris or medical material.
All right, thank you. Attorney Durso, the record shall reflect that. Thank you.
Now, you said you were an EMT back on May 15th of 2022.
Yes.
Did a paramedic arrive to the scene at some point?
He did. I would say just over 5 minutes, anywhere in the 5 to 10 minute range. A paramedic arrived at that point. Our primary paramedics were from a service called VEMS, Valley EMS, and they are out of Seymour. So anytime that there's a call that is considered advanced life support, they will also come in addition to us.
And when do you know the name of that individual?
Jeff McKee.
And when Jeff responded to the scene, were you present when withdrawn? When Jeff responded to the scene, did he take over care of that patient?
He did. We give a short handoff report of what we encountered, what we've done, and then he assumes primary patient care.
And when you handed off care to Mr. McKee, what, if anything, did you do or did you observe at that point in time?
At that point, I believe we did not spend much time working on him there. We moved him onto the stretcher. We moved the stretcher into the ambulance, and then we started transporting a short time later.
And what were your responsibilities with regards to transport?
During transport, I was driving.
Okay. And who went with you withdrawn? Did you go to the hospital?
Driving, I did, yes.
Okay. And what hospital did you go to?
Bridgeport.
And who was in the ambulance with you while you were driving?
It was Jeff McKee and my partner.
And who was your partner?
Sophia Kaiser.
And what is the protocol when you withdrawn? How long would you say it took to get from 43 Laurel Glen to Bridgeport Hospital?
I can't recall the exact time. If I don't want to guess. I can't give you. It's hard for me to give you a number on that.
When you were driving from 43 Laurel Glen over to Bridgeport Hospital, does the ambulance you were driving does it have lights and sirens on it?
Yes.
Did you in fact initiate the lights
we
and
did,
sirens?
Yep. Mm-hmm.
And okay. And when you get to the hospital, any given patient that you deliver to the hospital, what's the protocol for handing off to the hospital?
Yeah, so generally at Bridgeport Hospital, we touch base with what's called the EMS triage nurse. She'll check the patient in. You give a handoff report to them, and then they'll assign the patient depending on the acuity of that. In calls like this, we do what's called a radio patch, where you call into the hospital ahead of time and let them know what you're coming in with, and you try to impress on them the seriousness of the situation. So when that happens, a lot of the times you won't stop at EMS triage. You'll bypass them and go directly to the trauma room where the trauma team will be waiting.
And that happened in this case?
It happened in this case, yes.
And once you handed off the patient to the hospital at that point, what if anything, did you do in relation to this case?
At that point, I just removed the stretcher from the trauma room. We go back to the ambulance and we begin to decon so we can get back in service for if there's any additional calls coming in.
Thank you. I have no further questions, Your Honor.
Thank you. Attorney Smith?
Thank you, Your Honor.
You're welcome.
Good morning. How are you?
Good morning, sir. I'm good. How are you?
Good. You talk a little quick, Mr.
I'm
Egan.
sorry. Yeah, I tend to do that.
So I'm going to maybe ask you to just slow down a little bit
I'll
for
do my
us. I just
best.
want to go over things, okay?
Sure.
You used a term right there at the end, which I was unfamiliar with, maybe the jurors are unfamiliar with as well. You said after you took the stretcher out and went back to decog?
Decontaminate.
Decon. Ah,
Yep.
gotcha. Decontaminate. Thank you. All right. So you were telling us, Mr. Egan, that you arrived on scene and it was chaotic, correct?
Yes.
In fact, you said people were screaming, correct?
Mm-hmm.
Yelling obscenities, correct? Mm-hmm. And in fact, yelling obscenities at you and your crew member, Ms.
Yep.
Kaiser, correct?
Yeah, it happens frequently.
You said that the crowd was difficult to part to get to the patients. Mm-hmm. Ultimately, however, you did get to the patients.
We
correct?
did.
And you said one of the patients was standing and able to talk.
I didn't write that in the chart. I believe Sophia might have written a addendum after she went and triaged, but I did not encounter any standing patients.
You didn't encounter any standing patients.
No.
You encountered one person who was laying down on the grass, correct?
Yes.
And then you rendered some aid to the person that you indicated or believed was the most in need of your care. Is that fair to say?
Yeah, he was the first one he came across. So we do a rapid scan, and then after we did the rapid scan, applied that chest seal, my partner moved on to assess the rest of them, and then I began working the doing the AED CPR.
Any indication that these yelling, screaming folks had been drinking?
I did not witness any alcohol, so I can't comment on that.
Did you feel threatened at all?
I didn't feel threatened, no. I didn't feel the obscenities were being yelled like at us in a violent method. It was more like, hurry the blank up, he's blanking dying, things like that.
Okay. And yet they were still difficult to part for you to get to the patient?
Yeah, because it was very chaotic, so people tend to, situations like this, people tend to move in on the patient, so you have to be like, hey, excuse me, move out of the way, give us some room.
You mentioned that you parked up to the right of where that red bush is on the exhibit that you were shown. There were cars parked along the roadway?
I can't remember if there were cars parked like directly in front of the house or where they were, to be honest.
Do you recall whether or not there were cars parked in the driveway?
I do not recall, no.
You were solely focused on trying to get to the patients?
Yes, yep.
And when you got to this patient that you have described to us rendering a lot of aid to, you noticed that there was a puncture wound to the left lower chest, correct?
Yeah, left lower chest or upper abdomen, right in that area.
That was the only wound that you saw on this individual that you were treating?
That's the only one I observed at that time, yes.
And you described that it was rather dark in the area, correct?
Yes, sir.
You said that an officer may have been providing some light to you?
I remember there being a flashlight at one point, but it wasn't consistent the entire time.
You also had a light you described to us that was on your vehicle itself, correct?
The scene lights, yeah.
The scene lights.
Yep.
Those, however, didn't provide a ton of light. Is that fair to say?
No, yeah, it's not adequate by any means to completely light the scene up, no.
Gotcha. And this night was also rainy and misty, was it not?
I don't remember the weather, to be honest with you.
Do you recall whether or not the grass was wet where you were?
I do not.
Do you recall, you said you were the driver, correct?
I was, yep.
Do you recall whether or not you had your wipers on as you were driving to the scene?
I don't recall.
And then you described for us rendering aid. At some point you were joined by Jeff McKee, correct?
Yes.
You handed off to him. Did he stay in the vehicle with you as you drove to Bridgeport Hospital?
Like, did he stay in the ambulance with us?
Yes.
Yeah, he was in the back working on the patient.
So in this vehicle was you, the patient, Ms. Kaiser, and Mr. McKee, correct?
Yes.
And sir, you've been called here today to tell us what you witnessed when you responded to the scene.
Yes.
You've done that to the best of your ability.
Yes, sir.
But if what these jurors are interested in is why Mr. Valle did what he did that night, you can't really be of any help to these jurors.
No, sir.
Thank you. Nothing further.
Thank you.
Thank you. Any redirect?
No, Your Honor, thank you.
Did you say no?
No, Your Honor, thank you.
Thank you. All right, sir, you may step down.
Thank you.
Please watch your step.
Sure.
Thank you. Is the state prepared to call its next witness?
Yes, Your Honor. State will call Jeff McKee to the stand.
Thank you. Good morning. Sir, if you'd please enter the witness box, please watch your step. Please remain standing once you're in the box. Madam Clerk will put you to oath. Thank you.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. Please state your full name, spelling your last name, as well as your business address.
Sure, Jeffrey McKee, MCKEE is last name, and Valley Emergency Medical Services, 764 Derby Avenue in Seymour, Connecticut.
You may be seated.
Thank you.
Thank you. You may proceed.
Thank you, Your Honor. Good morning, Mr. McKee.
Good morning.
Can you please tell ladies and gentlemen of the jury what you do for a living?
So I am a paramedic providing advanced life support. I've been working with Valley Emergency Medical Services for a little over 4 years, and prior to that I was an EMT for about 10 and a combat medic in the Connecticut National Guard.
Did you have to go through any training or education to be a paramedic?
I did. I went through just about 18 months worth of didactic and skills training, as well as clinical at Capital Community College to obtain my paramedic license.
And what's the difference between a paramedic and an EMT?
So an EMT does what's called basic life support, where they can perform CPR, administer oxygen, basic medications, and do very basic assessments of patients.
And what does a paramedic do?
As a paramedic, we're a more advanced level of care where we can initiate IVs, we can intubate, provide advanced airways, and give a bunch of medications that we're trying to give.
And how long have you been a paramedic for?
I've been a paramedic for just over 6 years.
And I want to direct your attention to May 15th of 2022. Were you working that day?
I was,
In what capacity?
as a paramedic.
And did you have an occasion to respond to 43 Laurel Glen on that day?
I did.
Okay, and I want to direct your attention to States 1, where that red mark is right behind you, on that exhibit right behind you. Is that the home, the residence that you responded to on that night?
Yes, it is.
Around what time did you say you arrived to the scene?
I arrived at the scene shortly after midnight.
And what was the information that you had in relation to responding to that scene at that night?
I was dispatched for a possible assault with possibly multiple victims on a priority 1 as the first incoming paramedic from out of town.
And what does priority 1 mean?
So it means lights and sirens.
And why would you put on lights and sirens?
It was reported as a critical call that required a paramedic or advanced life support to respond.
So what time would you say you arrived there?
I believe it was shortly after 20 after midnight, somewhere in that time frame.
And when you got there, I want to direct your attention to States 5. States 5. It's on your screen there. Is this the area that you responded to at 43 Laurel Glen?
Yes, it was.
And when you got there, can you tell the ladies and gentlemen of the jury, if you can, in States 5, where you responded to? What did you do when you got there?
So upon arrival, there was a lot of individuals on scene as well as police and care providers. I was directed to the patient that was on the lawn, sort of where all the trash is to the right of that red bush.
So just so we know we're on the same page, I'm pointing to, for the record, you're on the right side on the grass area where there appears to be medical material in States 5. Is that where you were?
Yes.
Senator.
Thank you, Your Honor. And when you got there, can you tell the ladies and gentlemen of the jury what you observed?
So upon arrival, I observed a chaotic scene with a lot of younger individuals crying, screaming, upset, and I observed the Shelton ambulance on scene with a patient in the grass there performing CPR with a bystander as well as PD officers around, and that's the patient I was directed to. I know there was another paramedic on scene who had triaged, and that's the patient, my most critical patient I was directed to.
So were you aware that there were other patients at the scene?
I was told there was en route to the scene, and there were providers on scene that directed me to the patient that was in the front lawn that you mentioned right there.
Okay, and when you got to that patient, can you tell us what care, if any, you provided to that patient?
Sure. So I got the report from the EMT that was performing CPR on the patient, and he had placed an AED and an oral airway in the patient upon finding out that the patient was pulseless. So I had them continue CPR and connected them to my cardiac monitor via the AED pads that were previously placed. Did a brief pause, checked for a pulse, checked for breathing on the patient, as well as checked the initial heart rhythm, which was asystole. Upon doing that and determining there was no pulse and no breathing, directed CPR to be continued, as well as ventilation with oxygen.
What is asystole?
Asystole is essentially flatline, where there's no cardiac electrical activity originating at the top of the heart or in the heart whatsoever.
When you got to the scene, what did you observe about the patient outside of your assessment of the patient medically? What did you observe about the patient?
The patient was a young male in his teens. The patient appeared to be in good shape, healthy.
Did you observe any wounds on the patient?
I did. Observed a small puncture wound right under the patient's left nipple in the area of the chest with a chest seal that was placed on there prior to my arrival.
Was there any active bleeding at that point?
There was bleeding in and around the site. The chest seal was doing a decent job of controlling that bleeding, and there was direct pressure being held on that upon my arrival.
And when you medically, when you assessed the patient at that point in time, and you said they were in asystole,
Yes.
what steps did you take at that point when you determined that CPR should continue and there was a flat line?
So at that point, I continued my trauma assessment on the patient to determine if there were any other wounds or hemorrhage that needed to be stopped while the EMT partner and the other provider provided quality CPR to the patient. And then if there was any additional bleeding that needed to be rectified before moving the patient.
How long would you say that you were on the scene providing medical care to that patient when you got there?
No more than 15 minutes from the time I made patient contact to getting the patient in the back of the ambulance and starting transport.
Why did you withdraw? Did you determine that the patient needed to be transported to the hospital?
I did.
Okay, and why did you determine that?
I determined that because upon arrival of the first responders, they said the patient still had a pulse, a palpable pulse, and just prior to my arrival that had been lost, so it's technically what's called a witnessed arrest, which a provider witnessed the cardiac arrest, so there's still a chance for us to provide life-saving measures, and that's what I did.
And at some point, you transported the individual to the hospital?
Yes.
Okay. And what did you do between the time you placed them on a backboard, put them in the back of the ambulance and transported them to the hospital? What life-saving measures, can you explain what you did at that point?
So once we got the patient off of where they were found into the back of the ambulance, I noticed that the chest seal was not holding well, so I replaced that to stem the continued bleeding. CPR continued. I attempted to get IV access on the patient. However, his vasculature did not support IV access, which I went to what's called an intraosseous infusion, which is a drill through the tibial tuberosity on the left leg where you can infuse medications, fluid directly into the bone marrow.
So you're in the back of the ambulance?
Yep.
Who's driving?
So one of the EMTs was driving to the hospital.
And you tried to administer medication
Yes.
in the patient's veins?
And through the intraosseous infusion.
Why did you do that? Why did you do an intraosseous? Can you explain that to the jury?
Yes, so I did an intraosseous infusion because the patient did not have veins or vasculature that was apparent to me, either due to hypovolemia, which is lack of fluid or blood, or poor vasculature. So in an emergency situation like that, the next choice is to do an intraosseous infusion in through the bone marrow.
Okay, and how do you do that? Can you just explain that to the jury?
So it is a needle attached to a drill, and you use the drill to drill through the outer layer of bone in the select spot. And once it is through that first layer of bone, you stop and you're able to flush into the bone marrow with fluid or medication.
And why is that? Why are you trained to do it that way?
So we're trained to do that way in the instances that you cannot get an IV and that there's no vasculature available to obtain an IV while still being able to provide care, to provide emergency care.
And when you provide medicine in that manner, how does that get into does it get into the body faster?
It does. So it travels through the bone marrow directly into the heart and then to the.
So I just want to stop and say, Lazy Boys, that's beyond generous. 50 gift memberships to Trial TV Live. That's unbelievably generous of you. Thank you so much for your support. And you just got a lot of people: Suber, Michelle Phillips, Elizabeth Bear, Brass Tax, Joe R, Julie Moran, DM, Rhonda Davis. Wow, just goes on and on and on. So thank you for that. Really, truly appreciate that. I recognize a lot of people on this on that list. So thank you, Lazy Boys. That was really very much appreciated. Thank you.
The rest of the body once it's pumped through the vasculature.
And you did that in this case?
Yes.
And what medication did you provide the patient at this point?
I provided epinephrine, which is our standard advanced cardiac life support drug to try to resuscitate a patient that's in cardiac arrest.
And in this particular instance, after you applied that epinephrine, was it successful in reviving any type of heart rhythm?
It was not.
And can you tell the ladies and gentlemen of the jury what you continued to do on the ride from 43 Laurel Glen to the hospital?
Absolutely. On the transport down, I continued to give epinephrine every 3 to 5 minutes with a total of 4 doses to try to restart the patient's heart. I also continued CPR on the way down, and when the chest seal was no longer effective, applied a pressure dressing, which stemmed the bleeding that was continuing and stopped the bleeding with that. I also intubated the patient to get a definitive airway, which was confirmed on my cardiac monitor and listening to it as well. So ventilation while after being intubated, as well as CPR continued, as well as a normal saline drip to try to put some volume back into the patient.
Now, when you initially got to the scene and you assessed the patient, did the patient have a pulse on the scene when you saw
No.
him?
When I got to the patient, they did not.
And from the time you left 43 Laurel Glen to the time you got to Bridgeport Hospital, did you assess the patient for a pulse during that period of time?
I did. Every 2 minutes I assessed for a pulse. I also assessed for any cardiac rhythm or activity on my cardiac monitor, which the patient remained in asystole throughout the transport at that every 2-minute interval.
And how long would you say, if you can recall, the ride to the hospital was from 43 Laurel Glen to Bridgeport Hospital?
It felt to be between 15 and 20 minutes.
And at some point in time, did you arrive at Bridgeport Hospital?
We did.
And can you explain what happened when you arrived at Bridgeport Hospital?
So when we arrived just prior, I had given a trauma alert patch to the hospital advising them what I had found on scene, what interventions I had done on the way down, and what to expect when we arrived. When I got there, CPR continued into the emergency department. We rolled into the trauma room, and CPR continued throughout that process. I had the attending doctor and the respiratory therapist confirm my intubation and my tube placement, that it was accurate, and I gave a report to the attending physician and nurses that were there, and then the patient was moved over to the hospital bed, and the staff continued their resuscitation process.
And at the time that you handed the patient off to the hospital, at that moment, did you do any final assessment as to any type of pulse or activity with regards to the
I did. Just prior to bringing them into the ED, I did a final pulse, breathing, and cardiac rhythm check. The patient remained in asystole, remained pulseless, and remained not breathing. So we continued CPR from the ambulance in through the ED with the ED staff taking over CPR.
Thank you. I have no further questions, Your Honor.
Thank you. Attorney Smith, any redirect? Any cross?
Thank you.
Thank you.
Good afternoon, Mr. McKee.
Afternoon.
Just want to go over what you've told us here and make sure I got this correct. When you responded to the scene, you encountered a chaotic scene. Is that fair to
Yes.
say? People screaming.
Yes, crying, yes.
And did you have any trouble getting to the patient?
I did not.
Okay. Path was cleared for you at that point?
Yes.
You were directed to this patient by other responders that were already on the scene?
Yes.
You told us that you did an initial trauma assessment, correct?
Yes.
That included trying to find whether or not there were any other wounds, correct?
Correct.
You didn't find any other wounds, did you?
I did not.
You also looked for other bleeding, correct?
Yes.
Didn't find any other bleeding, correct? You looked for other trauma, is that fair to say?
Yes.
And you didn't discover any other trauma?
No.
Just what you've noted as being a small wound, one small puncture wound to his chest under the nipple, I believe, correct?
Correct.
Did you see any signs of alcohol or drinking when you got to the scene?
I did not notice.
Do you recall the conditions that evening? Was it rainy, misty?
It was misty. The roads were damp.
The grass itself, do you recall whether or not the grass was wet?
It was damp.
That caused you to slip or anything while you were setting up?
No.
And then you described for us the level of support that you gave to the patient, correct?
Yes.
And that, I believe you told us, at some point you determined that he needed transport, correct?
Correct.
And you determined he needed transport because it was what you described as a witnessed arrest, correct?
Correct.
Meaning that the people who had responded to the scene had gotten some indication of a pulse, correct?
Yes.
And some heart activity, correct?
Yes.
And however, by the time you arrived, there was this witnessed arrest, which meant that there was still a chance to provide life-saving measures, correct?
Yes.
And that's why you determined it was time to take this patient, transport him to Bridgeport Hospital, correct?
That is why. Yeah.
Which you did, and then you transferred care once you were there over to the attending physicians, correct?
I did.
And so, Mr. McKee, you've been brought here today, fair to say, to tell us what you witnessed and observed when you arrived on the scene?
Correct.
But if this jury was interested in knowing why Mr. Valle did what he did that night, you wouldn't be able to help them at all, would you?
I would not.
Thank you.
Does the state have any redirect?
No, Your Honor, thank you.
All right, thank you. Sir, you may answer the witness box.
Thank
You're
you.
all set. Thank you. Sir.
All right, so we heard from, and I said I wasn't going to recap, but I do want to talk a little bit about it. So we heard from Lonnie Blackwell, Michael Egan, and then Jeff McKee. So all first responders, right? Lonnie was the officer, and then we had the two paramedics. EMT at the time was Michael, and then the paramedic. Just kind of talking about what they saw, what condition everybody was in, the chaos, and Mr. Smith, keeps asking about, was it misting, was it raining? And we heard in his closing, he addressed that, which of course he would, because virtually, I think the EMT, Jeff McKee was like the only one that said yes, it was raining or it was misting, because nobody either remembers it or says no, it wasn't. And yet in his closing statement, Mr. Smith was like, you can see it on the video, you can see the rain, and it's funny because he shows the video to a lot of these participants, and they're like, yeah, no, I don't remember, and yet you can clearly see it. It was raining. It wasn't misting. It was actually raining. So I think he was trying to pull. I'm trying to remember back to his closing that was that why Raul slipped? Yeah, I don't think he really. I think he was just kind of trying to pull that into it was slippery, but that really doesn't hold much water because Raul had a knife. So what if he's slipping around? So I don't know. You know what? Maybe he was doing it to show the inconsistencies. Like they're looking at the evidence, and then they're saying, no, I don't remember, or I don't recall. Remember how many people said I don't recall? It was just amazing how many witnesses says I don't recall. All right, next up is the chief medical examiner, and I just wanted to say, okay, we had 1,200 votes. What would your verdict be for count one, which is the one for Jimmy? So 43% of you said intentional manslaughter. 31% of you said not guilty, self-defense. 24% of you said intent, murder one intent to cause. That's interesting. That's really interesting. I thought self-defense would have been the third one, but 43% of you thought it was intentional manslaughter, which if we go back, because of widespread panic in Ken, two of our fantastic mods, Ken led widespread to this, and widespread put this together over the weekend or Friday, I think. So let's see. First degree, reckless. First degree is intentional. So that's a Class B felony, 20-year prison sentence, up to $15,000 fine. So if right now, just for Jimmy, he'd be looking at up to 20 years. All right, I want to do, while we listen to the medical examiner, I want to do, the next one up is Ryan Heinz. So let me pull that together. So let's listen to the medical examiner, and I'll pull Ryan. Ryan and Tommy had the same. They were first degree assaults, and they were first degree, and Faison was second degree because of the life-threatening injuries. All right, so count two, assault, first degree intentional, Ryan Heinz. All right, let's get that poll going. Get this poll going. And so what would you, count two, what would you pick? I could say, what would you say? What would your verdict be? What would your verdict be? Count two, assault, first degree, intentional, Ryan Heinz. So is this going to be guilty? I guess just straight up guilty. Guilty. We'll go with not guilty. And then I think there's a lesser. Pretty sure there was a lesser. Hold on, let me check it out. So they had to prove intent to cause serious physical injury, more than a minor. So guilty when intent to cause serious physical injury does cause serious physical injury. So that's what this next poll is going to be about. And he had to use a dangerous instrument. So the summary is intent to cause serious physical injury, did cause it, and then it was caused by a dangerous weapon. Now, there is a lesser one. So the lesser one is second degree intentional. Second degree intentional. Wait, no. Hold on. That's what we're looking at right now. The second degree intentional. Okay, then the next, not guilty, the next would be second degree reckless. All right, so this one is reckless, which brings up 1 to 10 years. All right, so this is second degree reckless. So guilty, up to 20 years. I can even put that there, up to 20 years. Not guilty, obviously, no time. No time served. And then second degree would be 1 to 10 years. 1 to 10 years. All right, so guilty would be up to 10 years. This is assault. All right, so let's do this. All right, new poll for you guys. New poll for you. All right. All right, let's get back to the medical examiner. I will also say replay of day 1. Replay of day 1. Up. Replay of day 1, and this is the medical examiner. So we're going to hear, unfortunately, about
The evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
I do.
State your full name, spelling your last name, as well as your business address for the record.
James Gill, Gill, 11 Shuttle Road, Farmington, Connecticut.
You may be seated. Thank you.
Thank you, Your Honor.
Good afternoon, Dr. Gill. How are you today?
I'm well, thank you.
Good. Dr. Gill, where do you currently work?
I work at the Office of the Chief Medical Examiner in Farmington.
And for how long have you been with the Office of the Chief Medical Examiner?
Since July of 2013.
And what is your current position with that office?
I'm the Chief Medical Examiner for the state of Connecticut.
And how long have you been in that position?
Since July of 2013.
Please tell members of the jury what your educational background is, as well as the experience that qualifies you to have the position that you hold.
I received a degree in biology from MIT, followed by my medical school at the University of Connecticut. I did an internship in medicine in Vermont, followed by my pathology training at Yale. I did a fellowship in cancer pathology at Memorial Sloan Kettering, and then a fellowship in forensic pathology at the New York City Medical Examiner's Office. I'm board certified in anatomic and forensic pathology and licensed to practice medicine in Connecticut and New York.
And what are your duties as the Chief Medical Examiner?
I have administrative duties as well as investigative duties. So I am kind of the commissioner of the agency, but I also do medical legal death investigations. So that includes performing autopsies and certifying deaths.
And please explain generally what the term pathology entails.
So pathology is that area of medicine that deals with the laboratory aspects of the body. So things that can go wrong with the body. And typical pathologists usually work in the hospital, and they'll examine different tissue samples from the operating room and so forth to determine if there's cancer or what have you.
And is there a difference between pathology and forensic pathology? And if there is, what is that difference?
Yes, so forensic pathology is a subspecialty of pathology that requires additional training, and it's that specialty that deals with the investigation of sudden, suspicious, or unnatural deaths. So deaths that are related to trauma, injuries, intoxications, things like that.
And up to date, if you can approximate how many post-mortem examinations you have conducted.
I've performed over 4,000 autopsies and many thousands more of examinations of bodies.
Do you primarily oversee the autopsies of other members of your office, or do you conduct them independently?
I do both. Yesterday I did 2 autopsies yesterday, but I also oversee the office.
In your career, have you conducted or overseen autopsies or examinations where the cause of death was a stab wound?
Yes.
And can you approximate how many times?
Many dozens of times, both homicidal as well as suicidal self-inflicted injuries.
And prior to today, have you testified in court on the field of forensic pathology?
Yes.
Prior to you coming to court today, did you have an opportunity to review any records from your office to prepare for your testimony?
Yes.
And did you review the postmortem report that was prepared for this case?
Yes, I did.
And did you review any additional reports that may have been part of that postmortem report?
Yes.
And which reports would that be?
Those would include the toxicology report and some other laboratory and investigative reports.
Do you have the opportunity to review any photographs with relation to this case?
Yes.
And are photographs always taken during forensic examinations or withdrawn postmortem examinations?
It's a routine part of a forensic postmortem examination.
And what's the reason for that?
It's to document findings as well as sometimes the absence of findings, so other people can look at it and evaluate it as well.
Now, did you personally perform the autopsy on the body of James Thomas McGrath?
No, I did not.
And to your knowledge, who performed the autopsy?
It was Dr. Jones.
And to your knowledge, what position did Dr. Jones hold with the Office of the Chief Medical Examiner?
She was I believe, an assistant medical examiner. She was in her training year as a forensic pathology fellow.
And were you present and overseeing Dr. Jones when she performed that postmortem examination?
Yes, I was.
And why the oversight?
Because she's still in training, and so we supervise them, kind of work side by side with them so they can learn forensic pathology.
And to your knowledge, is Dr. Jones still employed by your office?
No, she's not.
And do you recall what date Dr. Jones performed that postmortem examination?
I'd want to look at the report just to refresh my memory, but it was May 15th, 2022.
And to your knowledge, where was that examination conducted?
At the office in Farmington.
And how do you know that?
I was there, and there's a record in the autopsy report describing the location and the time and the place.
May I approach the clerk, Your Honor?
Certainly.
Well, withdraw. May I approach the Attorney Smith?
Yes, you may.
No objection, Your Honor.
All right, thank you.
Parker's ID, please, Your Honor. May I approach the witness?
Yes, you may. What number is this?
I'm sorry.
It's okay.
States 10 for ID purposes.
Thank you.
Dr. Gill, I'm showing you what's been marked as states 10 for ID purposes only at this point. Do you recognize this document?
Yes.
Okay. And to your knowledge, who prepared this particular document?
Dr. Jones prepared the autopsy report, and the toxicology report was prepared by the laboratory, and she also prepared the lab request form.
And was this report primarily the report from the Office of the Chief Medical Examiner prepared in the regular course of business of that office to prepare such a report?
Yes.
And is it in the regular course of business for your office to prepare such reports on a daily basis?
Yes.
And was that report made at or near the time that that postmortem report was withdrawn? Was that report made at or near the time the autopsy on James Thomas McGrath was performed?
Yes.
I would just ask for 3 minutes as a full exhibit, Your Honor.
Attorney Smith?
No objection, Your Honor.
All right, court will accept into evidence as a full exhibit, states 10. Thank you.
Dr. Gill, I'm going to be asking you some questions based on States 10, approaching the witness, Your Honor, you may read from this report now that it is a full exhibit. Dr. Gill, who was also present at the postmortem examination in addition to you and Dr. Jones?
Dr. Vincent, one of our medical examiners.
And in addition to members of your office being present, do you recall if anyone else was present during that postmortem examination?
I don't recall anyone else being present.
Is it typical for members of the police department to come in and view the autopsy?
Usually, yes. It depends upon the type of death and the case and so forth, but it's not unusual for police or investigators to attend the autopsy.
If someone from the Shelton Police Department were present, would that be noted in that report?
It may or may not. Some doctors don't always include the police who are present or not.
Prior to the post-mortem examination done on James Thomas McGrath arriving, prior to the examination being done on James McGrath, did you or any of your coworkers have any knowledge of what the extent of the injuries were?
Yes.
And where did you get that information from?
The death was called into our office from the hospital, and so we get preliminary information from the hospital.
And looking at State's Exhibit number 10, how old was James Thomas McGrath at his time of death?
He was 17 years of age.
And to your knowledge, do you know where James Thomas McGrath was pronounced dead?
I have to look at the death certificate or Bridgeport Hospital.
And to your knowledge, were any operations or procedures conducted on James McGrath prior to his arrival at the medical examiner's office?
Yes.
And how do you know this?
From the autopsy report.
And how was the body of James Thomas McGrath transported or brought to the office of the chief medical examiner's office?
We have a transport team that will pick up remains at the hospital and bring them to our office.
Typically, and in this case as well, do you recall how the body was brought in? What condition?
The body was brought with resuscitative equipment still with the body in a body bag.
And was there an ME case number assigned to this examination?
Yes.
And referring to exhibit number 10, can you recall or can you tell the members of the jury what that ME case number is?
Yes. It's 22-10921.
And what is the significance of that ME case number?
So 22 is the year, and then we give each death that's reported to our office a unique sequential number. So it's a unique number for Mr. McGrath.
Can you please tell the ladies and gentlemen of the jury generally what goes on in a post-mortem examination, if you could give details as to what is conducted?
It depends a little bit on the type of death, but generally in a case like this, we would do x-rays of the body, and then we would do what's called the external examination, where we look at the outside of the body, looking for identifying features, color of the eyes, length of hair, any evidence of injury or medical treatment. And we would take photographs, and then we would do the internal examination, where we make a Y-shaped incision and examine the internal organs to determine largely why the person died.
I'm going to direct your attention to States 10, where it says external examination. What is the purpose of that section?
So that, again, is to document the different physical characteristics of the body, color of the eyes, scars, tattoos, things like that.
And where it says under postmortem changes, what does that paragraph indicate? This is page 2 of 5.
So that's where we would describe any changes that we see from occurring after death, like rigor mortis, stiffening of the body temperature, lividity, the settling of the blood, change in color of the body after death.
And as indicated before, you said that there was some medical intervention that was done. In looking at States 10, can you please explain what was done or what was present on the body of James Thomas McGrath?
He was received with a breathing tube in his airway, as well as 2 catheters, intravenous type catheters actually in the bone on both lower legs.
And is that what is referred to as therapeutic interventions on States 10?
Correct.
Again, referring to States 10, under where it says injuries, external and internal, what evidence of injury was present on the body?
So there was evidence of both sharp injury and blunt injury. So sharp injuries are injuries that are caused by sharp objects like a knife, a piece of glass, and you can either have a injury or a cut injury. The difference is that stab wounds are deeper into the body than they are long on the skin, while like a cut or an incised wound is longer on the skin than it is deep in the body. Blunt injuries are different types of injuries. Those are injuries caused by blunt force, where a person may fall down and bruise their knee or what have you. We call those contusions. So he had some bruises as well on different parts of his body that were just very superficial.
So in addition to those superficial bruising you had indicated, was there also a stab wound found on the body of James Thomas McGrath?
Yes.
And where was that stab wound located?
The stab wound was on the left chest below the left nipple.
Can you either read or explain the directions within the exhibit? It indicates the directions are stated with reference to the standard anatomical planes with the body measured in the horizontal position. What does that refer to?
So we don't know what position the person was in when they were stabbed. So we always give the directions in the anatomical position, which means standing straight up with your arms at your side. So we all have the same planes of reference. So for example, in this instance, the stab wound was going from the front of his body towards the back of his body, and it was going, from the left of his body towards the right of his body, and then slightly upward in his body.
Referring again to States 10, under injuries, external and internal, the last sentence of that paragraph indicates the injuries were labeled A through C for description purposes only. What is the purpose of that? Explain to the jury.
So there were bruises and there was a stab wound. There's no way for us to tell the sequence, which came first, which came second.
Directing your attention to page 2 and to page 3 of State's Exhibit number 10, under where it says A, stab wound of torso, can you please read what that paragraph says out loud to the jury?
So a stab wound is centered 21 7/8 of an inch from the top of the head and 5 1/4 inches left of the anterior midline. It's oriented obliquely, which means kind of at an angle, with a sharp edge angled to the upper left and a blunt edge directed down and to the right. It is 1 1/16 of an inch long, slit-like perforation on the surface of the skin without natural skin tension. After penetrating the skin and the muscle, the knife proceeded through the left 6 to 7 intercostal space, that's between the ribs, and perforated the pericardial sac and the left ventricle of the heart. There was approximately 750 milliliters of clotted blood in the pericardial sac around the heart, and approximately 1.8 liters of liquid and clotted blood in the left pleural cavity, which is the left chest cavity. And then the direction of the penetration is front to back, left to right, and slightly upward. In the estimated depth, that's how deep the stab wound was, the estimated depth of this penetration is approximately 2.5 to 3.5 inches deep.
Now, in reference to States 10, that paragraph you just read, what does it mean? What is that intercostal space notation? What is that?
So that's a term for between the ribs. So it went in the muscle part between the two ribs.
And what would be there? Is it tissue? Is it?
It's muscular and soft tissue.
And again, you indicated the pericardial sac and left ventricle. What does that refer to?
So the pericardial sac is the sac that the heart is enclosed in, and the left ventricle is the left side of the heart, the pumping chamber of the heart that pumps the blood to the rest of the body. So it's going to pump out through the aorta to the rest of the body. And there was a stab wound. The stab wound went through the wall of that left ventricle of the heart.
That next paragraph, there's approximately 75 milliliters of clotted blood in the pericardial sac. Is that normal to have that? What caused that, if you can explain that?
Yeah, there shouldn't be any blood in the pericardial sac. So that was blood from that stab wound, from the blood first going into the pericardial sac and then continuing into the left chest cavity.
Or it indicates that the direction of the penetration is from front to back, left to right, and slightly upward. How are you able to tell that?
So we do a dissection during the autopsy where we kind of go in layer by layer and we follow the track, the path of the knife, and we can then see the direction that it followed.
I'm going to direct your attention back to States 10, where it says, again, page 3 of 5, under where it says B, blunt impact injuries of torso, where it indicates that there was a 3/4 greenish-brown contusion of the inframammary right chest. What does that indicate?
That means that there was a bruise on the right chest below the right nipple, and it seemed to have some age to it. It didn't look that fresh.
And how do you know about the age? How would we be able to tell the age?
Because of the green-brown color change.
And also, States 10 again, page 3 of 5, where it says C, blunt impact injury of extremities. It references some injuries there, indicating a brown contusion, green-brownish contusions, and red-purple contusions. What does that indicate, that paragraph?
So there are scattered bruises. Some of them, they're of different ages. Some of them are more recent, and some appear older.
What is the purpose of documenting such injuries?
It's just part of a routine part of an autopsy to document all the injuries. You never know when a particular injury may be important for an investigation.
So you had indicated earlier that in addition to an external examination, there was also an internal examination done on the body of James Thomas McGrath. Is that accurate?
Yes.
And what parts of the body were subject to that internal examination?
All of the internal organs of the chest and the abdomen, as well as the head. So the brain, the heart, the lungs, liver, kidneys, all of those were examined.
And what is the purpose of doing an internal examination to all of those various parts of the body if it's, I don't want to say pretty obvious, but if it looks to you where that injury might be, why do everything else?
It's just being thorough and looking for other maybe natural disease that could have contributed to death. We also want to collect various tissue samples for further testing. And so it's again, part of a kind of a routine autopsy to do that examination.
Directing your attention again to States 10, page 3 of 5, where it says cardiovascular system. What does that paragraph mean in layman's terms?
So that's describing the heart, the valves, the blood vessels, and he had other than the stab wound, he had a normal heart. He was a normal, healthy person.
So would it be safe to say that in that section, there would not be any indication regarding the injuries done to the heart?
Correct. We include the injuries in a separate section. So the internal exam is really just the kind of the natural, normal descriptions.
May I approach counsel, Your Honor?
So I'm just going to pause it real quick there. Yeah, so Jimmy was the last one to get stabbed, right? So Raul and Tyler go up onto the lawn. He says people surrounded the both of them. They kind of split them off. And then Tyler and the Tylers were facing off. And Tyler said he saw Raul flinch because Ryan was in his face. Remember, Ryan was saying, "Why are you wearing that shirt like that? Why are you wearing that shirt like that?" Remember, he said he had his shirt up over his head. And Ryan said he flicked the shirt with his finger. He's like, "Get that off of your face. Get that off of your head. Get that off of your head." So he said that they said Raul flinched. So Tyler hit Raul. Sucker punched him. They all admit that. And then that's when Ryan jumped on Raul and he punched him. And so Raul started stabbing Ryan. He got him in the side and he perforated his lung. So he was first. And then Tommy comes over, separates those two, and he's now getting stabbed. He gets stabbed in the leg because Raul's on the ground. He's getting stabbed in the leg. Then Faison is there somehow, and he gets stabbed in the arm. And then Raul goes back to the car, sees Tyler getting stomped on, goes back into the fight, which Jimmy is the first one because he said there was like this horseshoe, right? There's like this horseshoe, and Jimmy was the closest, and so he got stabbed. He got stabbed last. So that's kind of how it. Or that's the order that I was able to piece together. Yeah, so July, for those that were asking and talking, so Stearns is supposed to start the 22nd. He was supposed to start the 15th with jury selection, but we figure it's going to take at least 2 days, if not 3. But the judge wants to start that the 25th, so that's Friday. Kohlberger's sentencing is the 23rd, 24th, which is Wednesday and Thursday. And then Lori's sentencing is the 25th, which is Friday. So Friday is going to be a huge, huge day for us. Oh, and then there's Carlos Dominguez may have a new trial the 23rd, 24th. They're scheduled to meet and figure out if there's going to be a new trial. So the end of July is going to be that week of July is just going to be crazy. We have to figure out what exactly we're going to do. Elizabeth, Tyler was on the street when Leo left the car. Yes, it was so quick. It was so quick. Yeah, he had the knife. He stabbed the 3 kids. He escaped, or he got away, or got pushed, or whatever you want to say. He goes back to the car, and he turns around, and that's when he sees Tyler getting stomped on and kicked and beat. So as Tyler's being thrown to the curb or thrown to the street, saying, "Get out of here! Get out of here!" You know, it's like simultaneous. It is what it is. It's not like Tyler was there for like a minute or 2 and then Raul rushes back in. It's literally as he's being thrown to the street and he turns around, Raul comes back in and stabs Jimmy. So to me, it was like, bang, bang, bang. It didn't happen. How can I put this? It happened faster and like in real time. It happened like he sees Tyler getting stomped on, and then he starts to go back in, and then that's when Tyler's thrown to the street. So it kind of happens simultaneously almost. Lito walked right past Tyler on his way to stab Jimmy. Yeah, Elizabeth, Tyler was already at the street, so yeah, I guess technically he did walk past him. Yeah, he did technically walk past him. Baca, Lito missed the boat that day. He left the shack. Yes. All right. I want to get through the medical examiner, and then then we can go to Ryan, because after that, then we can go to Griffin, because it's Sergeant Bango, detective at the time. So then we'll go to Griffin. That's going to be day 2. We'll go to Griffin's testimony. Then we'll start to hear, because I want to hear his testimony again, because he's the one that told the kids. He told the St. Joe's kids to pull up. He's the one that was in the group chat saying, pull up, basically, here's the address, that kind of thing. So, all right, medical examiner. Oh, and don't forget, take the poll if you guys haven't taken our poll already. What would your verdict be for count 2, which is assault on Ryan? So count 2, assault on Ryan.
Yes, thank you.
Let's mark this photographs for identification purposes. 20 for ID purposes only at this point. Do you recognize those photographs?
Yes.
And what do you recognize these photographs to be?
These are the autopsy photographs from Mr. McGrath.
Do the photographs that you see here fairly and accurately depict the body that came into your office on the day that the postmortem examination was done?
Yes.
And in the photographs that were depicted, does anything look different to you than the body of James McGrath did on the day of the autopsy?
No.
And again, the purpose of taking these photographs?
To document the findings, who he is, and any injuries.
Do you recall who took these photographs?
We have professional photographers who do that under our direction.
I'd like to enter these as full exhibit, Your Honor.
Attorney Smith?
No objection, Your Honor.
All right, court will accept into evidence State's Exhibits 11 through 20 as full.
Dr. Gill, for the next several questions, I'm going to be showing you what's been marked as State's Exhibits 11 through 20 as full exhibits. Can you see that, Dr. Gill, where you are?
Yes.
Also in front of you. Dr. Gill, what does this photograph depict?
This is a full-body photograph of Mr. McGrath showing how we received him at the medical examiner's office.
And that placard that's placed above the body, what does that number refer to?
That's his unique case number.
And from looking at States, I believe this is States 11, do you see anything in this photograph that would depict any kind of, as you indicated earlier, the therapeutic services that was done on Mr. McGrath at the hospital?
Yes.
Can you just identify those areas to the members of the jury?
You can see the breathing tube coming out of his mouth. In his lower legs, there are these two are called intraosseous catheters in both legs, and then there's some gauze pad over the left chest.
I'm referring to States 11, the lower left-hand area of the exhibit. There is a tag which is on the body of James McGrath's toe. What does that tag indicate?
That's how it's the identification toe tag.
Showing you what's been marked as States 12. Dr. Gill, what is this a photograph of?
This is a face shot of Mr. McGrath.
I just have one moment, Your Honor.
Certainly.
And that placard that again is depicted there, is that the same number that we saw in States 11? The number matches up the ME number?
Correct.
Showing you States 13. What is this a photograph of?
So this is the face and upper torso of Mr. McGrath, and it shows the stab wound under that left nipple. You can see that red line is the stab wound.
And let the record reflect, Your Honor, that the witness is pointing to the right-hand side of States 13, where he's indicating there is a red line below the left nipple of the body.
So noted. Thank you.
And Dr. Gill, if you can look at States 13, there is some reddish purplish bruising, it appears, around the neck area of the body of James Thomas McGrath. What is that?
That's called livor mortis. That's a change that occurs after death from blood settling in those areas.
Showing you what's been marked as safe 14. What is this a photograph of?
This is a close-up photograph of the stab wound.
And again, that's the placard, the ME placard number that matches up.
Yes.
Showing you what's been marked as safe 15. What is this a photograph of?
So this is also a photograph of the stab wound showing the skin, which is less relaxed. So the skin has a natural elasticity to it, and depending upon how the sharp injury is in the skin, sometimes it can cause the wound to gape open. In that first picture, we saw that gaping wound. This is kind of pushing the skin back together, relieving that natural skin tension, so you can get a better look at the actual stab wound.
Showing you states 16. Dr. Gill, what is that a photograph of?
So this is after the skin of the chest has been reflected to the side, and we're looking at the chest wall, and just above the label there's some bleeding there. That's where the knife went through that intercostal space.
Showing you state 17. Is this a close-up photograph of state 16?
Correct.
And can you also see in that photograph the puncture wound?
Yeah, there looks like there's some disrupted muscle there. It's difficult to make out.
Now, this placard that is utilized here, it looks like there's some measuring tool in there as well. Do you utilize that to measure the puncture wound or the injury?
Yes, that's always kind of on our label. Yeah.
Showing you states 18. What is that a photograph of?
This is showing the heart while it's still in the body, and that kind of oval red lesion. That's the stab wound of the heart, of the left ventricle of the heart.
So is that the heart taken out of that muscle or tissue that we saw in stage 17?
So the pericardial sac has been opened, and we're looking at the heart inside the sac now.
Showing you stage 19. What is that a photograph of?
This is let's see, showing the pericardial sac before it's been opened up. So you can see a little bit of lung, pink lung at the top there, and then that hole kind of right in the center. That's where the knife went through the pericardial sac.
And lastly, showing you stage 20. Again, what is that a photograph of?
So this is a photograph of just the heart, and you can see kind of below the yellow, the fatty tissue, there's this darker red area. That's the actual stab wound that went into the left ventricle of the heart.
What is the purpose of taking this photograph with the heart removed from the body?
Just to further document the injury.
May I just have one moment, Your Honor? Dr. Gill, based on your training and experience in the field of forensic pathology, with respect to the stab wound to the torso, perforating the heart, what effect would you expect such an injury to have on a person's ability to survive?
Well, it would not be immediately incapacitating. The person would still remain conscious for a period of time until they've lost enough blood and the heart can no longer maintain the blood pressure. Then they would lose consciousness. And again, if the heart and the circulation isn't restarted, they would die.
Were any samples or specimens collected during the post-mortem examination and submitted for laboratory analysis?
Yes.
And do you recall what specimens were collected?
There were several specimens collected for toxicology, including blood, vitreous fluid from the eye. We usually collect liver as well, and urine.
And what tests were conducted on the blood of the body that was collected?
So we did our kind of routine toxicology testing, which includes alcohol and all the common drugs of misuse, as well as other medications and so forth.
I'm going to direct your attention back to States 10 on page 5 of the toxicology report, withdrawn. Page 5, what does it read under the heading toxicology?
So it gives the positive findings that were detected in the blood and the vitreous fluid from the eye.
Okay. Directing your attention to page 2 out of 3 of the toxicology report. Do you recall or can you read what the blood alcohol content or BAC of the body of said James Thomas McGrath was?
Yes.
And what was that?
It was 0.2 gram percent or gram per 100 milliliters.
Referring again to States 10, to the very first page of that exhibit where it says final diagnosis. Please read what it says.
Stab wound of torso with perforation of heart, hemothorax, approximately 1.8 liters. That's blood in the chest cavity. And then hemopericardium, that's blood in the pericardial sac, approximately 75 milliliters. And then superficial blunt impact injuries of the trunk and the extremities, the bruises.
Based upon your review of the postmortem examination of James Thomas McGrath, what was the cause of death in this case, Dr. Gill?
The stab wound of the torso.
And what was the manner of death?
Homicide.
And if you could please explain your reasoning to the jury as to why it was a homicide.
Homicide for a medical examiner is death at the hand of another person. So this stab wound was caused by another person, so it's a homicide.
I just have one moment, Your Honor.
Yes.
I have no further questions for Dr. Gill.
Thank you. Attorney Smith?
Thank you, Your Honor.
Thank you.
Good afternoon, Dr. Gill.
Good afternoon.
You told us that you have been at the Office of the Chief Medical Examiner since July of 2013?
Correct.
And did you take over from Dr. Carver?
Yes.
And you've been there since for the past 12 years?
Yes.
Any break in that time period? You've served continuously?
Correct.
All right. And you've told us that in conducting your autopsy, you discovered a 1 1/16 inch long slit-like perforation in the chest, correct?
Yes.
And you've described that both in your testimony and in the report as being the result of a knife, correct?
Yes.
And was that based on information that you had from other people involved with this investigation?
I think it's probably a combination. The features, the anatomical features, are what we see with a knife injury, and I believe we had history that he had been stabbed.
And so did you come to that conclusion that it was a knife based on your own observations or based on something you had been told?
Again, I think it was a combination. The features are kind of classic findings for a knife. I really couldn't think of much else that would cause it.
No other sort of sharp object like a piece of glass or something of that nature?
A piece of glass wouldn't cause such a straight injury with a single blunt angle and a sharpened angle, and to that depth, I think it'd be very unlikely that a piece of glass would do that.
Any other tool, perhaps, a screwdriver or something like that?
A screwdriver gives a different type of pattern, a more circular puncture type injury.
Fair to say you didn't have anything definitive at that point that led you to know that this was a knife, but that's what you concluded based on what you've described here to us?
Yeah, the anatomic findings are supportive, very supportive of a knife. Yeah.
And you also had information, I guess, from the police officers that were involved, or where did the mention of a knife come from?
Probably from the hospital that he presented with a stab wound.
And you described that this stab wound went through the left 6 to 7 intercostal space, correct?
Yes.
And you described that as being the space between the ribs?
Correct.
And as you went through and gave us a list of your findings, you described also an injury under Section B, which was an old bruise. Is that fair to say?
Yes.
And then under Section C, a number of other scattered bruises of indeterminate age. Is that also fair to say?
Correct.
Now, as part of your report, you said that the wound itself was an estimated 2.5 to 3.5 inches deep, correct?
Yes.
And why is that an estimated number?
Because the heart and the body can move. And so if a person's leaning forward or laying back, there can be some movement of the heart. And so we can't give an exact, precise depth. Plus, if it goes into the heart cavity, we don't know how deeply it went into the cavity. It didn't go through the heart, through the whole heart, but it went through the wall. So we give an estimate. That's typical.
So based on a position, the person's body position when the wound is suffered, fair to say the stab wound could have been 2.5 inches deep, could have been 3.5 inches deep.
It's within that range, correct?
You didn't note any other fractures, correct?
Correct.
You didn't note any other puncture wounds, correct?
Correct.
So this single stab wound that you've described to us, in your opinion, was both the only wound and the wound that led to his death?
It is the only fatal injury, yes.
Other than what you've described as being old, unrelated bruises of indeterminate nature, is that fair to say?
The bruising, yeah, that played no role in his death.
You also told us that you had ordered what was your standard specimen testing for toxicology reports, correct?
Yes.
And that included a toxicology for alcohol, correct?
Correct.
And did you tell us that the blood alcohol of the deceased was a 0.2?
Correct.
Did that have any bearing on your findings in this case?
It played no physiologic role in his death. He would have died from this stab injury whether or not he had alcohol in his system.
And Dr. Gill, you've been called here today to tell us what you witnessed and observed as it relates to this autopsy, correct?
Yes.
And you've done that to the best of your ability?
Yes.
But if this jury is interested in knowing why Mr. Valle did what he did that night, you can't tell us anything that would help them, can you?
No.
Thank you. Nothing further.
Thank you. Attorney Messina?
Just a couple questions.
Okay.
Dr. Gill, you had indicated on direct examination that you and your team determined that the fatal injury caused the body of James McGrath was a stab wound, correct?
Yes.
Okay. And I know you had indicated earlier, but approximately how many postmortem examinations have you conducted or overseen where the cause was a stab wound in your career?
Your Honor, I believe this is outside the scope of my cross-examination.
Okay, so you did question the witness regarding other causes, so I'll allow it. Overruled.
Many dozens, but some of those involve, for example, in one person, maybe 80 stab wounds. So yeah, I've seen hundreds and probably thousands of stab wounds.
In those cases where you've determined it to be a knife, have those injuries been very similarly situated to what you saw on the body of James McGrath?
Yes.
And you had indicated on cross-examination regarding the difference between a knife perforation versus, let's say, a glass perforation. What would be the difference there?
A glass, because it's more irregular shaped, you get an irregular pattern and maybe more jagged. Usually it's not going to have that depth. This was a very smooth edged, straight edged, straight in wound. So that was caused by something that's sharp, long, narrow, and that's a knife.
You had testified on cross-examination that you were able to determine the positioning or how that knife went into the body of James McGrath. Would you be able to determine the position of James McGrath at the time the stabbing took place, based on the injuries?
No.
Okay. I have no further questions, Your Honor.
Thank you.
Thank you.
Any additional cross?
No, Your Honor.
All right, thank you. All right, you may step down. Thank you. Please watch your step as you exit out. If you don't mind, I'll take that exhibit. Thank you, sir.
Okay, so 2 fights. First fight was at Lazy Brook. That involved Griffin and Ryan, and we're going to hear from Griffin next. I'm going to cue up Griffin. He was day 2. Now we just said Sergeant Bango, but that's okay. I don't need to hear from him. So 2 fights. First one was at Lazy Brook. That's where Griffin and Ryan showed up at the lacrosse at the Leafers. They were having a lacrosse party for the daughter, and her team. They showed up. Raul, Jack, and Tyler were already there. They're the ones that stopped Ryan and Griffin at the door in the garage and said, "Give me your beer." Ryan gave them over. His story is he gave them a couple beers. Jack said that's not enough, and he took the beer. So then Jack and Ryan went to have a fight. That's where Raul had the helmet on, and he was wearing the neck pillow. Now some say that he took the helmet off and hit Ryan. I personally didn't see that in the video. I just saw him. There was another witness that said he headbutted Ryan. I can see that. I see him headbutting. I don't see him taking the helmet off, but that's just my eye. So one witness said he headbutted. Another witness said he took off the helmet and swung and hit Ryan. So that was fight number 1 at Lazy Brook. Then that party gets dispersed. Then they go to Trumbull High School, and that's when the jawing starts, and that's when they start yapping at each other via the group chat. That's when Griffin says, and we're going to hear from Griffin. That's when Griffin says, "Pull up," sends him the address to Tyler Rich's house, which is Laurel Glen, and then they go there, and that's when they're surrounded by the car, and it's beaten and jumped on and pounded on and smashed windows, blah blah blah. They leave that. That's when they leave, and that's where Jack gives, or somehow Jack has a knife, and somehow Raul gets it. Depending on who you listen to, either Raul's this crazed maniac begging for it, or Jack just throws it at him and gets it. Either way, Raul gets a knife from Jack. They drive back with Tyler, Jack, and Raul drive back to Tyler Rich's house on Laurel Glen. He does not have a helmet at that point. He does not have a neck pillow. He does have a knife. And that's when they get out. Tyler and Raul get out. Tyler Rich comes to confront them. Ryan is squared up against Raul. He says Raul has a shirt over his head, and then he's like flicking at the shirt. So he's putting hands on Raul. He's flicking at the shirt, saying, "Take that shirt off. You look stupid." And then Tyler Rich sucker punches Raul. Then they get into the fight, and that's when Raul starts stabbing people. So he did not have a helmet at the second fight. His injuries look pretty light. Granted, they were 72 hours later, but he should have still had injuries. If he had gotten stomped on and kicked, and he would have still had black eyes and stuff. So there is that. His injuries were, unfortunately, I don't know if that's the right word, but his injuries were not did not match what he said. All right, let me find Griffin. I want to go to Griffin's testimony because he's the one that said pull up. Griffin is the one that said pull up. I mean, I could go to ours, I guess. I'm going to go back to this. All right, hold on. If you haven't taken our poll yet, please do so. Kidding me? So this is Griffin. Here's Super Bowl snoring.
Good morning.
Good morning.
How are you?
I'm good. How are you?
Good.
All right. So this is Griffin. He was at the first party. He's the one with Ryan. They had the beer, and he's going to describe his side of it. Nick says, helmet and neck pillow. I think it's fair to say he was acting like a child all night, regardless of this tragedy. Yeah. I mean, he's only 16. He's 16. He's drinking. Yeah. I mean, he's not He's certainly not. They were all, yeah, of course. He's being a goof. He's trying to be, and he said he's just trying to. He just did something silly, something goofy. Old Pueblo Hops. Ryan's head wound supports headbutt. LOL Bird. We already know there was a fight there and they left mad. Fairfield 16, but thinks he is old enough to drink. Janet True. There was also testimony from the girl that took the video that he headbutted. Yes, that's coming up. That's Emily. There's Isabella. So we're going to hear from Griffin, then Isabella, and then Emily, and then Tanner. So I think it's Emily that says she's the one that said the headbutt. And then there was the selfie. There was a picture of Griffin and Ryan in the back of the truck with the girls that took them after the fight broke up. All right, so let's check out his testimony.
Griffin, can you tell the ladies and gentlemen of the jury how old you are at this moment?
I'm 19.
And do you work?
I do.
What do you do for a living?
I do sales at Iron Solar Pros.
At Iron what?
Ion Solar Pros.
Okay. Just keep your voice up, okay? You're soft-spoken. And how long have you been working where you work?
About 7 months.
7 months. And are you nervous?
Yes.
And prior to today's testimony, have you and I met?
Yes.
And why did we meet?
Because of this instance.
Now I want to direct your attention to May 14th of 2022, okay? How old were you back then?
I was 16.
And were you in school?
I was.
Where were you in school?
I was a sophomore at Shelton High School.
And did you play any sports?
I played football and lacrosse.
Now, I want to direct your attention to around 6 p.m. on May 14th of 2022. Can you tell the ladies and gentlemen of the jury what you were doing around that time?
I was getting ready and headed over to one of my friend's houses.
And what friend's house were you going to?
My friend Natalia.
And did you go there with anybody?
I went with my buddy Ryan Hines.
And how do you know Ryan Hines?
He moved to Shelton in 8th grade, and we played football together ever since then.
And when you got to Natalia's house, did you stay long?
Decently, not terribly. We were there for a few hours.
A few hours. And when you got to Natalia's house, what kind of things were you doing there?
There was a small group of us. We were just hanging out. Had a drink or two. It was really just kind of sitting around, hanging out.
And when you said you had a drink or two, what kind of things were you drinking?
Beers.
Beers. And you said you had two beers?
Yeah.
Okay. And at some point in time, did you come to leave Natalia's house at some point in time?
Yeah.
And why did you leave Natalia's house?
So me and Hines were a little bit bored, and we had known that our buddy Austin Leifer was throwing a party, and I'd grown up with him, so I gave him a text, and I was like, hey, do you mind if me and Hines came? He told us, yeah, feel free, come on over. So we had basically my cousin Tanner pick us up, and he dropped us off there.
Now you say Austin Leifer. How do you know Austin Leifer?
I've known him since we were young, 4th grade. We played sports together, went to school together.
And they were having a party at their house?
Yeah.
And where does Austin live, if you can recall?
I don't know the number, maybe 5, Lazy Brook Road.
Lazy Brook Road?
Yeah.
And so at some point, your cousin Tanner, Tanner who?
Chernowski.
Okay, and is he your blood relative?
No, we've just known each other since we were born.
Okay. And at some point, Tanner comes and picks you and who else up?
Ryan.
Okay, just the two of you?
Yeah.
And when he picks you up, where does he take you?
To Austin's house.
Okay. And when you get to Austin's house, around what time of night was it?
I'm not sure, maybe around 10.
Okay. And when you got to Austin's house, who got out of the car?
Me and Hines.
Okay. And did Tanner get out of the car?
No, he left.
So Tanner just dropped you off and left?
Yeah.
Okay. And when you got out of the car, tell the ladies and gentlemen of the jury what happened during that sequence of events.
Me and Hines step out of the car, begin walking up the driveway.
Let me stop you there. Did you bring anything with you to Lazy Brook?
Hines had a 12-rack of beer.
12-pack of beer? What kind of beer was it?
I believe Bud Light.
Okay. And when you got out of the car, you and Hines, tell us what you and Hines did after that.
We began to go in. We entered the garage, and then we were encountered by 3 St. Joe's kids asking us basically who we were, which we expected. Like, what are we doing here, this and that. We told them Austin had invited us.
Sustained. I'm going to strike what Mr. Hines said or what the other person stated. So if you took a note on it, please discard it, strike it from your notes. It's not to be considered for evidence in this case, okay?
So without telling us what they said, did you have a conversation with these 3 individuals?
Yes.
And do you know who these 3 individuals were?
At that given time, they were just 3 SJ kids to me.
Do you know who they are now?
Yes.
And who are they?
Tyler De Silva, Jack Snyder, and Raul Valle.
Okay. And is Raul Valle in court today?
Yes, he is.
And what is he wearing?
Black suit.
And can you point him out for the ladies and gentlemen of the jury? Your Honor, may the record reflect that the witness identified the defendant in this case?
Court will let the record reflect the witness identified the defendant. You may proceed.
And does the defendant have a nickname?
Yes, Lido.
What is his nickname?
Lido.
Lido? So when you and Hines got to the St. Joe's party, the defendant and his 2 friends confronted you?
Yeah.
And Hines?
Yes.
And without telling us what anybody said, what was that confrontation like?
Between 2 dudes who never see each other, they were in a place where they were comfortable with, not knowing that was a place we were also comfortable with. So they were a little, who are you guys? What's going on? Blah, blah, blah. Kind of hostile, not really, but it escalates when one of them grabs Heinz's beer out of his hand. We move outside.
Well, let me stop you there. Before you move outside, does the defendant say anything to you or Hines when you're confronted by him and Tyler and Jack?
I don't remember specifically.
Okay. And at some point in time, someone takes Heinz's beer?
Yes.
Who takes Heinz's beer?
Jack Snyder.
And when that happens, what's the reaction that, if anything, that Hines has at that moment?
He's pissed off that someone just grabbed his beer out of his hand. So we move outside afterwards. The 2 of them conclude that they'd fight for the beer back.
Okay. And the 2 of them that you're referring to?
Hines and Jack Snyder.
Okay. And at some point in time, did they confront each other as if they were going to fight?
Yes.
Were you present and witnessed that happening? And when that happened, what, if anything, can you tell us about where, withdrawn? Based on your recollection, do you know if Tyler De Silva was present at that moment?
Yes.
And where was he standing at that moment?
So Hines and Snyder are looking at each other. De Silva's to Snyder's left.
So if you're Hines and I'm
De Silva's right there.
So he's over to Jack's left.
Yes.
Okay. Was the defendant present when this was happening?
Yes.
And when do you recall where he was standing before when Jack and
he was right here to Hines.
Behind him, to his right?
Like peripheral. Okay.
Now, what do you recall about what happened next when you were witnessing this?
They both put their hands up. They're about to begin fighting, and the first punch was thrown, but by Lido from the back, and it hit Hines in this back side of the head, and then Hines instantly takes Snyder to the ground.
So if you're Jack and I'm Ryan, the defendant is here, and he punches Ryan in the face from behind?
Yes.
Okay. Tell us, when that happens, what occurs next?
Hines instantly takes him to the ground, and this is like a 30-second thing that from start to finish. And once he gets to the ground, a girl they all knew was like trying to break it up. Lido had a motorcycle helmet on. He had taken it off and struck Hines with it once or twice, hit him in the head.
Now, when the fight starts after the defendant punches Ryan from behind, does anybody else jump in the fight?
Once they get to the ground, Lito hits him with the helmet. So yeah, I guess that's jumping into the fight.
Did Tyler jump into the fight?
The way they fell, I only saw like his upper body. I didn't see any fists, so maybe he kicked, but I'm not here to say this.
So
or
at
no.
some point in time, Jack and Ryan are engaged in a fight, and what do you witness the defendant do?
Hit him with the motorcycle helmet.
So he comes over and hits him with the helmet. How does he hit him with the helmet?
Takes it off and strikes him down on it twice, I believe.
Okay. Do you recall what Tyler DeSilva was wearing that night?
A powder blue jersey. It was open, like a white shirt on, I think jeans.
And do you recall what the defendant was wearing that night?
Also a powder blue shirt with black, I think, sweatpants.
And do you recall what Jack Snyder was wearing that night?
A red hoodie and black sweatpants.
Approach the witness, Your Honor.
Yes.
Showing you what's been marked as State's Exhibit 53 for identification purposes. Do you recognize 53?
Yes.
And what is 53?
A picture of Jack Snyder and the defendant.
And is this, did you take this picture?
No.
Now, is this how you remember what the defendant was wearing on the night in question?
Yes.
And is this picture accurately reflect what Jack was wearing that night?
Yes.
Your Honor, unless there's an objection, I would offer it at this moment. No objection, Your Honor.
All right, court will accept into evidence States 53.
Showing you States 53 again, now for the jury's benefit. Is that the defendant to the right there?
Yes.
And that's Jack Snyder to the left?
Yes.
And is that the motorcycle helmet that the defendant has on that you saw the defendant use during the fight with Ryan Hines?
I believe so, yes.
Now, you indicated that after the fight, it lasted about 30 seconds?
Maybe 40.
Okay. When the fight eventually ended, what, if anything, did you and or Ryan do next?
The mom comes out, Lifer's mom comes out running or yelling. Like, obviously, there's a fight in her driveway. Kind of just get up, gather his things, tries to find some of his beers they had spilt. I think he grabbed a couple of them. We headed down the driveway. We met a group of girls who had just witnessed that as well. And we had offered or asked them to bring us back to our friend's house, and they said yes. They brought us back to our friend Natalia's house. And then
when you went back to Natalia's house, let me ask you this. Between the time you were at 5 Lazy Brook to the time you went back to Natalia's house, were you drinking any alcohol?
No.
When you got back to Natalia's house, how long would you say you were at Natalia's house for when the girls dropped you off?
Maybe around like 10, 15 minutes.
And when you were at Natalia's house, were you drinking alcohol at that point?
No.
Did you observe Ryan Hines drinking alcohol at that point?
No.
Now, at some point in time between leaving Lazy Brook Road and getting to Natalia's house, was there any communication between you or anybody else over any type of messaging?
Not at that point, no.
Okay. Can you tell the ladies and gentlemen of the jury what, if anything, occurred between the time you left Natalia's house? Well, withdrawn. At some point in time, you were there for how long?
About 15 minutes.
15 minutes, and at some point you left?
Yes.
Why did you leave Natalia's house?
Close friend of mine, Charlie Connery, had given me a call, had heard about what happens with Hines, and he said he was coming to grab us.
Without telling us what he said.
Sustained.
Okay, you can't tell us what he said. Did Charlie Connery call you?
Yes.
Did you have a conversation with Charlie Connery?
Yes.
And did you tell him what you observed at 5 Lazy Brook Road?
Yes.
Okay. And at some point in time, did somebody pick you up at Natalia's house?
Yes.
And who picked you up?
Charlie.
And when he picked you up, where did you go?
To Tyler Rich's house.
Okay. Now, between the time you left Natalia's house, the time you got to Tyler Rich's house, were there any communications between, we'll call it, you and your Shelton friends and the St. Joe's kids?
Yeah, some had begun.
Okay. Can you please describe to the ladies and gentlemen of the jury what that was without telling us what people said?
We were in a basketball group chat.
What does that mean, basketball group chat?
It means that prior to this incident, it was an existing group chat. There was 2 other St. Joe's kids in it that we hung out with, and we would go play basketball, pickup games, kid stuff. And once this had happened, a few people were added into the group chat, and then it became very argumentative, going back and forth because of the fight. And it was just boys talking crap to each other, beefing.
And were you in that group chat?
Yes.
And did you engage anybody in that group chat?
Yeah.
Okay. And what kind of things were you saying in that group chat?
We were talking crap back and forth. At one point, it was said within the group chat on their behalf
Well,
of.
we can't tell us what they said, unless you know something that the defendant said. We just need to know the tone of it.
It was hostile, argumentative. We were both going back and forth. We were hot. Our boy had been jumped by 3 kids, so we were acting out of emotions, being like boys, just like talking shit back and forth.
Okay. I'm going to show you what's been marked as State's Exhibit 5. It's a full exhibit. Do you recognize State's 5?
Yes.
And what is State's 5?
The Rich's house.
That's Tyler Rich's house?
Yes.
How do you know Tyler Rich?
From the same town. We've always just kind of been around each other since we were younger.
You grew up with him?
Yeah.
And
Yes.
what time of night would you say you got to Tyler Rich's house?
Probably around 11.
11-ish? Okay. Was it dark out? What was the lighting like?
Well, the sun was down, yeah, so it was nighttime, but the moon was out. It wasn't terribly dark. We were able to see outside.
Okay. Was it pitch black?
No.
And when you got to Tyler Rich's house, was this group chat, this basketball group chat between the Shelton kids and St. Joe's kids, did that continue when you were at Tyler Rich's house?
Yes.
Was everybody that was withdrawn? How many people would you say were at Tyler Rich's house when you and Ryan got to Tyler Rich's house?
Probably around 30, 40.
30, 40 kids? Okay. May I approach, Your Honor?
Yes.
Showing you what's been marked as State's Exhibit 54 for identification purposes. You recognize 54?
I do.
And what is State's 54?
A picture of Faison Teal.
And how do you know Faison Teal?
I played football with him in high school.
And does this picture accurately reflect what Faison Teal looked like on or about 5/14 of 2022?
Yes.
Showing you State's Exhibit 55 for identification purposes. Do you recognize State's 55?
Yes.
And how do you recognize State's 55?
It's Tommy Connery. It's Charlie's older brother. I've known their family for some time.
And how do you know? You've known him for some time?
Yeah.
And are you friends with Tommy or Charlie more? How does that?
I was friends with Charlie because he's a year older than me, so that made me be friends with Tommy as well.
And does this State's 55 accurately reflect what Tommy looked like on or around May 14th of 2022?
Yes.
Showing you State's Exhibit 56. You recognize 56?
Yes.
And what is State's 56?
Photo of Ryan Hines.
And how do you know Ryan Hines?
Once he moved to Shelton, we were kind of just boys from sports.
What kind of sports?
Football.
And does this picture accurately reflect what Ryan Hines looked like on May 15th of 2022?
Yes.
And finally, I'm going to show you State's 57. You recognize State's 57?
I do.
And how do you recognize State's 57?
It's a picture of my friend Jimmy McGrath.
And how do you know Jimmy McGrath?
Note reads, we are hopelessly deadlocked, 11-1 on the charge of murder at count 1. signed by James Stolman, jury foreperson, 12:47 p.m. My intention is to bring the jury in, give them a brief instruction to continue deliberating, and then send them back out to continue their deliberations. Counsel, do either of you wish to be heard?
Jury's already saying they're deadlocked.
No, Your Honor.
So I would ask to mark this. Thank you. And then I would ask for our jury to be brought in. Welcome back, ladies and gentlemen of the jury. Counsel, please stipulate that all 12 members of our jury are present.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
Thank you. All right, ladies and gentlemen, I did receive a note from you regarding count 1 and the fact that you are deadlocked on count 1. That has been marked as Court Exhibit 7. Look, I recognize that most of you, if not all of you, have never been through this process before. There are numerous exhibits and many days of evidence to consider. I did instruct you to consider all the evidence. By the court's estimate, at the time that we received the note, which was 12:47 p.m., you had been deliberating for just about 2 hours or less. Please remember, each of the 4 counts must be deliberated upon separately. If you would like to deliberate on counts 2, 3, and 4, and then return to count 1, that is fine. At this point, I simply suggest that you continue with your deliberations. You should review the evidence and the position of each juror to determine if any evidence has been overlooked or any juror's position misunderstood with respect to either the evidence or the law. Please continue to discuss and consider the opinions of other jurors. Kindly explain your views and listen to the views of others. Majority, please listen to what the minority has to say. Minority, please listen to what the majority has to say. Ultimately, you will make up your own mind and decide this case based on your own individual judgment and conscience. But at this time, please return to the jury room to continue on with your deliberations. Thank you.
I'll rewind that because I want to see that again too. We'll rewind it. I'll rewind it again since we have time.
Any comments related to the court's charge to the jury?
Nothing from the state, Your Honor.
Not from the defense.
All right, court stands in recess.
All right, let's go to recess.
All right, I'm going to rewind that because they're hung on count 1, but let's rewind that. That came in really fast. Let's rewind that. Let's check this out again.
Counsel, before the jury comes in, I just want to let everyone know that the court did receive a note from the jury. I'm going to mark that note as a court exhibit. The note reads, "We are hopelessly deadlocked, 11-1 on the charge of murder at count 1. Signed by James Stolman, jury foreperson, 12:47 p.m. My intention is to bring the jury in, give them a brief instruction to continue deliberating, and then send them back out to continue their deliberations. Counsel, do either of you wish to be heard on the note?
No, Your Honor.
No, Your Honor.
So I would ask my clerk to mark this. Thank you. And then I would ask for our jury to be brought in. Counsel, please. All right. Welcome back, ladies and gentlemen of the jury. Counsel, please stipulate that all 12 members of our jury are present.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
Thank you. All right, ladies and gentlemen, I did receive a note from you regarding count 1 and the fact that you are deadlocked on count 1. That has been marked as Court Exhibit 7. Look, I recognize that most of you, if not all of you, have never been through this process before. There are numerous exhibits and many days of evidence to consider. I did instruct you to consider all the evidence. By the court's estimate, at the time that we received the note, which was 12:47 p.m., you had been deliberating for just about 2 hours or less. Please remember, each of the 4 counts must be deliberated upon separately. If you would like to deliberate on counts 2, 3, and 4, and then return to count 1, that is fine. At this point, I simply suggest that you continue with your deliberations. You should review the evidence and the position of each juror to determine if any evidence has been overlooked or any juror's position misunderstood with respect to either the evidence or the law. Please continue to discuss and consider the opinions of other jurors. Kindly explain your views and listen to the views of others. Majority, please listen to what the minority has to say. Minority, please listen to what the majority has to say. Ultimately, you will make up your own mind and decide this case based on your own individual judgment and conscience. But at this time, please return to the jury room to continue on with your deliberations. Thank you.
So she said 11-1. I totally missed that. So she said they were 11-1. When did she say that? And they got the note at.
Any comments related to the court's charge to the jury?
Nothing from the state, Your Honor.
Not from the defense.
All right, court stands in recess.
All rise, go to recess.
All right. So when did she say 12-1? I'm sorry, 11-1. She said 11-1. Oh man, I totally missed that. All right. So she said 12:47. Yeah, they got the note at 12:47, but here it is. It was 2:17 when they came in. So that means they 12:47, 1:47. That's like an hour and a half they sat on it. Right? That's weird. They got the note at 12:47, but it's now 2:17 that they decided. That's pretty weird. And it's just count 1. So that's Jimmy. Jimmy is count 1. So they haven't even gotten to count 2 and 3, which is Ryan, and then Charlie, and then count 4 is Faison. So, yeah, they probably went to lunch. Yeah, lunch is usually from 1 to 2. So they got the note, they took lunch, and then I guess they came back, right? Count 1 is Jimmy's count. So they still have to get through. Well, here, let's read this. They have to get through murder in first degree, right? And then there's the lesser included, manslaughter, and then reckless manslaughter. So if they can't even get past that. So then count two is Ryan, count 3 is Charlie, and then count 4 is Faison. So she's telling them go back and at least hash out hash out counts 2 and 3 and 4. At least you guys can do that. Try that at least. That's so funny. 2 hours and they're like, we're hopelessly deadlocked. They started at 11. Whereas Carlos Dominguez, they didn't once said that they were deadlocked until the very, very end. It's just funny how different juries act differently. All right, so they started at 11. I'm not gonna count that. I'm just gonna say let's just keep going. They just, they're still deliberating. I'm just gonna say, yep, they started at 11. I guess they had a lunch. I guess we can. I will add question. There was a question at 2:17. There was a question. Question at 2:17. Well, not really a question, but they're 2:17. All right, so they're back at it. What do you guys think of that? Goldo, if guilty on count 1, what's the minimum? 60? Is it 60? 25 to 60. 25 to 60 is 25 to 60 year prison sentence. So that's for Jimmy's. For Jimmy, that's what he's looking at. Green Eyed Cat, it was in the note. What was in the note? I'm sorry. Refresh my memory. I got what was in the note? What was in the note? Oh, the 11 to 1 was in the note. Count 1 is Jimmy's. Count 1 is Jimmy's deletion. That's Jimmy's deletion. It's murder 1, and then the lesser included is manslaughter, reckless manslaughter. So the count 1 is Jimmy's is Jimmy. Count 2 is Ryan. Count 3 is Charlie. Count 4 is Faison. Not include lunch breaks, so less than 2 hours. Yeah. Julia, the poor kid should not get more than 10 years and be out in 5. Aloha from Hawaii. Oraya's journey. Awesome. So the note was that they were deadlocked on count 1, 11 to 1. Okay. All right. Thank you for that. Thank you. I know you guys are all saying that. So let me just deadlocked on count 1, 11 to 1. And yeah, she said the 4-person's name. I'm not going to say it here. Yeah, Irish Amy is on vacation. Gimme Clout. They're struggling with the first count. They can't even get past the first count. So the juror note gave the split. Okay, gotcha. Okay, thank you, Green Eyed Cat. Thank you, guys. All right, remember, we're going to be respectful of each other, guys. Even though you have a difference of opinion, we're going to be respectful of each other. So please do not attack each other, even if you disagree with somebody. We don't need to bludgeon over each other's heads how we feel. State your opinion, and then let's move on. We know this is emotionally charged, but we're not going to beat each other up and try to make somebody feel bad or think something else. You have your opinion, I have mine. Let's just leave it at that. Sinbad, 11 to 1. The one holdout must be hungry. Do they have to decide accounts in order? No, they do not. As far as I know, they do not. You are welcome, Nomad. Baca, wasn't first-degree manslaughter a lesser on count 1? Yes. Yes, it was. I'll read through it again. For those that are questioning and concerning and have questions, just listen up. All right, everybody listen up. Heads up, heads up, heads up. This is what count 1 consists of. All right, so listen up. Count 1, intent to cause the passing did stab James McGrath. Person is guilty when intent to cause the passing of said person. So, count one is murder. Count one is murder. Then, if you found him not guilty of that, you go to manslaughter first degree, which is intentional. All right? Murder and then manslaughter first degree. And that's all for Jimmy. That's all for Jimmy. Then then the next count is Ryan. That's count 2. And Charlie's count 3. They both are the same, which is assault first degree intentional. All right. And then Faison is count 4. And he's second degree because his injury was not life threatening. Ryan and Tommy. Ryan and Tommy's were life threatening. All right. Jana, so was it ever told whose hand was on McGrath's back right before he was stabbed? We don't know. We do not know. We do not. Payday fool, that's what we heard here too. Something about 11 to 1. That's what the note said. I missed it, but apparently people heard it. I missed it, sadly. Kerrville, yeah, the jury note read by the judge said 11 to 1, but not which direction. I'm so sorry that I missed it. So she read the note. All right, let's go back to that note. I got to hear this because I missed it. All right, I'm going to play this again, you guys.
The court exhibit. The note reads, we are hopelessly deadlocked, 11-1 on the charge of murder at count 1. Signed by...
So there it was. We're hopelessly deadlocked, count 1, murder, 11 to 1. So there she said it. So the note, and it was signed by the foreperson. So the note said, I know you guys were saying that, but I had to hear it. I had to hear it for myself. So the note said, we are hopelessly deadlocked, 11 to 1 on count 1. Hopelessly deadlocked. Hopelessly deadlocked. Hopelessly deadlocked. So one person is saying, one person, all you need is one person, right? We do not know, Madeline. We do not know. We don't know. We don't know. Oh, here, I should hit play just in case they come back. We don't know which way, we don't know which way they're leaning. Green-eyed cat, I predicted 3 to 4 days of deliberation. I have to say I'm shocked they are not being more thorough with the evidence and just being emotional. Psychosaurus Rex, hopelessly, haha, but dramatic. And I'm here for it. Sinbad, silly question. So if manslaughter, wouldn't there be 2 boxes, one for M, one for manslaughter? There should be. Yeah, there should be. There should be. No verdict yet. No verdict yet, Kathy. They're hopelessly deadlocked. Well, Raya, you're on Kauai. Did I say that right? I'm terrible with Hawaiian names. I'm so sorry. Dana, not guilty. A shame she sends them back to try and convince that one person to cave. Just wrong. What I see online, accurate or not, is that count 1 has murder first, intentional first, reckless. Both have the same time range. Reckless usually gets less. Green-eyed cat said, no way to know which way the majority is voting. Yeah, I can't speculate. Baka, I seriously question the intellect of some jurors in some cases. Come on now, we can't go there. Neil, I just returned. How can they be hopelessly deadlocked at this very early stage? That's going to be a question. That is definitely a question. They literally started at 11 and at 12:47. So not even 2 hours. Not even 2 hours. From 11 to 12 is 1 hour, and then 12 to 12:47 they got the note. So less than 2 hours. Ed says, I'm shocked that 2-day instruction marathon didn't make the charges clear. Psychosaurus, so they're hung on M. Are they not considering lessers? Why not just NG, not guilty? And we don't know, right? We don't know. Aaron is working on another client. Right. My 2 cents. Hold on. My 2 cents. What's the next trial you will be covering? Stefan Stearns starts Stefan Stearns starts, jury selection starts the 22nd. Was supposed to start the 15th, but they've kicked it to the 22nd. Holberger's sentencing is the 23rd, 24th. Lori Daybell's sentencing is the 25th. And Carlos Dominguez might have a new trial. So our next big trial is going to be Stefan Stearns. Depending on what happens here, we got to find another trial to watch before Stearns kicks in. So we may pick up on I don't know, we'll find something. We always find something we like. Don't worry. The next big one though is Stearns for us, and then of course Donna. We're going to be definitely doing that. Let's see. Anyone else hearing the static? Oh, hold on. That might be the feed. Let me turn that down. All right, 13th juror. That could have been from the feed. I turned it down. Let me know if that's any better. Maz says usually means one difficult juror. Every time they say hopelessly deadlocked, the song Hopelessly Devoted to You starts playing in your head, Kathy says. Elizabeth says one person has dug in and made it clear nothing will change it. Shanna, maybe it's the intent on the charges that are deadlocked. They're deadlocked on the intent. Maybe it's the intent. Texas says sounds like 11 want to give him guilty on charge 1, and 1 is saying they don't agree and won't budge. Tomorrow is Jose Morales sentencing. Lazy Boy says. No static there. I turned down the feed, so if it was the feed, I turned it down. It went away just now. Okay, thanks, Paul. Yeah, I had the court feed on. I had the volume up. It could have been that. 13th juror, yes, that was the problem. Okay, cool. Payday Fool. Does anyone know why the one juror got replaced halfway through? Which trial are you talking about? Karina Cooper. Karina is on day 3. Yes, that was the one we were going to check out. Karina Cooper. We may check that one out. Especially if this ends like today. If this ends today or tomorrow, we're going to have to scramble. So yeah, we could do Karina Cooper. She's the one who she shot her husband or something like that. We might pick up on that one. Shanna, yes, meant the intent. Vice, any questions from the jury? Yes. Well, not a question, but they said they were hopelessly deadlocked. That's it. They deliberated for about an hour and 47 minutes. They came back with their hopelessly deadlocked on count 1, 11-1. And Judge Murphy said, go back and deliberate on counts 2 through 4. And yes, Bach, if they had their lunch, right, they only deliberated from like 11 to 12. Wait. 11. Usually lunch is from 1 to 2. So they deliberated from 11 until 12:47. Then they broke for lunch. Angela, was the knife, it was never recovered. Shouldn't be too hard to look in an area where it was supposedly through it. They looked and they looked and they looked and they could not find it. They said they did not find it. Caleb says, if you had to guess, how long will this take? I thought I was going with at least 6 to 8 hours because I know how divided we were. I was going for at least, and that's just for today. I thought this was going to be a 2 or 3 day deliberation, to be quite honest. I don't expect them to come back with a verdict today. My guess would be 2 to 3 days. But I don't know. Madeline, what is the letter charge under count 1? What is the letter charge? What is the letter charge? Not quite sure I understand that. The letter charge. Count 1 is Jimmy's. I'm not sure I understand the letter charge. Volume is low. My volume is low. All right. How's my volume, you guys? I've got myself cranked. I can turn myself up. You know what? I think I do need to turn myself up higher. Hold on. Let me turn myself up. All right. Let's try that. How's that? Is that any better? Oh, yeah. I can definitely turn myself up more. Hold on. All right. How's that? I turned myself up. Is that any better? I cranked up my gain. Hopefully that's a little bit better. Volume's good now? Okay. We'll give it, there's like a 15-second delay, so let me know in 15 seconds. Let me know starting from now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Drunky! How are you? Can hear you all the way in California. Cool. All right, so the volume's better. Okay, I turned it up a little bit. Okay, better now. Okay, cool. Sound is good. Okay. Yep, I turned it up a little bit. Richard in the kitchen. Yes, it's better. Paul Young, thumbs up. Okay, cool, guys. Thank you. All right, awesome. So, all right, Aussie, thank you so much. Congrats on 10,000. Finally worked out how to use the stickers. Yay! Cool. Awesome. Thank you, Aussie. Appreciate that. Thank you for your $5 Australian. Thank you. Thank you. Loads better? Okay, cool. Thanks, guys. Doing meh, but happy to see you all. Oh, drunky. Why are you meh? John Smith, it's smart that there's one person holding out, not easily influenced. It's very easy to give up. Yeah. Well, let's hope that person has reasons, right? Has reasons. As long as you have reasons, right? As long as you have reasons. Volume is good now? Okay, cool. Thank you. All right, let's get back to... All right, we were listening to Griffin's testimony. Davida, I have to go, but we'll check back later. $5 Australian. I don't know. What's it called? Is it just Australian? What is Australian money called? Currency. What is Australian currency? It's just Australian dollars. Okay. Loud and clear. Cool, cool. It's the dollar. All right. Thank you, Aussie. Missy says, all right, I'll be hanging out and chat, but I may go take a cat nap on your lunch break. Paul says, we don't actually know there is a single holdout, do we? That's what the note said. The note said we are hopelessly deadlocked 11-1. Aussie dollar is Australian dollar. Vice, yes, volume is usually loud and clear. It's much better now. Okay, cool. Yeah, I had it down. I turned it back up. When did the judge say 11-1, Yulia? When she read it. We heard it. She said, hopelessly, the note said, hopelessly, we are deadlocked on count 1, 11-1. So she said it. They wrote it in the note. So, yeah, I didn't follow that case. I wish that was like available to stream. I would love to stream that, Drunky, about the Australian mushroom lady. I think that would be really interesting. but I don't think it's not streamed. Kerviel says jury note received at 12:47, read by judge. We are hopelessly deadlocked, 11-1 on the charge of murder on count 1. Thank you, Kerviel. Neil says, if someone has made it clear that they're not going to change their mind, that person needs to be spoken to and reminded of the importance of keeping an open mind. Caleb says, any chance it's 11-1 not guilty? We don't know. That's the thing. We just don't know. Richard in the kitchen, one tried and true fact. I'm a retired police officer, and you just never know what a jury will do despite a mountain of evidence of guilt. That is true. I agree with that, Richard, and thank you for letting us know. Brat says, I agree. The mushroom case was quite fascinating. I know from what I read, what I could see, I definitely want to see more. Psychosaurus Rex says, jurors are also told to stick to their personal convictions and not be swayed if they do not agree. Vice, no, not stream. This trial is crazy. Yeah, I wish they did. I wish they did. All right, do you guys want to get back to Griffin? Should we get back to Griffin's testimony? Nicholas, there was a note from the jury at... it came in at 2:17, but they wrote it at 12:47, or it was given to the court, but they read it at 2:17, which is now half hour ago. They are hopelessly deadlocked on count 1, 11-1. So count 1 is the one with Jimmy. That's the stabbing and deletion of Jimmy. The judge sent them back to deliberate like a minute later. She did say that you can continue to deliberate on counts 2 through 4. So. Ken says, the best odds of winning even the most perfect case, and I genuinely believe this is 95%. Wow. After hearing Griffin again, I think Jack started it all. Yep, no problem, Nicholas. Ken says, you could put virtue itself on trial and 1 in 20 juries would convict. All right, let's get back to Griffin's testimony. It's 3 o'clock, almost 3 o'clock on the East Coast. They end at like 4:30, so they probably are only going to deliberate maybe for another hour. Let's see, 3 to 4, maybe an hour and a half. So let's watch Griffin's testimony. Let me pull this down again. Pull this back here. Oops. All right. That back on. Oh, I guess I don't need that now. All right. Okay, so this is Griffin's testimony. This is from day 2. Griffin's testimony from day 2. Oh, and we took another poll. I stopped the poll. What would your verdict be for count 2? Okay, so count 1 for Jimmy, we had 43% of you said manslaughter, which was intentional. 31% of you said not guilty on both, self-defense. 24% of you said murder 1 was intent. That was the intent to cause the deletion. 24% of you thought that. Then on our second poll, and I'll put up another one for count 3, which is the same for Tommy. So Ryan and Tommy are the same. So what would your verdict be on count 2 for Ryan? Second degree, 43% said second degree reckless. Guilty was 40%. 16% said not guilty. All right, so let's. So remember, Ryan was the one that Raul had his shirt up over his head, and Ryan was the one that flicked the shirt off. Tommy is the one that came in and tried to break it up. So that's Tommy. Let's take that poll. All right, this is for Tommy. Tommy Connery. So what would your verdict be for count 2, assault? So they're pretty much the same, although 2 different people. So guilty up to 20 years. Next one would be second degree reckless. And that is 1 to 10 years. And then the third one would be not guilty, no time served. Okay. No time served. All right. What would your verdict be for count 2, assault, first degree intentional, Tommy Connery? Now remember, Tommy was trying to break up the fight. So Raul's already on the ground. He's already stabbed Ryan. Tommy gets in there. He's trying to break them up. And then Raul starts stabbing Tommy. He's trying to break up the fight. Okay. Now say new poll for you guys. All right. I'm going to go ahead and play Griffin while you guys contemplate the new poll.
When I first switched over to public schools in 3rd grade, I met him on the bus.
And does this picture accurately reflect Jimmy McGrath on May 14th of 2022?
Yeah.
What he appeared like on May 14th of 2022?
Yeah.
Your Honor, without objection, I would offer these as full exhibits.
All right. Without objection, court will go ahead and take into evidence states 54, 55, 56, and 57, I believe.
I may have a moment. I'm sorry.
It's okay.
After I call
Madam Clerk, those went through 57, correct? Yes. Thank you.
Showing you states 54, now publishing that to the jury. States 54 is again,
Faison Teal.
and was Faison present at 43 Laurel Glen, Tyler Rich's house on the night of May 14th of 2022?
Yes.
Showing you 55. What's 55 a picture of again?
A picture of Tommy Connery.
And was Tommy Connery present at Tyler Rich's house on May 14th of 2022?
Yes, he was.
Showing you 56. What is 56 again? Picture of who?
Ryan Hines.
It was Ryan Hines. Is that the same Ryan Hines you mentioned that was with you at Lazy Brook earlier in the night and went with you to Tyler Rich's house?
Yes.
And finally, 57. Can you tell the ladies and gentlemen of the jury who 57 is?
Jimmy McGrath.
It was Jimmy McGrath at 43 Laurel Glen, Tyler Rich's house when you went there that night?
Yes.
I'm going to show you states 12. Do you recognize states 12?
Yes.
And how do you recognize states 12?
It's Jimmy McGrath.
Now, are you familiar with an Enrico Fiola or Ricky Fiola?
Yes.
How are you familiar with him?
Played sports with him. I've known him since probably 6th grade.
And was he present at 43 Laurel Glen on the night of May 14th of 2022?
Yes.
Are you familiar with Sal Perry?
Yes.
And how are you familiar with Sal Perry?
Our families are friends.
And was he present at 43 Laurel Glen on the night of May 14th of 2022?
Yes.
Are you familiar with Mike Samperi?
Yes.
And how are you familiar with Mike Samperi?
I grew up with him as well.
And was he present at Tyler Rich's house on May 14th of 2022?
Yes.
Are you familiar with an Alex Bernstein?
Yes.
How are you familiar with Alex Bernstein?
He's Tanner's friend. That's how I met him.
And was he present at Tyler Rich's house on the night of May 14th of 2022?
Yes.
How about Charlie Connery? Was Charlie Connery present at Tyler Rich's house on the night of May 14th
Yes.
of 2022? And how about Jacob Villalobos? Are you familiar with Jacob Villalobos?
Yeah.
And how are you familiar with Jacob?
He was my captain.
Captain for what?
Football.
And was he present at 43 Laurel Glen
Yes.
on May 14th of 2022? How about Matt Lakovich? Are you familiar with a Matt Lakovich?
Yes, I am.
And how are you familiar with him?
He was also my football captain.
And was he present at Tyler Rich's house on the night of May 14th of 2022?
Yes.
Now, when you got to Tyler Rich's house at around 11 p.m., what kind of, you said there were about 30 kids there?
Yeah.
What kind of things were going on when you got to Tyler Rich's house on May 14th of 2022?
Typical high school things, down in the basement, listening to music. A couple people had drinks.
Did you drink?
Not while I was at the Rich's, no.
I'm sorry?
Not while I was at the Rich's, no.
You didn't drink at all at Tyler Rich's house?
I could have had a beer.
Okay. Have you drank before?
Yeah, prior to Lazy Brook.
Okay. How about prior to May 14th of 2022? Have you ever had a beer before?
Yeah.
Okay. Have you ever been intoxicated before?
Yeah.
On May 14th of 2022, were you intoxicated?
No.
Now, how long would you say you were at Tyler Rich's house while the group chat was going on?
Probably about like 25 minutes.
Okay. And after about 25 minutes, well, withdrawn. During that 25 minutes, did you say anything in that group chat with regards to 43 Laurel Glen?
Yes. As we were all together going over this group chat, we're talking, they're talking. It was kind of just like I was collective with a couple people would tell them to pull up. So I did.
So you told them to pull up? And when you told them to pull up, how did they know where to get to?
I said the road name.
I'm sorry?
I said the road name.
Okay. And at some point in time, after that 25 minutes, did something happen that you became aware of outside of 43 Laurel Glen?
I'm not sure who, but someone had pointed out that there was a car outside. We kind of all collectively headed out through the back and went outside and saw the car.
Okay. I may have a moment, Your Honor. Can I see?
Yes.
The front of 43 Laurel Glen. Showing you what's been marked as State's Exhibit 49. You recognize 49?
Yes.
Okay. And this is a overhead shot of what?
The Rich's household.
Okay, and that would be this house here to the left of 49, kind of covered by some trees with the 3 pickup trucks in the driveway.
Yeah.
That's Tyler Rich's house?
Yeah.
Your Honor, may the record reflect that I'm pointing to the house with the black, blue, and white truck parked in the driveway.
All right, so noted, thank you.
Now, at some point in time, a car arrives.
Yeah.
What kind of car was it?
I believe a Honda Pilot.
Showing you States 30. Is that the Honda Pilot you saw pull up or in the area of 43 Laurel Glen on May 14th of 2022?
Yes.
Okay. And when this Honda Pilot pulled up, can you tell the ladies and gentlemen of the jury where you saw the car when you exited? Well, withdrawn. When you were aware, became aware that there was a car outside of Tyler Rich's house, what, if anything, did you do?
We all came outside. At first, it was like, where's the car? And then we had noticed closer to at like the bottom of the road, like where the road meets that road, a car was added to like the chain of cars that were there, and we had recognized that we didn't know what car that was. So we all kind of made our way over to it, realized that they were in the car.
Now I'm going to take you back now, okay? Back up. This is State's Exhibit 6, okay? Tyler Rich's house, right?
Yes.
Okay. When you were at Tyler Rich's house, were you inside the house or outside the house?
Both.
Both, okay. When you became aware that there was a car that arrived in the area of Tyler Rich's house, were you inside the house or outside the house?
Inside.
Okay, and where were you inside the house?
We were in the basement.
Okay. And at some point in time, when you heard there was a car that arrived at Tyler Rich's house, did you exit the basement?
Yes.
How did you exit the basement?
Through like the umbilical doors in the back.
Bilko doors?
Yeah.
So those are like the basement doors that
Yeah.
open like this? And what side of the house are the Bilko doors in? I'm showing you state 6. Can you show us where?
It's kind of blurry,
Can you
but
step down and point, Your Honor?
Certainly, that's fine. If he feels comfortable doing that.
May I approach you?
Certainly, of course.
You would go up there, right here. Do a point right here for the jury.
so right around here is the walkway entrance that brings you from around back.
Okay. So, Your Honor, the record can reflect that the witness pointed to this area just in front of the blue truck in State 6 in the back area where there appears to be an air conditioning unit. Is that right?
Yeah.
Okay. In this opening area here.
All right, that's noted. Thank you.
And when you came out of the Bilko doors, are you able to describe to the ladies and gentlemen of the jury in State's Exhibit 49 did you observe the car when you walked right out the Bilko doors? Not at first?
No, you came around the house.
So you came around the house. Did you come around the house? And for the jury and the record's benefit, did you come out this way where this patch of grass is just to the left of the blue truck?
Yeah. Sorry.
Did you walk down the driveway?
I believe so.
Okay. And when you walked to the driveway, did you walk to the end of the driveway?
Yeah.
Okay. And when you got to the end of the driveway, tell the ladies and gentlemen of the jury what you observed at that moment.
We had noticed that the car was about where those trees are, equivalent parked right about there.
So for the record's benefit, are you referring to these trees right here?
Yes.
So was the car parked in the middle of the road, side of the road?
It was pulled up onto the side.
On the side of the road. So right about here?
Yeah.
So, Your Honor, the record can reflect there's trees at the bottom of stage 49, the bottom right-hand group of trees just after the intersection of Laurel, Glen, and Adams.
All right, that's noted. Thank you.
So the car was parked there.
Yeah.
When the car was parked there, did you approach the car?
Yeah, we all did.
Okay. And when you say you all did, how many people do you think approached the car, if you know?
At least 20.
Okay. And do you recall who was present when you approached the car?
In the car?
In your group? No, in
our
your group.
Not specifically.
Okay. Was Tyler Rich present? If you recall.
I don't recall exactly who was outside.
So there was about 20 kids?
Yeah.
Okay. And when you approached the car, was the car facing,
It was facing
towards Adams or away from Adams?
away, down the road.
So if we're looking at approach your arms.
Okay.
This is stage 1. So when the car is parked, it's parked this way, facing towards Farmhouse Road?
Yes.
Okay. And you approached the car?
Yes.
And did you recognize anybody in the car?
Yes.
Who did you recognize in the car?
De Silva, Snyder, and Lito from Pryor at the Lifers.
So you noticed the defendant was in the car? Jack Snyder and Tyler De Silva? Did you notice if there was anybody else in the car?
I think so, but I'm not sure who.
At that moment, you weren't sure who else was in the car? Now, can you please describe to the ladies and gentlemen of the jury what happened when your Shelton friends went out to the car?
They start talking, start going back and forth. We're saying stuff to them, they're saying stuff to us.
Was it a civil discussion? Was it argumentative?
Argumentative.
Okay. Did you say anything?
No, I was in the front. I wasn't at any windows.
You were in the front?
Yeah.
What do you mean you were in the front?
Like where I was standing, I was kind of looking through the windshield.
So if you were
if the car is parked here on the right side in states 40, 49, you were somewhere up here in front of the car?
Yeah.
Now, if this is the car here, are you directly in front of the car? Or are you inside of the car?
I'm more towards the passenger side, yeah.
So you're closer to the curb than you are to the center of the road?
Yeah.
Okay. But still in front of the car?
Yeah.
And how long would you say the interaction went on between your friends and the St. Joe's group?
A few minutes.
Okay. Do you recall who was driving the Pilot that night?
Jack Snyder.
Okay. And do you recall, if you can, who was in the front passenger seat?
I don't recall. I just saw the powder blue in the front and back.
Okay. And you said about 5 minutes that interaction went on?
Yeah, a few.
And at some point in time, did something happen between your group of friends and the Snyder vehicle group of friends?
Yeah, they're talking back and forth, and then collectively people start like holding onto the roof racks and shaking it back and forth.
So your group started shaking the car? Okay. And what else? Excuse me. What else happened during that?
The car was on, so once that started happening, they put it in drive and drove forward, and I had to like hop out of the way a little bit, and they sped down the road.
So you had to hop out of the way when the car drove down the road?
Yeah.
How was it being operated, if you recall?
Speeding, I guess.
And when you say it went down the road, it took off towards Farmhouse?
Farmhouse, yes.
Okay. And when it took off down the road towards Farmhouse, what, if anything, did you observe at that point?
What happens after they drive away is they continue to drive back and forth from the Rich's house, like up and down the road.
So they're driving in State 49 up and back down Laurel Glen?
Yeah, I'm not exactly positive if they hit a U-turn or
If you see, it's like a square, so I don't really remember if they drove the square or
if they just busted a U-turn and came back and forth.
But they came back and forth.
They crossed the house multiple times.
Okay, and when they crossed the house multiple times, what, if anything, did you observe people from the car doing?
They were throwing things at us, we were throwing things at them.
What kind of things were they throwing at you?
I believe there was a WD-40 can, like a water jug of some sort.
Okay. And when those things were thrown at you guys, what, if anything, did you observe your group of friends do?
Throw it back.
You threw it back at them. Okay. Did you witness anybody throw anything and hit the car?
I don't recall if anyone hit the car.
Are you aware if the car was hit with anything?
I'm not sure, no.
Okay. And at some point in time, did they stop driving back and forth in front of Tyler Rich's house?
Yes.
Okay. And when they stopped doing that, what, if anything, did you observe as to where the car went?
they had moved towards where Farmhouse Lane is and stopped the car up like on the corner of it.
So for the jury's and the record's benefit, this is Stage 1. If we're looking at Stage 1, they're somewhere in the area of the intersection of Farmhouse and Laurel Glen?
Yes.
Okay. And would you say they were in front? Did you see them in front of this house, or was it more towards the intersection?
I was far away, so.
You couldn't tell exactly, but they were in this area?
Yeah, in that vicinity.
And Your Honor, may the record reflect the witness was saying they were in the area of the intersection of Farmhouse Road and 36 Road.
It's noted, thank you.
And when you were down the road, when you saw them, the car stop down the road, did you observe anything about the occupants of the car?
I think two of them had gotten out.
And could you see who got out of the car?
No, I could not see specifically.
Okay. And when you noticed those individuals get out of the car, what if anything did you observe next?
Two of my friends, maybe more, but Ricky and Tyler began walking down to go speak with them.
And when you say Ricky, you mean Ricky Fiola?
Yes.
And when you say Tyler, you mean Tyler Rich?
Yes.
Okay. And they went down the road? Did you see them go all the way down the road?
I saw them when they got pretty close, and then I had headed back inside.
Did you observe Tyler Rich or Ricky Fiola do anything when they were going down the road?
No.
Did you hear anything as to not what people said, but did you hear anything, any argument or anything down the road from where you were?
No.
Okay. And you say that at some point in time you went back into the house?
Yeah.
And when you went back into the house, how did you enter Tyler's house?
Same way I left, through the basement door.
So you walked. Before you get back into the house, can you show me on States 49 where you were standing when the car finally went down the road?
Yeah, I kind of like around the mailbox, like poked out in the road a little bit, just saw the boys walking down there.
So my finger's pointed in the road here, just in front of the mailbox on 49. Is that about where you were standing?
Yeah, in that general area.
Okay. And when you went back, your record can reflect my finger's pointing to the front of the mailbox, just about maybe 5 feet into the road.
Court will note it, thank you.
And when you went back into Tyler Rich's house, did you walk up the driveway and go inside the Bilko doors, or did you go in the house a different way?
I took the same route.
Okay. And when you were back in the house, when you were back in Tyler Rich's house, how long would you say you were in Tyler Rich's house for at that time?
A few minutes.
A few minutes. And when you were back in Tyler Rich's house, were you consuming any alcohol?
No.
And how many people would you say were inside the house when you went back inside the house at that moment?
Almost all of us.
Okay. And at some point in time, did you come back outside the house?
Yes.
And why did you go back outside the house?
Because they had came back.
When you say they had come back, who came back?
Well, when we got outside, Lito and De Silva were out of their car.
Okay. Now, show you States 52. Okay. Now, when you came out of the house, what route did you take?
The same route I had been taking. We veered a little left because they were approaching towards the yard.
I'll show you States 50. A little closer view. When you came out of Tyler Rich's house, you came out this side of the house where the Bilko doors were?
Yeah.
Okay, and I'm pointing to the area just in front of, there's an opening between some trees in the house just in front of the blue truck here, right?
Yep.
Okay, and when you came out of the house, what route did you take?
Kind of
Describe it.
Kind of like exactly where that blue truck is, and then went cut towards the grass.
So did you come down to the left side of the blue truck and go out to the right this way over to the cement block area, or did you go out of the side of the house and take a right in front of the blue truck past the black truck and come down the, we'll call it the driver's side of the black truck?
I mean, the blue truck wasn't there at the time, so we kind of just walked down like exactly where it is, and then like bended into the grass.
So, if I may have a moment, Your Honor.
Certainly.
I'm going to show you States 5. When you came out of the Bilko doors, right where this air conditioning unit is in front of the opening where this blue truck is, did you come down the left side of this blue truck and through the middle of between the blue truck and the white Jeep, or did you come down the passenger side of this blue truck towards this area?
The passenger side.
So you came out the Bilko door, took a quick left, and then down the grass area where the cobblestone block is?
Yes.
Okay. And where did you end up when you first went outside?
Like right in between that slab and red bush in that area.
Okay, so I'm showing you States. For the record, Your Honor, I'm sorry.
It's okay.
This is States 52.
Thank you.
This is obviously a more recent picture. Was this green tree here?
No.
Okay. And when you came down, can you point to the area in States 52 where you came where you stood?
In this general vicinity right here.
Okay, so in the record reflect just above the area of this square cement, looks like possibly a septic cap thing here, and the red bush.
All right, so noted, thank you.
And when you stood there, what was the lighting like at that point?
I think there might have been a light on from the driveway, like slightly illuminating. It was dim lit, moon was out. It wasn't terribly dark, you were able to see.
Did anybody have flashlights on?
Yeah.
Okay. How were they having? What were they using to illuminate what was going on?
Phone flashlights.
Okay. And when you got outside, tell the ladies and gentlemen of the jury what you observed initially when you got to that area.
So when we get outside, the cars pulls up facing
Towards Adams.
kind of like
Do you know where it's parked in that picture, 52?
It's like the car would be right here. This would be the car.
So can the record reflect that the car is parked in 52 to the right lower area would appear to be the middle of the road?
Carl noted, thank you. Cordell noted, thank you.
So when the car was parked there, tell me what you observed.
Lito and De Silva hop out of the car, start approaching the property. Obviously, there's arguments going back and forth.
How were they approaching the property? Can you recall how they were approaching the property?
They were just or like if I was like how I saw them.
Yeah.
From my view, the one on the right was De Silva. Lito was on the left, so on Tyler's right.
So if I'm standing in that area where you pointed out in 52 between the red bush and what looks like to be the septic cap, we'll call it that, you see Tyler De Silva to your right and Lito to your left, the defendant?
Yeah.
Okay. Was there anybody else with them?
The driver, but they were just alone out of the vehicle.
And when you observed Tyler and the defendant get out of the car, how many people from your group were outside?
Majority.
And do you recall if there was, not what people said, but do you recall if there was a verbal interaction between anybody from your group and the defendant and or Tyler De Silva?
Yeah, there was stuff being said back and forth.
What kind of things, not what they said, but what was the manner in which the things were being said?
Argumentative.
Okay. And was your group being argumentative?
Both parties.
So the defendant and Tyler De Silva were being argumentative back?
Yeah.
Did it look like they were trying to be peaceful?
No, but neither did we.
And so can you tell on States 52 where approximately you observed Tyler De Silva was as opposed to where the defendant was?
This would be probably about De Silva. Lito would be about right here.
And when there was an interaction between your group and the defendant and Mr. De Silva, where did that interaction, that verbal interaction, take place?
As they were walking up, a little bit on the grass as well.
A little bit on the grass just past the curb area?
Yeah.
Okay. And who was talking to, not what was said, who was talking to Tyler De Silva or arguing with Tyler De Silva at that moment? Do you recall?
A couple of people. Rich was arguing with him. He was also said some words towards both of them. Everyone was kind of talking.
So Tyler Rich was talking to Tyler De Silva?
Yeah, at one point, yeah.
Do you recall anybody else from your friend group talking to Tyler De Silva?
Not specifically.
Do you recall whether or not anybody was withdrawn? How far apart were Tyler De Silva and the defendant?
They weren't terribly far apart, maybe a couple feet, 5 to 8.
Okay. And do you recall who out of your group of friends was was anybody having a discussion or near the defendant at this moment?
Hines was near the area.
Brian Hines was near the defendant?
My buddy Ty Wood was confronting him.
How do you know Ty Wood?
Known him my whole life. My sister and his brother were friends. We played sports together.
And obviously he was at the party that night as well? Who else, if anybody, do you recall being near the defendant at that moment?
I'm not sure of anyone else.
But you're from what you recall Ty Wood and Ryan Hines?
Yes.
Okay. And how was the defendant's demeanor with regards to your friends Ryan Hines and Ty Wood?
They were both ready. I'm just like ready to fight.
Okay. And how long would you say there was this verbal altercation going on back and forth on May 14th of 2022?
Not very long.
When you say not very long,
Minute or two.
okay. And after a minute or two, did something happen?
Yes.
Okay. Can you please describe to the ladies and gentlemen of the jury what you observed happened?
Ty and Lito had been arguing. It looked like Lito was about to swing on Ty, so Rich stepped in front and struck Lito.
So Tyler Rich punched the defendant in the face?
Yes.
Okay. And when Tyler Rich punched the defendant in the face, what happened next?
Well, the fight begins, and his whole interactions, or Lito's whole interactions, kind of get out of my view from the crowd of people that are all just in front of me, so I can't really see him. But then I see De Silva, and he starts getting into it, and then him and Rich actually end up in like a wrestling match, basically, in the lawn.
And who do you recall being in the area of Tyler Rich and Tyler De Silva's fight?
Like Locke, Villalobos, Alex Bernstein was in the area.
When you say Locke, you mean Matt Locke?
Lockovich, yeah.
And Tyler Rich?
Yeah.
And Jacob Villalobos? Who else? Do you recall anybody else?
Not specifically, no.
And when you were observing the fight between Tyler De Silva and Tyler Rich, did you have an idea? Were you aware of what was going on with the defendant?
No.
Okay.
I knew he was in a fight. I could see it, but I couldn't see specifics.
Do you recall how many people he was in a fight with?
No.
Okay. And when the fight's going on, withdrawn, did you have any weapons on you that night?
No.
Did you see Tyler Rich with any weapons on him that night?
No.
Did you see Ty Wood with any weapons on him that night?
No.
Did you see Ryan Hines with any weapons on him that night?
No.
Did you see Jacob Villalobos with any weapons on him that night?
No.
Did you see Matt Lockovich with any weapons on him that night?
No.
Did you see Sal Perry with any weapons on him that night? How about Mike Sampieri? Did he have any weapons on him that night?
Not to my knowledge.
How about Charlie Connery? Did he have any weapons on him that night? How about Tommy Connery? Did he have any weapons on him that night?
No.
How about Faison Teal? Did you see any weapons on him?
No.
Did you see Jimmy during the fight?
Not during the fight.
Not
No.
during the fight. Do you know if he had any weapons on him?
He did not.
So when the fight's going on, you lose sight of what the defendant's doing and you kind of focus on Tyler Rich and Tyler De Silva. How long would you say you were, did you move at any point in time from where you were during that fight?
I might have creeped about where that tree is, maybe right on the cement.
Just watching.
So you were in that general
I
area?
stayed in that area mainly.
Do you recall anybody being near you at the time?
Tanner?
Tanner Chernowski was near you?
Yeah.
Okay. And how long would you say, withdrawn, tell us what you observed about the fight that you did observe.
It was quick. They were on the ground. I remember like they were wrestling, grabbing at each other. I saw like De Silva's whole back out because his shirt was like pulled up a little bit. They were just kind of wrestling, and then it wasn't very long, not a very long interaction. A couple of the dudes pick him up onto his feet, push him out into the street, and tell him to get lost, basically.
And when that occurs, at any point in time, did you observe the defendant do anything?
Yeah, so while the interaction with De Silva's ending, the defendant runs to the car. You see the car door open because the lights turn on from inside the car, and then he runs back into the fight.
And so, just so we're clear, States 52, during this point in time, you're somewhere in this area?
Yeah.
And that's between the square cement block septic cap here and this tree that was not there at the time?
Yeah.
And the car is somewhere in this area here, just in front of the mailbox, maybe like...
Maybe a little farther back as well.
Okay, maybe, so probably around just to the lower right-hand portion of 52. And you observe the defendant run to the car?
Yes.
And when you observe him run to the car, what does he do?
He runs back to the fight.
And when he runs back into the fight, where did you observe where Tyler De Silva was at this point?
He's kind of like in the
road now at this point because he was pushed out into the road.
Was anybody fighting with Tyler DeSilva at that moment?
No.
Okay. And when the defendant runs back into the fight, what, if anything, withdrawing, how would you describe the scene of the fight? Was it chaotic?
Yeah.
Okay. A lot of kids?
A lot of kids.
And when the defendant runs back into the fight, what, if anything, did you hear at that moment?
My buddy Charlie yells that he has a knife.
And when you heard Charlie yell that he has a knife, what, if anything, did you observe next?
I didn't observe. Like from that point, it was a crowd of people, and then it broke out in chaos. People started yelling, screaming, and then I had seen Jimmy, and he had these white shorts on. They were stained completely red, and I looked away, and a bunch of people flooded to him to help him.
States 57. Is that the outfit you recall Jimmy wearing the night of May 14th of 2022 with the white shorts?
Yes.
And when you saw Jimmy, withdrawing, when the defendant came back into the fight, did you observe a knife on him at that point?
I couldn't. I still had no eyes. I saw once he ran back from the car, I lost sight of him because of the crowd.
Okay. When you say there were a crowd, were there people in front of you where you were standing between the tree and the in that cement square in States 52?
Not many.
Majority was more into the grass, which is where he was, and I was like.
That's why I had the view I had of the car and the fight. And once he ran back towards the curb, he was not in my vision anymore.
Do you recall where Jimmy was at this moment? Did you see Jimmy?
I had known he was on the
far side of the interaction.
Okay. And when you heard Charlie yell, "He's got a knife! He's got a knife!" You didn't observe the defendant with anything. What did you observe next after you heard that?
It erupted and everyone started screaming. Some people were crying, yelling, freaking out. Once I had noticed Jimmy, I was shocked. I was 16 years old. I didn't know what to do. And then I had noticed Charlie was freaking out because his brother Tommy had been stabbed, and Charlie was like my best friend at the time. So I had taken my hoodie off, gave it to him, was like put it on his leg.
Let's stop there. So what did you observe first about Jimmy? You saw Jimmy first?
I noticed the red on his shorts. That was what I noticed.
Did you hear him say anything?
I did not.
Did he do anything? Did you see him do anything?
He fell to the ground.
Okay. So you saw red on the shorts and he fell to the ground? When you saw that happen, what did you do next?
I was moving towards him, and then like a couple people instantly grabbed onto him and were catering to him, and then I noticed Tommy and interacted with Charlie, gave him my hoodie.
Do you recall where Tommy was at that moment? If you don't, it's okay.
He was like in the middle of the yard.
Okay. And did you go up to Tommy?
I did.
And what did you observe about Tommy?
That he had been stabbed in the leg.
Okay. Do you recall if he had been stabbed more than once?
Yeah, I believe 3 or 4 times.
And when you saw that he was stabbed, what, if anything, did you do?
I had taken my hoodie off to give it. I gave it to Charlie first and told him to give it to Tommy to wrap his leg.
And when that happened, what did you do next?
I ran back inside to look for anything, towels, water. While I was like searching for things, I believe I was with Tanner. We had noticed Hines was sitting, and I was like, "What are you doing, dude?" And he said he was catching his breath, and he was hunched over with his hand on his left side, holding it, and then he moved his hand, and we had noticed that he was bleeding, and we took him out. We were, dude, like, come on, you got to get in the ambulance, you got to go, and then it kind of just all. Once everyone started getting treated, it was all just like a blur.
Where was Ryan stabbed?
He was stabbed once, like right beneath his armpit. And like the lower, I don't even know what this area is, your lower side, and then right above his butt.
Okay. And do you recall where Tommy was stabbed?
In his thigh.
Do you recall if anybody else had been stabbed that night?
Faison had been cut on the arm, and obviously Jimmy.
Now, when you went inside to help Ryan, at some point in time, did you come back outside with towels and
I didn't find anything, but I just kept using my clothing.
So, did you or anybody call 911?
Yeah, multiple people did.
How long would you say, withdrawn, after, when you saw Jimmy fall, did you see the defendant and Tyler De Silva do anything?
The last I saw of them was them run to their car and drive off, and then they weren't in my mind anymore.
And where did they drive? Did they drive towards Adams or towards Farmhouse?
Towards Adams.
Okay. And when 911 was called, how long would you say it was between the time the fight, the end of the fight took place and the time the first responders arrived? Do you recall?
I don't recall specifically. I remember it taking a decent amount of time because a lot of people were complaining that the ambulance wasn't there fast enough.
And
while we were there,
when you were waiting for the first responders to arrive to the scene, did you were you doing anything at that moment? Were you rendering aid to anybody?
Not at that point. Once they came, they made us all back up. They took over, obviously, took care of everything. And at that point, I finally answered my mom because throughout the whole interaction, she was blowing up my phone from hearing the sirens all driving by. And I finally, answered her, talked to her.
Okay. And at some point in time, did your parents arrive at 43 Laurel Glen?
I don't recall if they picked me up or not.
Okay. Did you, at some point in time, first responders arrived, police, paramedics? Do you recall whether or not you talked to any police officers that night?
I believe I did.
And after that night, do you recall whether or not you met with police officers again in connection to this case?
I did.
They may have a moment, Your Honor. Your Honor, that's all the questions I have for this witness at this time.
All right, thank you.
Good morning, Mr. Marcenzi. So you were telling us a little bit about your relationship to some of these folks, as well as what you witnessed on the 14th into the morning of the 15th, right? And you were telling us that the evening began, you were getting ready over to go over to Ms. Ridzik's house, correct? That was about 6 o'clock?
Maybe a little later.
Okay. And that involved some drinking as far as getting ready to go over there?
While we were there, yeah.
While you were at Ridzik's house?
Yeah, the initial time.
Okay. What about beforehand when you were getting ready to go over there? Did that involve any drinking?
No.
Okay. Any other substance use?
No.
You told us that once you got to Ridzik's house, you had a drink, maybe 2 beers, maybe 3, maybe 4?
No, because I didn't have that many. I wasn't able to get anything for that night, really, so I didn't have much. So I was just kind of...
Well, you were there with Ryan Hines, correct?
Yes.
And he had a 12-pack of beer,
He did.
correct? You didn't have any of those beers?
No, I don't believe he gave me any.
Okay. Is it possible?
I don't think so.
Possible?
Sustained.
Because when we showed up to the lifers, he had...
Hold on just a minute.
Sorry.
It's okay. I'm going to sustain the objection to the question, asking if it's possible, it's speculative. I'm going to strike the response that was provided to that question before the court had an opportunity to stop the witness from answering the question. So please retract or take any information responding to that question out of your notes if you have anything in there and you're not to consider it as part of the evidence. Attorney Smith, you may proceed.
Thank you, Your Honor.
Thank you.
So your recollection is that it was 2 beers that you had at Ridzik's house?
Mm-hmm.
Nothing else to drink there?
No.
Ryan didn't share any of his beers with you?
No.
And at some point, you went over to the Lifer's house, correct?
Yes.
And that was 5 Lazy Brook Road?
Yes.
And you knew that they were having a party there, correct?
Yes.
Where you expected that there would be more drinking going on, correct?
Potentially.
Well, when you arrived there, you knew that your friend, Mr. Leifer, was drunk to the point of being ill, correct?
I had found that out from them when I had arrived.
Because you didn't see him because he was in the back throwing up, correct?
I didn't see him because I wasn't allowed into the property by the defendant and his friends.
And you were driven to 5 Lazy Brook Road by a person named Tanner Chernowski, correct?
Yes.
And you described Tanner Chernowski as your cousin, correct?
Yeah. Not by blood, but essentially we've been family friends since we were young.
So he's not your blood cousin or relative, but you consider him so close as to be, you call him a cousin.
Yes.
Now, when you got there, you mentioned that there were some kids from St. Joe's at that party, correct?
Yeah, it was a St. Joe's party.
It was
Often
a St.
attended
Joe's
St.
party.
Joe's, yes.
So most of the kids there were from St. Joe's, correct?
Yes.
You were not from St. Joe's,
No, I was not.
nor was Ryan Hines, correct?
No.
Nor was Tanner Chernowski.
No.
And there were 4 kids there, but you from St. Joe's that you noticed, but only 3 of them who you could identify, correct?
Yeah.
And that was Jack Snyder, correct? Tyler De Silva, correct? And Raul Valle, correct? And you knew them to be St. Joe's kids, right?
Yes.
And you said that Mr. Hines had brought a 12-pack of beer with him,
Yes.
and that you began to go into the garage, correct?
Yes.
Could you see what was going on in the garage?
Yeah, the garage doors were open.
And there was a party going on in the garage, right?
They were inside, so they were really the only ones in the garage, maybe a couple other stragglers outside. But the party was in the house.
Nothing going on that you could see inside, like beer pong or any games?
No,
being
door
played?
was shut. And the way it's set up, you can't see into the house.
And you didn't know at that time who Jack Snyder, Tyler De Silva, or Raul Valle were, is that correct?
Not fully. I had known Snyder and De Silva just like through football, not like personally knew them, but I've heard the name before.
Okay. So at that point, when you saw them, you couldn't say what their names were, is that
No.
fair to say?
Correct.
And at some point, you said that Jack Snyder went to grab Ryan Hines' beer, correct?
He did grab Ryan Hines' beer.
He grabs Ryan Hines' beer, and then you said the defendant didn't say anything, correct?
Not to my recollection. I don't recall what everyone was saying.
And that he was peripheral to Mr. Hines and Mr. Snyder, correct?
Yes.
And at some point, Mr. Hines and Mr. Snyder squared off, right?
Yeah.
As though they were going to have a fist fight or some sort of physical
Yeah, they
altercation.
had agreed to fight over the beer.
Okay. When you say they agreed to fight over the beer, were there any adults present at this point, or was this just students?
Witnessing this, no. I think maybe a parent or two. Both of them were home, but I know his mom was home.
And you claim that the first punch was thrown by the defendant,
Yes.
and that he punched Ryan Hines in the face from behind,
Yes.
correct? And you said that Hines then took Snyder to the ground.
Yes.
Now, you've described and you saw a photograph of Mr. Valle wearing a helmet, correct?
Mm-hmm.
And he was also wearing some sort of a neck pillow. Did you see that?
Outside, I'm not too exactly sure if he had it on still or not. It was a black pillow or a dark colored pillow. It was nighttime. I don't recall exactly if he was wearing the neck pillow.
And that was Austin Leifer, your friend. That was his father's motorcycle helmet,
I
correct?
believe so. Yeah.
And at some point after they began fighting, you said that Mr. Hines was getting the better of Mr. Snyder, correct?
I'd say he was. Yeah, he was brought him to the ground. He was on top of him.
And at that point, you said that the defendant tackled Ryan Hines, correct?
No, he removed his helmet and struck him.
Okay. Well, that's what you told us now. You gave a statement to the police officers on May 15th of 2022, correct?
Yeah.
You went there with your parents at about 2 o'clock down to the PD to give a statement?
Sounds about right.
And you told them at that time that the defendant tackled Ryan and punched him, correct?
They might have taken that incorrectly because Hines is the only person that tackled anyone. He thought, or he took him to the ground. I watched him tackle him, and no one else went to the ground either.
So you didn't tell them that that the defendant tackled Ryan and punched him?
If they marked me as saying that, then on paper I did, but I recall Hines tackling it.
And you told us here, and you told them then, that the defendant took off his helmet and swung it at Mr. Hines, correct?
Yeah, he struck him with it.
He took that helmet physically off of his head and swung it and struck Mr. Hines.
Yes, he hit Hines with it.
And then Mr. De Silva jumped in afterwards, correct?
Yeah, he didn't contribute much to it, but yeah.
He began punching and kicking Ryan Hines on the ground, correct?
Yeah.
That's your recollection. That's what you're certain of today.
Yeah, he wasn't very much so involved. He was the last one to enter in, and by then it got broken up pretty fast.
And you were prevented from helping because this fourth unknown person was holding you back, right?
I wasn't, so to say, be held back because we were initially watching because they agreed to fight one-on-one, and that was agreed upon both. They were fine with it. The second they get active, like, things happen, and then the girl hops in. I'm off to the side. I had no clue who I was standing with, and we were talking about it, and he was like, don't get involved. He was telling me not to because he was like, dude, like you're in that. Like, there's 3 of them.
There were adults at this house, you think?
What do you, like, parents?
Yes.
His mom was home, yeah.
You were aware of that?
I wasn't until she came outside when the fight got broken up.
But so you claim that these two agreed to fight, Mr. Snyder and Mr. Hines, and
Yeah.
you decided you were just going to watch the thing.
But they said they were running one-on-one fight. Hines, it's not allowed to be said, but they said they agreed upon ones.
You didn't make any efforts to notify any parents inside the house that this was going on out in their driveway?
I didn't know they were in the driveway. Or in the house, sorry.
You said the fight lasted a short time, maybe as much as 30 to 40 seconds?
As much as 40. Nothing like...
And afterwards, Mr. Leifer's mother came outside and asked you to leave, correct?
Yeah, which we were more than fine with doing.
And she gave the beers back to Mr. Hines, correct?
I didn't exactly see if she picked them up or if she handed them to him. She could have.
And at that point, you got a ride back to Ms. Ridsick's house, Natalia Ridsick's house, correct?
Yes.
Who gave you that ride?
I do not know her name. We had been walking down the driveway. We had met a group of girls, and they had witnessed what happened, and we were like, you guys mind bringing us home? And they had no problem with it.
But you don't recall who that was?
I do not recall their names.
And you told us that you weren't doing any drinking on the way back to Ms. Ridsick's house, correct?
No, I didn't have anything. Once I had gotten to Austin's, I had no alcohol.
You didn't have any of Mr. Hines's beers that he had just gotten back?
No, he lost majority of them in that yard, so he was not in the mood to be giving them out.
And you immediately called your friends, Thomas and Charlie Connery, right?
No, I believe Charlie called me.
And you told them about what had occurred there at the 5 Lazybrook house, right?
Yeah.
And everybody on your side, and this is the Shelton High kids at this point that we're talking about, right?
Yeah.
Those are your friends, are mainly Shelton High kids?
Yeah.
And you let them know about the fight that had just happened at 5 Lazybrook Road?
Yep.
You were upset, right?
Yeah. Me and Hines were a little pissed off. We were like, what the hell, that was bull.
A little pissed off?
Yeah. We weren't, fuming, acting out of rage, doing anything stupid, but we were like, that was stupid. Like, we were just pissed.
Okay. And you told us that there was a basketball group chat that some of the kids started, correct?
Yeah, I was in it prior. It was started because we played pickup basketball, hence the name of the group chat. And we had 2 SJ kids in there that we were friends with. We'd hoop with them. And then after it all had happened, I don't remember who specifically, but they were all added, or at least 4 people. I didn't have any of the numbers, so they were all just random numbers.
When you say they were all added, you mean Mr. Valle, Mr. De Silva, and Mr.
I found that out
were
after,
added,
but
correct?
in the given moment, I didn't know, yes.
But that's who was added, right?
Yes.
And that's who you started texting about 43 Laurel Glen Drive, correct?
Yes.
Giving them the address, correct?
Yeah.
In fact, taking a photo of the address and texting that, correct?
Yeah.
That wasn't just some of the kids, right? That was you.
Yeah, my phone number is the number that sent it, yes.
You've talked about things as having happened collectively, but when we're talking about the address being sent, that
I
was
sent
you
the
individually, not collectively.
I mean, if you put it into retrospect, yeah, my finger hit the button, I think, but I was a sophomore at a senior's house. I wasn't just going to have some kids show up that this is my first time hanging out there. I wouldn't just invite them. So I was told by people, I don't exactly remember who, but we had been talking about it, talking about what just happened. Because they started off with come to Trumbull High. So we were like, we're not going to Trumbull High. And said what we said.
So you're saying somebody forced you to text?
No, nobody
the
forced
address.
me to text anything, no.
And then you described ultimately getting over to 43 Laurel Glen Drive. And you told us maybe 30 to 40 kids were there?
Yeah.
Could it have been more?
I don't think so. By more, if it's not touching 50, maybe a number in the 40s possibly, but I don't think so.
And you didn't have anything to drink once you got there, except maybe I think you conceded you could have had one beer?
Yeah, I could have been given one. I don't remember drinking, but I'm not going to rule it out.
Was there beer at the party at 43 Laurel Glen Drive?
Not for the taking, but people had their own supplies.
Was there liquor at the party at 43 Laurel Glen Drive?
I didn't see. He could have had a bottle at his house prior. I'm not sure.
And when you arrived there, you described it as being dark, correct?
Where?
43 Laurel Glen Drive now.
You're referring about outside?
Yes.
It's dim lit. It wasn't terribly dark. We were able to see the people in front of us. Flashlights are out too. There's the light in the driveway. It's not you can't see.
It was misty that night?
I don't recall it being misty.
You don't recall it being misty or rainy?
No.
You don't recall the grass being wet?
I do not.
You don't recall any sort of precipitation whatsoever?
I don't recall, but I don't recall mist specifically.
And you said you were in the house in the basement, correct?
Yeah.
And that it was a typical high school party, typical high school things were going on, right?
Yeah.
What were those typical high school things that were going on at that party?
Listening to music, people having a couple drinks together. Might have had a pong table, I'm not sure, but just people hanging out, listening to music, having a good time, hanging out.
You said might have had a pong table. What's a pong table?
Like a table to play beer pong.
And what's beer pong?
So when each team has 10 cups and you shoot a ping pong ball into each other's cups, and whoever makes all 10 first wins.
How old was the oldest person that was attending this party?
Could have been 18 or 19.
No adults present?
Not to my knowledge, no.
So you told us before that maybe some folks had some beers, they'd brought their own. Now you're telling us that there might have been a beer pong table set up and people might have been playing beer
Yeah,
pong?
by beer pong, I don't specifically mean every single cup is filled with beer, because we've come to learn that it's a lot easier to fill them with water, because then you could just keep playing and play the game.
Okay, so are you telling us that this night there were people playing pong with water?
I'm not telling you specifically, I don't recall, but if 95% of the time that is the situation, because you get your beer all gross.
And you told us that at some point you became aware that these St. Joe's kids had arrived and they were outside, correct? Yeah. How did you become aware of that?
So initially there was a text that said we were here. Someone ran outside, didn't see them. And then someone else was like, there's a car outside, and that's when we all flowed outside.
And you described that car as being parked outside down towards the corner of Adams, correct?
Yeah.
And that car was on the other side of the street, correct?
Yes.
And then you told us that you all collectively headed outside, right?
Yeah.
Was that all 30 or 40 of you?
A few stragglers may have fallen back, but the majority made their way outside.
And who were you standing beside when you headed outside?
I don't recall fully who I walked out with. We kind of just all funneled out, so we just walked outside.
Did you head outside with Tanner Chernowski?
Yeah.
Did you head outside with Ryan Hines?
Yeah, he came out.
Did you head outside with Michael Sampieri?
If Samp went outside, I wasn't specifically saying I'm with any of them. Some of them were outside, yes.
Why did you go outside?
Because I went outside. They were in the group chat. They said they're here. Curiosity. Walk outside. Everyone else was going.
You were just curious about what was going to happen after you told them to come
Yeah,
to
I'm gonna
43
go.
Laurel Glen Drive
I'm gonna
after
go
the fight?
confront them. Yeah, I'm gonna go outside. But this was more of like me and Hines were like youngins to everyone there. We looked like we were the little kids there, so they were kind of taking control. And it was more like people. They were all known. The defendants and his friends have known some of the people that were at the Rich's house.
Okay. And then when everybody gets outside, you've told us about them going up to the Honda Pilot, correct?
Mm-hmm.
And you said that at this point they all surrounded the Honda Pilot, right?
Yeah.
And they were touching the Honda Pilot, right?
I'm looking from the front. I don't know if they eventually did when they began rocking it. Yes.
Began rocking the car?
Yeah.
You were shown a picture of the Honda Pilot, correct?
Yes, we were.
That's right there. You were shown this picture. Is that the Honda Pilot that you recall seeing?
Yes, it is.
You gotta rotate it. That looks like the Honda Pilot that you saw.
Yeah.
The outside the windshield. It's very close. Just a moment, Mr. Marslinzik. I'm trying to get an exhibit. I'm going to show you exhibit number 31, close-up of that Honda Pilot. You agree that's the same vehicle?
Yeah.
Okay. And when that vehicle arrived and you first saw it, it didn't have that shattered windshield, did it?
I'm not sure.
You're not sure.
I didn't see anyone specifically make that happen, so I don't know if they arrived with it or left with it.
Okay. How did you come out when you got to the car when you went outside?
Where was I parallel to the car?
How did you come out of the house?
Through the umbilical doors out of the basement around the house.
What kind of doors?
Like the umbilical ones, like the basement doors.
Okay. And can you describe the umbilical doors for us?
It's like the ones that open. Like, I don't know, if this is a house, they're slanted like this and they open. And there's a staircase that goes into the basement.
Okay. And then you came out and you described for us how you walked down the pathway?
Yes.
And where did you go? If you want to use the exhibit behind you, you went beside the square cement?
That's the second time when they come back. The first time initially, we all come down the driveway.
Oh, you all came down the driveway?
Yeah, we all walked out. I don't know specifically the driveway, but we all walked out to the car.
So you remember that? You remember how you got out of the house?
Yes.
You don't remember whether or not that windshield was shattered beforehand?
I wasn't paying attention to if their car was beat up or not.
You were standing right at the front by the passenger side, right?
Yeah, I wasn't on the car. I was a few feet back. I was looking through the windshield, but I don't remember if there was a crack there or not.
Which side of the windshield would you say that defect is in?
The passenger side.
The side you were standing closest to?
Yeah.
You didn't notice whether or not it was shattered?
I wasn't looking for shattered glass, and you probably can't really tell it's cracked either when it's nighttime. You know, it's got a light on it with a flashlight taking a picture of it, so it reflects back a little bit. I didn't recognize if there was a crack or not.
I see. You did notice, however, that these kids were all now surrounding the car and that at some point they started to shake the car.
Yes.
They started to throw things at the car.
I don't know if anyone threw anything at that point.
They started to pound on the car.
Yeah, probably just banging on the windows.
Somebody reached in and punched somebody that was inside the car.
I didn't see any of that.
You didn't see that?
I didn't see if anyone got punched while in the car.
You were standing on the passenger side. How far away from the car itself?
Probably 4 to 6 feet back.
Could you have reached out and touched the car?
No.
Did you reach out and touch the car?
Did I touch the car? Not to my recollection, no.
Not to your recollection?
Yeah, I don't recall encountering and going up and touching the car.
Is that the kind of thing you'd forget?
What do you mean? Like, would I forget touching the car?
Yes.
Probably not.
But you simply don't recall whether or not you touched the car?
I didn't touch the car.
You didn't?
I didn't touch the car.
Now you recall that you didn't touch the car.
Yeah.
These other people were all touching the car.
Yeah, they were on the sides of it. I was in the front, so I can't do anything from the front of the car.
I see. You distanced yourself from the car.
Essentially, yeah.
You distanced yourself from the group.
Not from the group. I was still with people.
Same people that had you feel like you had to text the address.
I'm going to object as to argumentative.
I'll allow it overruled.
Sorry, but what was that?
These same people that you felt like were making you text the address.
I didn't feel like I was made to text anybody the address, but sure.
So you went outside. Folks, there was, you described there as being a chain of cars that were there, correct?
Yeah, there was a couple cars parked on the opposite side of the road as well.
There were cars parked on both sides of the road, right?
Yes, but significantly more on the other side.
Significantly more cars were parked on the other side
There
of the
might have
road.
been 1 or 2 car parked near the mailbox, but there was on the other side.
It was lined up with at least like 4 to 6 of them.
Okay. So the chain of cars were there. Were you standing between the pilot and another car?
They weren't too close to the other car because they were able to put it in drive and drive forward while turning left. So they were slacked back a little bit, but essentially, yeah, I was technically between 2 cars.
Okay.
But it wasn't a close gap.
And you described that water bottles and a WD-40 can were thrown out of the vehicle?
Yes.
Or were they thrown at the vehicle?
No, the WD-40 can came out, which someone picked it up on the road and threw it back.
Okay. Was anything else thrown back at the vehicle?
There was like a water jug tossed. But once they started driving up and down, slowly, majority of us would fade into the inside. But a couple people trickled, stayed outside. And that was really it. They just kept driving up and down. We thought it had been done by that point.
Okay. How many times did they drive up and down?
3, 4 times.
Not 2 to 3?
Well, including their first speed down, and they come down and back up again, so it's at least 3.
Could you see how many people were inside the vehicle?
I know there was more. I didn't see specifically how many. There could have just been 4 of them. I don't think it was full.
Now, when you were part of the group that collectively surrounded this car, you wanted them to exit the vehicle, right?
At that point in time, we didn't really have a game plan or an approach. We just went and were going to talk with them, which obviously was a little bit hostile, but we didn't know what was going to happen or what would happen.
You didn't want to get payback for the Lazy Brook Road?
Sure, it was in thoughts, but at that point in time, they're all sitting in a car. You can't do anything, so...
Can't do anything except lay hands on it, start rocking it, throw things at it, smash the windshield.
Yeah, sure. We rocked it and threw things at it because things were thrown. Like I had said before, I don't recall anyone doing anything to the windshield. I'm not saying it wasn't us or it was, but I didn't see any of that.
You collectively attacked the vehicle. Fair to say?
Objection is the characterization.
I'll overrule it. You can answer it.
I wouldn't say attacked. We had a mass of people. I wouldn't say necessarily attacked.
No, you wouldn't. And you also can't tell us who laid hands on the vehicle, can you?
No, there's a lot of people.
Yes, you told us who was there. Enrico Fiola was present.
Yeah.
Sal Perry was present.
Mm-hmm.
Mike Samperi was present.
Mm-hmm.
Alex Burnson was present.
Mm-hmm.
Tanner was present.
Mm-hmm.
Yes?
Yes.
Jacob Villalobos was present. And you knew all these guys very well, correct?
Yeah.
You played sports with all of them, correct?
Mm-hmm.
You grew up with all these kids, correct?
I did.
But you can't tell us who it was that started shaking the vehicle.
It's not that I couldn't tell you who, it's that I didn't specifically look around and remember who was who. I know who all my friends are, obviously, yes, but I don't know where their positions are. I don't know their experiences. I was paying attention to myself and looking at the car. I wasn't watching everyone else's doings.
Isn't it that you don't want to tell us? You don't want to tell us what your friends did that night?
Honestly, I wish I could, but I don't know.
Well, you can. Go ahead, tell us.
Well, I don't know.
You don't know.
I don't know where my friends' position were or where they were, no.
But you knew how you came out of that house.
Yeah, because I
I'm
walked
object
it.
this asked and answered at this point.
I'll sustain the objection.
And you're telling us that they drove up and down the road 3 to 4 times, you've said?
Yeah.
Multiple times. And that at some point they drove off down towards Farmhouse Lane, correct?
Mm-hmm.
And would you agree that that is about 2 football fields away from where the Rich House is?
Yeah, it's a good distance.
And you claim that you saw only 2 of your friends walk down towards Farmhouse Lane, right?
I just knew 2 specifically. There could have been more. I know that Ricky and Tyler went and encountered him.
Do you know that because they told you that, or because you saw that?
They were the ones that actually had discussed that they were going to go down and talk to them. So once they started going, I came back, and I don't know if anyone else trailed after them.
Did you see them go down to Farmhouse Lane?
Yeah, I saw them. I walked inside, but I watched them head towards Lido, yes.
Those, you think only those 2 people were the ones that walked down there?
No, I just know that those 2 people. I don't know specifically who else.
And you told us you didn't hear anything go on down there?
No,
at
I went
Farmhouse
back
Lane?
inside.
You went back inside. You remember that?
Yes.
Who else went back inside with you?
Majority of people.
Alex Burnson?
I'm not sure. At that time, I just kind of met Burns. I wasn't really looking out for him.
Did Enrico Fiola go back inside with you?
No.
Did Sal Perry go back inside with you?
I'm not sure.
Did Mike Samperi go back inside with you?
I'm not sure.
Did Tanner Chernowski go back inside with you?
I'm not sure.
Did Jacob Villalobos go back inside with you?
I'm not sure. There's a lot of us. You're naming 6 of the 40 kids. I don't know where everyone's exact whereabouts were at every given moment. I apologize.
No apology necessary. When you spoke with officers before, though, you didn't mention anything to them about friends going down to Farmhouse Lane, did you?
Well, I was in a panic and just explained what I had actually, the big things. It didn't
So
come
you
down
didn't
to
tell
details.
them about that, correct?
I don't remember exactly what I told them. That was 3 years ago.
You told them that everybody went back inside and only one person remained outside to see if the St. Joe's kids were going to come back, right?
No, I didn't specifically say that. I just know that somebody, I don't know how many people, but majority had funneled in and someone had mentioned that they were back.
And that one kid just stayed outside to see if the St. Joe's kids were going to come back, right?
Yeah, someone actually was outside. I don't remember who it was, and they were looking, but it wasn't like
Well, did one kid stay outside, or did 2 kids go down to Farmhouse Lane?
those are 2 separate events. They went down and spoke to them. Then when they were down at I don't know anything that happened in that conversation, what they saw, what they said, anything about it, but I watched them walk down the road towards them. And then at separate times, we all funneled back inside. Someone was outside still. I don't know if they were looking for them, but someone was still outside, and then they had mentioned that they had came back.
Who was that?
It was someone just yelled like they're back, and everyone was like, "What?" and all funneled out the back doors. Like,
And in fact, you continued texting throughout this time period, didn't you?
I think the texting died down a lot once they had fully arrived. There was a couple texts sent. Yeah.
There were a couple of texts sent, or you sent texts, Mr. Marcinsic?
Well, multiple people sent texts. I included, yes.
You sent texts,
Yeah,
correct?
I sent texts. They sent texts. Multiple people sent texts.
In fact, you snapped a photograph of Mr. Snyder's car sitting outside and texted that with a caption on it, taunting them, didn't you?
Yeah.
This was after they had shown up and driven away, correct?
No, that's as they just showed up. I took that picture first thing.
Oh, so you took that picture before you went outside?
No, I took that picture outside when they had arrived.
And you said, "Sitting ducks, ODE, very scared," right?
Yes.
And then you asked, "How's your car, pussy? Fold, that's crazy, right?"
Mm-hmm.
And that was after you'd gotten out?
It's after they had driven up and down, I believe.
That's after they'd driven up and down the
driven
street?
up.
You're continuing to text them at that point, right?
I believe so.
Are you still feeling pressure to do that from other people?
I never felt any pressure in the first place to be texting them.
Oh, okay. You didn't feel pressure before when you sent the LGD, 43 LGD address?
No, there wasn't pressure to do that. It was dudes being dudes talking.
Just dudes talking?
I mean, yeah, we were expecting to fight, not any of this.
You were expecting to fight?
Once we had told them to come, yeah, I don't think we're gonna have them come and there'd be no point in having them come. Yeah.
Did you say 43 Laurel Glen Drive, 30 to 40 dudes here?
I don't exactly recall, but if I did, then yeah.
Okay. You didn't mention those texts, however, when you were talking with the police, right?
I don't recall. I don't think so. I don't know that it wasn't asked. Once I was asked about them, I told them about them, yeah.
Oh, once you were asked about them, you told them that they existed, but before that, you didn't think that was important to share with them?
Not really. It was argumentative. It's a lot of just hearsay nonsense back and forth between the two of us. Yes, well, I told them where to go, but that doesn't invite anything that happened on that night.
Mr. Marcinzik, you didn't tell the cops about that because you thought it might get you in trouble, didn't you?
I don't know exactly what my thoughts were when I was 16. I could have been scared. I'm not sure.
You didn't think maybe you'd get in trouble for luring somebody over and then getting into a fight?
I mean, you said it yourself. I said the address with how many people. I wouldn't necessarily call that luring. They knew what they were getting themselves into.
Sir, what I said was you texted them the address, but you didn't say 30 to 40 dudes here, did you?
That's what you said.
That's not what I said, sir.
Well,
Is that
I
what
had a misconception.
you said?
I need to be looking at the same text you're looking at. I don't remember text I sent 3 years ago.
Okay. Let's see. At some point, you described there was a second encounter when the car came back, correct?
Yeah.
And you were inside when the car returned?
Yeah, when I had gotten outside, the car was already parked in the street.
Yeah. I'm talking about the second encounter when the car comes back, as you've described, and the fight occurs out on the lawn. Okay?
Yes, the fight. Yes, when everyone gets outside, the car's already parked, and the two of them are making their way towards the yard.
How did you know that the car was already outside?
There was a bunch of us there. They had said that the car had returned.
Did you see the car outside?
Did I see it return?
Yes.
Like, did I watch it come to a complete stop and return? No, I did not.
Where were you when the car returned?
I was inside.
You were inside the house?
Yes.
Okay. And so you came to learn that the car had returned because somebody...
It was just, we were all together. It was known, yes.
Did you just see people start to funnel outside, or did you hear somebody say, hey, the car's here?
Both.
Both of those things occurred?
Yeah, the car's here, we funneled outside.
And you didn't think, guys, we should stay inside right now. There's really no need to go outside the house if the car's back.
No, obviously not. I should have. It's a more mature way to look at it, yeah. But I was 16 and immature and walked outside to go watch a fight.
Go watch a fight?
Yeah, because at that point, no one was really involved. The people arguing were the people arguing now.
So, at some point, you get back outside into the yard. You see Tyler De Silva out there?
Yes.
You see Raul Valle out there?
Yes.
And you see Jack Snyder out there?
Jack Snyder was driving.
Jack Snyder was driving is what you told us here today, but when you spoke with the cops, you said all three of them got out of the vehicle. Did you not?
I don't recall if I said that back then. Like, I might have misconstrued it a little bit. All three of them were there, but Jack remained in the vehicle.
And you did tell the officers that all three of the parties were out of the vehicle with the doors open, correct?
I mean, at one point, all doors were open on the vehicle.
You said everyone exited the house and approached the three parties on the lawn, correct?
Yeah.
Three parties?
Yeah.
Snyder, De Silva, and Valle, correct?
Yeah, I said that in the moment. I don't know why I said that, honestly, but probably didn't assume two dudes would hop out and fight everyone. I thought maybe he was out of the car. I didn't see him somewhere, but then I noticed him in the car once they got in and instantly drove off.
And in fact, when you got out, you saw Tyler Rich and Tyler De Silva talking, correct?
Yeah, there were words.
Were they fighting at that point?
No.
And to your knowledge, did Mr. De Silva and Mr. Rich know each other?
I can't speak. I want to say they did, but I'm not sure.
And you said that they began exchanging words, correct?
Yeah.
And at this point, how many people from the party, the Shelton kids, were out there in the lawn?
Majority of us.
30 to 40?
Probably 30. Not all kids were outside, and I know kids that stayed inside.
Okay. Who were you standing beside?
What was that? Sorry.
Who were you standing beside?
I was kind of near the vicinity of Tanner. I wasn't really like up with everyone, or with anybody specifically. I was just kind of observing.
What was Tanner doing?
At the time, Tanner was observing, and then he pulled out his phone and eventually recorded.
Tanner was filming this?
Eventually, once the fight broke out, yeah, he took a video.
Was he the only person filming?
I'm not sure, but at least to my knowledge, yes.
You were standing over by where Mr. De Silva was on the ground being attacked, correct?
Yeah, well, him and Rich were wrestling on the ground, yes.
It wasn't just Mr. De Silva and Mr. Rich that were going at it by themselves, was it?
Honestly, they were them two were the main ones. They were on the ground with each other. It's not like no one else was with Tyler on the ground, or Tyler Rich I'm referring to. No one else was helping him on the ground. But it was mainly just them two kind of going back and forth on the ground.
Just the two of them. Everybody was standing back to the side, letting them go at it.
I'm not going to speak up for people, or specifics, or I'm sure he caught a shot or two from somebody else, but it was mainly I remember seeing him on the ground. Rich had his shirt pulled up. De Silva's whole back was out. I remember seeing it. Rich was on the ground. De Silva was on top of him, but Rich kind of had him in a chokehold kind of thing, but not really. Just holding him down so he couldn't get on top of him.
And you had such a good view of that because somebody was using their phone to live stream that, and the flashlight was on, wasn't it?
There was flashlights on, yeah.
And somebody was live streaming that whole thing, weren't they?
Live streaming?
Yes, sir.
I don't think anybody was live streaming this.
You don't think anybody was live streaming this?
I have no knowledge of anyone live streaming this event.
You think somebody just pulled out their phone and turned on the flashlight and was holding it up to show the fight going on?
Are you confusing a video for a live stream? Because a live stream is lively streamed, and a video is not live streamed. Do you understand what I'm saying?
I appreciate the distinction, sir. I'm not confused.
So you are asking about a live stream? No, I don't. To my knowledge, no one recorded a live stream. No.
Not to your knowledge.
Yeah, I don't know anything. I've never heard once of a live stream.
But you would agree that somebody had their phone out, it was open, and at least it had the flashlight on, correct?
Yeah.
And that was shining on Mr. De Silva and the fight that was going on there, correct?
Yes.
You saw that?
Yes.
You were close to that?
Yeah.
You said the scene was chaotic, correct?
Yeah.
You've told us today that there were only 2 people that were in the yard that were fighting from the St. Joe's kids, correct?
Yes.
You told the officers there were 3, that it included Mr. Snyder, correct?
There were 3 involved. I could have said it like that. He wasn't literally involved in the fight, but he was their driver.
And you said Mr. Rich and Mr. De Silva began exchanging words, and they soon became involved in a physical altercation, correct?
Yes, they eventually were involved in an altercation, yes.
Again, how did they become involved in a physical altercation?
Well, once it looked like to us that Lito was going to swing on our friend Ty, Rich had just thrown a punch onto him and then stopped worrying about him, and him and De Silva started fighting.
I see. You said we thought that Lito was going to
that was
throw a punch.
Everyone kind of saw it, at least what.
Sir, you don't know what everyone saw, do you?
No, I don't. You're right. I'm sorry. I don't know. We all saw it, but I saw him make a little move towards Ty, and Rich punched him. And then he turned towards the sofa because whoever was over there was just dealing with that.
You saw Mr. Valle
Yeah, that's what started the fight. And then
make
once
a movement of some sort?
Yeah, like they were squared
Describe
up to
that
each
movement.
other. Just like he was like, it was, he didn't make a big enough movement, but he twitched like in the wrong way that looked like it could have been aggressive, and obviously Rich is going to defend his boy.
So the first punch was thrown by a Shelton High kid. That's correct, isn't it?
Yeah.
And that punch hit Mr. Valle, didn't it?
Yes.
And thereafter, it did become chaotic, didn't it?
Yeah.
In fact, everybody swarmed, the 30 or 40 of you, the 2 people that were there in that yard, correct?
No, there was a lot of people also watching. It wasn't like, obviously we're not gonna, like, you saw pictures of them afterwards. They didn't get stomped on by multiple tens of people. Like, there was a couple kids, yeah, on each of them, but like once the fight broke out, I didn't see Lito anymore because the crowd, and it went down. The crowd blocked it all, and I was just looking at De Silva fighting Rich.
The crowd blocked it off because they were swarming. There were at least 8 to 10 people attacking both of them, correct?
I can't say. I didn't see 8 to 10 people on De Silva, but I can't speak for Lito.
Did you see Mr. Villalobos involved in the fight?
Towards the end, he actually put De Silva to his feet and shoved him towards the road with the help of a few of his other buddies.
Did you see that, or did you watch a video?
No, that happened because when I was watching De Silva fight, he got lifted up and pushed out.
You saw that yourself?
Yeah, I was watching. Like I said, I was able to see the De Silva interaction.
Okay. Did you see Charles Connery involved in the fight?
I did not see him involved. No.
Did you see Ryan Hines involved in the fight?
He was. I know he was on the left side, but he was in Lito's area. They were all crowded together, so I didn't see him specifically do anything.
Didn't see Sal Perry involved in the fight?
I'm not sure.
You didn't see Michael Sampieri involved in the fight?
I did not see Michael at the time, no.
Didn't see Alex Bernson involved in the fight?
I saw Alex Bernstein.
Oh, what did you see Alex Bernson do?
He would when he threw a couple punches at De Silva, but nothing crazy. Like he threw some extra ones, but while Rich was wrestling him, he gave him a few.
Was he wearing a shirt?
I think he had it off.
It's hard to tell because there were a couple of folks that took off their shirts for this, right?
I'm not sure. Burns a big dude, so he stood out, and I'm pretty sure he had his shirt off.
Did you see Mr. McGrath involved in the fight?
I did not. He was on the other side.
Did you see Tyler Rich involved in the fight?
Yes.
Did you see Faison Teal involved in the fight?
I did not. He was on the other side as well.
Did you see Michael Lokovich involved in the fight?
I don't recall if he was involved, but he was in my general area of De Silva.
Did you see Tommy Connery involved in the fight?
He was also on the farther side, so I'm not sure if he was in there or not.
In fact, it was hard to see what was going on the other side because that side had encircled and descended upon Mr. Valle, correct?
Objection, he said he didn't see.
Sustained.
Did you say that you didn't see or that it was hard to see?
I didn't see. Once the people came in front of me, I said it, I didn't see at first and followed it up by saying it was hard to see, but I meant for both. I couldn't see. People were swarming, yes. I didn't see it, but I didn't specifically see anyone go to the ground on him, multiple people. So I can't speak on that.
People swarmed him, correct?
Objection, just testified he couldn't see.
Sir, overruled. You can answer that if you know.
Obviously people, yes, huddled around, but I didn't, I saw more people standing than doing anything.
Did you remain in that same position throughout the course of this fight? Where you've described by the red bush and the cement square? Yeah. You did not yourself throw any punches?
No.
And you described Tanner Chernowski, your cousin, as you've described him, the closeness, filming this, correct?
Yes.
He took his phone out and didn't call 911, but started filming what was going on.
Yeah.
And he was walking back and forth filming this, correct?
No, I believe he's stationary, maybe moves a couple feet left and right, but not really moving around. The video, you can really only see De Silva. Like I said, his side's over there.
But you described yourself seeing Mr. Valle go to the car.
Yeah, because the car was...
Like I said, it's more in that where the area it is. They're fighting back more up.
So when he runs out of his area, he's now kind of behind. Like from my view, he runs behind where De Silva is, and you see the car door open. I watch him open the car door, and then the light turns on. We all kind of, a couple of us put our attention over there, which Tanner also noticed, and then he runs back.
And you saw that?
Yeah, once he runs back, I lost him again because he ran out of my view.
And you described Mr. Chanowski taking a video of this, correct?
Yes.
You've watched that video, have you not?
Yeah, I've been shown it.
When was the first time you saw that video?
I'm not sure, honestly. I think the first time I saw it was when I was shown it.
Who showed it to you?
By the detectives, because Tanner didn't send that video anywhere, and he told everyone he deleted it the night of, but he kept it and gave it to the cops.
He didn't show it to you?
No, I had not. That night I wasn't worried about watching a video.
Cops showed that to you. That's your testimony?
I believe so. I don't have any prior knowledge of the video.
And you told us that you didn't see anyone get stabbed with a knife, correct?
And I didn't directly watch a knife enter somebody, no.
In fact, you didn't see a knife at any point. Is that
No.
fair to say?
Yes.
You were watching both of these fights going on, but your attention was divided, fair to say?
Yeah, and once it became divided, it mainly focused just onto De Silva's fight.
And you'd had at least 2 or 3 beers?
Yeah, in the span of those 4 hours.
Okay. And you were 16 at the time?
Yes, I was.
And you told the officers that Snyder, De Silva, and Valle hopped back into the Pilot and drove off towards Adams.
Yeah, well, they were all into the car and they drove off.
And you told us you'd been friends with Mr. McGrath, correct?
Yeah.
And that you'd known him since you were very young, correct?
Correct.
And would you describe him as a cousin the same way you described Mr. Chernowski?
Nah, because once we went to high school, obviously he went to prep, we grew apart a little bit, but it was still always love when we saw each other.
And you would describe him as somebody who was the toughest kid you know, right?
Yeah, on the field he was an animal.
And that he wouldn't back down from anyone, right?
No.
And that if he saw his friends getting into a fight, he would join that fight, right?
Objection. Calls for speculation.
Doesn't, if not, if that's what he said, I'll overrule. The question continues to be, you've said. Is that correct, Attorney Smith?
I beg your pardon, Your Honor, I'm sorry.
Does the question continue to be that you've said these things?
That he would describe him as that.
Describe him as?
Yes, Your
Okay.
Honor.
I'll allow it overruled.
I'm sorry, repeat.
That you would describe him as somebody who, if he saw his friends being in a fight, he would go out and join it, correct?
Depending on the situation. If he saw his boys winning, probably not.
If he saw his boys winning, probably not?
Yeah, he wouldn't just jump into a fight to fight.
But if he saw someone punching his boys, he'd probably hop in.
Objection is to probably.
Sustained.
Mr. Marcinzik, at some point you also engaged in doing an identification of folks that were there with the officers, correct?
Yes.
And you identified Mr. Valle as having been there.
I'm sorry, what was the end of that?
You identified Mr. Valle as having been there.
Yes.
You also identified another person as having been involved, correct?
Tyler De Silva?
Anybody else?
Not sure.
When you were telling State's Attorney Durso about watching this fight go on in the yard, you described De Silva as being in a wrestling match, right?
Yeah, like they were on the ground, like together, Rich and De Silva, so I would call that grappling with each other.
Just Rich and De Silva involved in a wrestling match by themselves.
Well, they were the main two on the ground. Like, yeah, you obviously caught a couple strays. There's plenty of people, but I don't know from who.
What do you mean by caught a couple strays?
Like, they're on the ground, someone's gonna just throw a sneaky punch or throw a sneaky kick, like, just exactly like what they did to Hines at Lazy Brook.
Well, and you described Mr. Lakovich as being in the area, correct?
Yeah.
Villalobos was in the area, correct?
Yeah.
Burnson was in the area, correct? Correct?
Yes.
Yes. Sorry, you have to.
Sorry.
For the record. But they weren't just in the area, were they?
I mean, I know Byrne was throwing some punches, yes, but I don't recall exactly if Locke and Villa were fully in there like that.
Would you agree that you are very clear on the facts about how you came in and out of the house and where you stood?
Yeah.
Would you agree that you are less clear about who threw punches and who was involved?
I would, yes, with the fight aspect.
Would you agree that all of the Shelton High kids were friends of yours?
I mean, yeah, they've all known each other.
You don't want to see any of them get in trouble, do you?
No, but they necessarily couldn't really get in any trouble at this point in time, so I wouldn't be doing them a favor.
Okay. You continued to text even after the fight had ended, correct?
I believe I had sent some texts once because my phone was being nonstop lit up with calls, and I pulled out my phone to look at them, and I had noticed a text from them first, so I responded. I think I remember what they were as well.
Oh, what were they?
The final text was that I received a text that said, "Let me know how surgery goes," and I responded out of childness. I was like, "Bro, look at your face. You'll probably never get a girl." Not really knowing the severity, just throwing something, but that's why I responded, because I read that text.
You responded to Mr. Snyder, correct?
Yes.
Mr. Snyder said something about surgery, correct?
Yes.
And you responded something about look at your face?
Yeah. I didn't know whose number that was, so I just gave it was a random number to me, so assumed it was maybe one of the people fighting, since he's sitting, like, I don't know. I didn't know who it was at the time.
Just a moment, Your Honor.
Sure.
You told us when the swarm occurred on Mr. Valle, you couldn't see Mr. Valle anymore at that point, correct?
I couldn't really point anyone out in specific.
And you didn't see him again until you saw him
ran
at
into
the
the
car,
road.
correct? And then when he came back onto the lawn again, you lost sight of him again at that point, correct?
I had lost sight of him, and the only thing that I had heard was Charlie Connery scream twice that he had a knife.
You lost sight of him because that group swarmed him again, correct?
No, he came back into it. He had all willed to leave and brought himself back into it.
That's your opinion, sir?
I don't know. I watched him wailing. Like, no one pulled him back in from that car. He ran to their car and came straight back in.
And you couldn't see him because all of your Shelton High friends were blocking your view, correct?
Yeah, I wasn't the tallest 3 years ago, so.
I feel your pain. You could be unable to see them because they were taller and they were also forming a circle, were they not?
Honestly, a circle probably would have made it easier for me to see him if they fully surrounded him, because majority of the people, it was like a wall, so I couldn't see him.
Could you see Mr. McGrath at that point?
No, I wasn't. I didn't. Maybe I saw him. I didn't notice it was Jimmy at the time. No.
Could you see Michael Sampieri?
Sorry, what was that, Michael?
Could you see Michael Sampieri?
I don't know exactly where Michael was. No,
Could you see Michael Lakovich?
he was around me. Yeah,
Could you see Jacob Villalobos?
yeah. He pushed Tyler into the road. I think Locke might have helped with that too.
Could you see them at the time that you could no longer see Mr. Valle?
Like once they split, was I able to see Locke and Lobos? Yeah, I wasn't focused on them. Like I never really took screenshots in my mind of all the people that were around and everything. I know who was there, but I don't know the specifics of who was where, when, where, and how.
This was a chaotic scene, right?
Yeah.
And you heard a lot of people screaming, right?
Yes.
In fact, before you heard Charlie Connery screaming about a knife, you heard other people screaming other things, right?
Not necessarily, because Charlie yelling he has a knife was significantly louder, and like everyone heard Charlie yell that.
You didn't hear anything being said when Tyler DeSilva was being attacked?
No. At least I don't recall. Like it was scuffling and shit talk. I don't remember exactly everything that was said.
All right. Thank you. Nothing further.
All right. I'm assuming there's going to be some redirect.
Yes.
Is that correct? All right. This is a good time to take our morning recess. Thank you. You may be seated.
Well, then there's that. Okay, that's bango. So that's bango. Let me see. Let me try and find. So next up is going to be, I'm not going to worry about redirect because I can tell you what redirect was. Hold on. That was day 2. Was there any redirect? All right, there was some redirect, but all right, we're going to jump to Isabella Molnar. She's next up. Hold on a sec. Let's see, if you haven't voted yet, take a moment to vote. What would your verdict be for count 4? So that's Face-On. That's Face-On's. Let's listen to Face-On while we wait. Well, they're going to be ending soon. It's 4:30. They're going to be ending very soon. So I don't want to get into another. Do I want to get into another testimony? Maybe we'll just ride it out. Let's just ride it out for. I have a feeling they're not going to be. I don't think they're going to be. I don't think they're going to be deliberating too much longer. Let's just ride it out. Joe with us. Joe Schmo. Where are you? There you are. Joe Schmo. I never took screenshots in my mind. Is such a next-gen thing to say. Right? Good to see you, Joe. Hope you had a good weekend. All right, we're just going to wait. Am I muted? No. Screenshots. All right. We're just going to wait it out because Thursday Judge Murphy ended at 4:30 in the middle of her jury instructions. Sometimes they'll go to like 4:45. I don't think they go to 5, so we're just going to ride it out. Psychosaurus Rex, we need just 60 some more boops to get to the 50 like. Yeah, we're at 434, you guys. Got 1,100 of you watching, so if you can take a moment to hit the like button, that would be great. And then answer our poll. What would your verdict be for count 4, assault intentional to Face-On Teal? Jules, please press the like bottom, also known as the like button. Bob, that is the question. Why did we not see those texts? There was the group texts. We never saw them. He shows them to Raul. He says, will it refresh your memory? Will it refresh your memory? And how can you show a witness, Ken? Please help me understand this. How can you show a witness something and then it's not entered into evidence? Is that even like plausible? Is that allowable? I don't understand that. Donna G, boys being boys, it applies to young teenagers, many football and lacrosse players, drinking and being cocky and not knowing when to just leave. Oh, I hear you. Testosterone, 16, 17, 18-year-olds, they're drinking, testosterone's kicking in, they're football players, lacrosse players, they're used to being hit. They're used to hitting and they're used to being hit. So they don't shy away from pain, if you will, you know. Just Shamrock, wow, this channel has grown. Proud moments. Yes, we're at 10,260 subscribers. So thank you. Ken, that's typically how it's done through recollection refreshed. But doesn't it have to be in evidence? Or doesn't it have to be, so you can just show a witness anything and it doesn't have to be put into evidence? The memory is the testimony, not the thing being used to refresh the memory. All right, Ken. I've never seen that, though, where they show a document or they show something and then it's not brought into evidence. Sinbad, Squeegee, if it isn't in evidence, how is the jury going to actually see it in deliberations? Right. That's my question. All right, Ken, that said, what is used to refresh the witness's recollection often is entered in at some point. Right? I've never seen that before. I've never actually seen, will this refresh your recollection, and then it's never brought into evidence. Verdict clock, here, let me go to, let's see. I've since 11, and they took an hour off, so say from 12, I'd say 4 hours, 4.5 hours. And if you keep the 11 o'clock in, 5.5 hours. So they're at 5.5 hours. If you count, see, that's the thing. Do we count lunch? Some people count lunch, some people don't. Donna G, this is the first time I've watched on this channel and I love it. Thank you. Thank you so much for that, Donna. Appreciate it. Humans for Humanity, only 10 years? No. That's just for face on. That's just for face on humans, I should say. We did Jimmy, we did Ryan, and we did Tommy. Now we're doing face on. He faces 60 years to life, I think, right? Is it 60? I'm sorry, 25 to 60 years. For Jimmy's stabbing and deletion, he faces 25 to 60 years. This one, the poll right now is just for face on, and he's the one, he didn't have life-threatening injuries, so that's why he's at count 2. I'm sorry, that's why his count is assault second degree. So that's what that is, just for clarification. Defense could have introduced chat. Old Pueblo Hope says. LOL Bird says, the hot mic during a sidebar when Raul was on the stand, they were arguing about trespassing charges on Lazy Brook, whether Raul had or didn't have trespassing charges. Prosecution alleged there was. Austin says, I think this trial is weird, but when I get out of it, it's not self-defense. You can't bring a knife to a fist fight. You just can't. Yeah, that's what a lot of people are saying. Bob says, also, how did the first kid get stabbed in the side and lung if Raul was supposedly on the ground getting stomped? Wouldn't he have had this to stab him immediately, not when on the ground? No, yes and no. Tommy, who got stabbed, Ryan got stabbed in the, yeah. So Ryan said Raul was on the ground, and you're right. Raul said he was on his face down and he's just doing this. So you're right. That's inconsistent because Tommy said he came over. Well, it's who do you believe? Tommy said he came over and tried to separate Raul and Ryan, and that's when he got stabbed in the leg. So Raul was on one knee, stabbed Ryan, then Tommy came over, separated them. Then he got stabbed. So maybe that's when, yeah, there's inconsistencies, Bob. Definitely inconsistencies. Ken says that's not actually not typical how it's done. That's actually the rule. You can use a document to refresh the witness's memory, but that by itself doesn't mean it comes into evidence. All right. I just feel like I always see it somehow, at some point it's entered into evidence. I guess it's kind of, especially because this is such a huge point of contention. Like, who said what? Remember they were saying, Raul was like, well, it has your name, or it's It has your name, but whose number is attached to that? Merciful to You says the basketball chat was a key factor. Yeah, it certainly was. Kerrville, depends if it was deliberating lunch, but I doubt this one was since they were stuck before lunch. Grandma Jenny, thank you for covering. Thank you for stopping by. Take a moment to hit the like button and also answer our poll if you guys have not already. Todd says, I can tell you something about why Raul's girlfriend didn't want to go to the riches with Raul. We kind of heard, but yeah. Aussie Gardner, show Chris and Aaron some love for free. Hit that chubby wubby thumb. Thank you, Aussie. Right, here, let me get caught up. Let me get myself caught up here. Be Kind says it's very complicated with so many involved. I agree. Merciful to You, Faison said he thought the pilot was pulling up with McDonald's. That is true. Larry the Creator, I honestly think he will be found guilty of second degree. I don't think he wanted to delete anyone, but asked for the knife to scare them, and it turned into he could have left many times. Yep. Would anyone here take a 40-year plea bargain? I know, that's tough. Billy says football players football players don't like basketball players, I know. Love this because I can't find anywhere verdict clock. Other than my scroll at the bottom, they've been deliberating since 11. So you have to do your own math. You have to do your own math here. Kim says, I have seen so many people say they just found your channel and love it. Me too. How did you hide for so long? You could have been famous for it. No. Well, thank you, Kim. I don't know. YouTube is like showing us right now. I'm not. It all has to do with the algorithms. For some reason, we're being shown, I guess. I don't know. I appreciate that you guys are finding us, though. Thank you so much. Really, really do appreciate everybody being in here. Our mods are doing a fantastic job. We're all about, supporting each other. We're not here to break each other down, tear each other down. If you want to do that, there's plenty of other chats that do that. We're here for civil, discourse and talking, and you guys have your opinions, but just be respectful. Be respectful of each other and the channel. Janet True says, I love this channel. Thank you. Appreciate that. Nanar says, too many of the boys involved and their testimony was cocky and protective of self. I understand why protective, but I don't. I understand why protective, but I don't. Their cockiness 3 years later is annoying. Yep. Well, Todd, I know you feel that way. Defense was showing somebody who was wearing dark top, white shorts, kicking. Now, that's just the defense. I'm not saying anything other than the defense did show that in the video. So we thought that maybe that was Tommy, but I think, also Jimmy was wearing the same outfit. I personally don't think Jimmy was involved, but then he showed somebody kicking, and who was that kicking? That was somebody wearing the same clothing as Jimmy. I don't think Jimmy did. I think he was a complete innocent bystander. Abel, how are you? Kitty. Good to see you. Haven't seen you in a while. Jess says, I believe the chat may not have been shown because it contained sensitive information about minors at the time of the event. So you're saying the group chat was, I don't think it was entered into evidence. There were things they didn't show, like the autopsies, but at least they said it was entered into evidence. LW, did the jurors leave? I don't know. That's why I'm hanging here. I hope the judge comes back and says we're releasing you. I hope the judge comes back. Gourmet Thursday, I like your channel too. I love that you listen to the proceedings and not interrupt during. Plus, you seem very kind. Oh, well, thank you. Thank you for that, Gourmet. And I like your handle just because I like to cook. So thank you for that. Appreciate that. Thank you. Appreciate that. Kim, if the jury ends up hung, who thinks they will retry? That's a good question. Be Kind, just found your channel today. Oh, awesome. Awesome. Thank you, Be Kind. Love it. I love all the new people coming in. You guys are fantastic. And everybody coming in is really cool and respectful and respective, I should say. That's all. That's all we want. Just be cool, man. Just be cool. Just be cool. Abel, did the WD-40 do any damage? I don't think so. Although he got sprayed by Tyler Rich, and then there was somebody else that came in. Somebody else came in and said, "Hey, sorry that happened to you." So I thought that was cool. I forget who that was. Who was that? It wasn't Aiden. Was it Aiden? Oh.
Just about 4:45. Nearing the end of the day, so I'm going to go ahead and release the jurors for the evening. So I'll ask the jury to be brought in. Thank you. Counsel, please stipulate to which one of our juries.
State will stipulate, Your Honor. Defense stipulates, Your Honor.
Thank you. Ladies and gentlemen, jury, it is a little bit after 5:45. At this point in time, I am going to send you home for the evening. I'm going to bring you back tomorrow morning for continued deliberations. All of the rules of juror conduct are in place. They're all important. However, before you go home for the evening, I want to remind you of a few things. You must continue to avoid all communications to and from anyone regarding this case, except communications with your fellow jurors only when all 12 of you are present here in our jury deliberations room. Avoid any media and social media platforms while you are not here, and obviously while you are here, where you may find information about this case. Do not visit any locations mentioned, look up any statutes mentioned, or conduct any experiment or research, either individually or as a group. We are going to reconvene tomorrow morning. I will bring you in first thing in the morning and provide you with additional instruction, and then we'll go on from there, okay? So we'll see you back tomorrow for continued deliberations. Please take your role as jurors, which I know that you are doing. Please take that role responsibly. Again, there is a lot of media coverage relative to this particular case. Have a good evening. We'll see you back tomorrow. Thank you. Court stands adjourned.
All right. So there you go. There you have it. They are done for the day. Put us back here. If you guys listen, you can hear Super Ball snoring. Here, hold on. I'll put the big screen up. There's Super Ball. Do you hear her snoring? She's snoring right now. All right, let me bring us back here. All right. LW350, we're getting off topic, but couscous is, I think it's made from semolina. It's a small little pearl couscous. It's kind of like, I don't think it's like a pasta. You'd have to Google it. Anyway, it's a really nice salad to make. All right, let me focus on the trial. I don't want to get off topic. All right, let me end our poll for today. So we took a couple polls. All right, so 744 votes. Let me go through our polls for today. All right, so 744. All right, so for Faison, who was count 4, 40% of you thought guilty, 34% of you thought assault second degree reckless, and 25% thought not guilty for time served. So, how's it going, Funk? Good to see you. Hope you're doing well today. Thank you for being in the chat. you heard Super Bowl? Yeah, she's. Hey, William, she's snoring. It's a grain, feels like tiny rice in your mouth. Yeah, you know what? I looked it up. What is? I thought it was a grain too, but then it's a type of pasta made from semolina flour and water, often resembling tiny granules or small balls. So it's North African. It's made from durum wheat, the staple in North African cuisine. So. Sinbad, so how long does Kitty Cam run for? Every time I refresh, I have to stream again. Kitty Cam yesterday, we ran it for about 3 or 4 hours. I think we ran it for a couple. Yes, little spheres of pasta. Let's see. Chat is very split for this trial. Let me see, just in general, we've taken, so here are the polls we took today. How long do you think the jury will deliberate for today? 2 to 4 hours, 29%, 4 to 6, 28%, 6 to 8, 26%, and 0 to 2, 15%. I personally went with 4 to 6 hours, so 28%. So I was wrong. So that's just for today. I learned my lesson with Carlos Dominguez because I said, how long are they going to deliberate for? And I didn't realize, well, they deliberated for 9 days. So I'm just going to say for this day. I'm not going to say how long are they going to deliberate just in general. I'm going to say, how long are they going to deliberate just for this day? So for those that picked 6 to 8 hours, well, let's see, wait, they did 11 to 4, that's 5. So they did between 4 and 6 hours, 28%. So congratulations those that picked 4 to 6 hours. I guess I'll change that tomorrow, knowing that they will not. Well, no, they should come in at 10. And if they leave at 4, if they leave at 5, potentially they could go for 7 hours. All right, so what would your verdict be for count 1? And that was for Jimmy. Manslaughter, intentional, 43% of you thought that. Not guilty, self-defense, 31% of you thought not guilty. Murder 1, intent to cause the deletion, 24% of you went with that. So manslaughter basically, so seems like, yeah, you guys didn't think it was intentional, although manslaughter was intentional. And then for count 2, what would your verdict be for count 2? Now that was Ryan. So second degree reckless, which was 1 to 10 years, 43% of you thought that. Guilty up to 20 years, which is straight up guilty. 40% of you thought that. And then not guilty, 16% of you thought that. So far on Jimmy's, 31% thought not guilty, 16% for Ryan not guilty. Then for Tommy, 813 votes. Second degree reckless, 1 to 10 years, 42%. Guilty, 38%. That's up to 20 years. Not guilty, 19%. So 24% of you thought for Jimmy, not guilty. 16% for Ryan, 19% for not guilty. For guilty, for Jimmy, 31%. Ryan, 40%. Tommy, 38%. All right, then finally, 744 votes for Faison Teal. What would your verdict be? This would be second degree assault, guilty 40%, second degree reckless 34%, not guilty 25%. So there's still a fair amount of us that think that there's not guilty, but then there's also a fair amount that think he is guilty. So, meaning you would believe in the self-defense. All right, Steph, when is the verdict, please? We are waiting, still waiting. Tomorrow. Tomorrow's going to be the best I can say is tomorrow. All right, Bice, have a good evening. Thank you for joining us. Yeah, Super Bowl is our kitty. We have, okay, so Paulie, here's the story for those that are new to the channel. Super Bowl, who is right here, she's my paralegal, she's my sidekick. She found us, feral cat, when we lived in a different location. She's 6 years old. Then we moved to a new location 3 years ago, and we were no cats at all for 2 years. Then last year, in July, Rafa and Paulie, boink, they popped up and they adopted us. Then Polly got pregnant. She gave birth June 5th. And, well, here, let me see. Let me see here. Let me see if I can pull up kitty cam. All right, I have to reconnect. All right, so that's kitty cam, and they don't seem to be around right now. All right, they're somewhere. So Polly had 4 kittens on June 5th, so they just turned 4 weeks old. So they're all resting. So we've been showing them on the weekends. That's Polly meowing, and then Rafa's our ginger. Rafa's our ginger. So they're just chilling. So yep, there's kitty cam. Nothing's happening. Well, hold on. Let me go see if I can. Let me go check in on them. All right, so those are Polly and her kittens. So 3 of them look exactly like, well, 2 of them look exactly like her. One of them's kind of looking like her. And then, of course, you've got a little ginger boy. So, yeah, so they just turned 4 weeks. So, land of the giants, right? So there you guys have it. All right. Mike says, just joined. Do you think the defendant helped or hurt himself testifying? Good question, Mike. Some of us think that it hurt him because there were some inconsistencies. You could say lying, you could say inconsistencies, whatever. But yeah. It won't be long and they'll be escaping. Yeah, trust me, we've got it all kind of barricaded. Over the weekend, we opened it up. If you guys were watching a couple weeks ago, we had where Polly is right now. We had that blocked off, and that goes into the bathroom. That's actually where she gave birth, was in the bathroom. And so we opened that up for them. So now they have that extra little space. Yeah, I would say another, they're already escaping. So we keep having to make the boxes bigger and bigger and taller. So, but yeah, if you guys want to go check out kitty cams, we aired them. We ran one Saturday and Sunday for like a couple hours both. So if you want, you could go check it out. So anyway. All right. I am going to call today. Thank you guys for watching. We're gonna call today here. I haven't seen them in a week. I think they're doing great. You've made a great space for them. Thank you, Nan. Appreciate that. Thank you so much. All right, guys, we are going to call it a night. Thank you again for watching us. Thank you to Aaron for putting all the graphics together and helping on the back end. Thank you to our fantastic mods. Psychosaurus Rex is our newest moderator, so be sure that you you give our mods some love on the way out. And we have some really great things lined up for you guys coming up. Thank you, chat. Thank you to all the new people that have joined. Thank you for keeping it respectful and courteous. We want to lift each other up. We want to lift this community up. We don't want to tear each other down. We appreciate your opinions, but just make sure that you guys don't attack each other, because there's other chats for that. Our chat, that's not what we're about. And I do appreciate you guys respecting that and respecting each other. So, all that being said, have a wonderful evening, you guys. As always, I will leave you with Super Ball as she sits in the sun, and she's got her little murder. Super Ball's blowing out the camera. So again, thank you guys for joining us. We'll see you tomorrow. We'll continue watching some testimony, and we'll see you then. All right. Thank you, mods. Thank you, Aaron. Thank you, chat. Thank you, Psychosaurus Rex, our newest mod. Thank you, Brat and Widespread. Appreciate you guys. And Ken as well. I'm just trying to remember everybody that was in. I think we're, and Brat. Yep, I said that. Brat, Widespread, Ken, and Psychosaurus. Thank you guys. Really appreciate you all. And we'll see you tomorrow. Starts at 10, so we'll come on at like 9:45 Eastern, and we'll start playing some more testimony, and we'll just hang out. So until then, have a great evening, and we'll see you tomorrow. Bye.